Good morning. I am Zachary Parker, Chair of the Committee on Youth Affairs. Today is Thursday, November 13th, 2025. We are meeting in room 123 of the John A. Wilson Building and virtually via Zoom. The time is now 9:04 a.m., and I am calling to order this joint hearing of the Committee on Youth Affairs and the Committee on the Judiciary and Public Safety, chaired by my Ward 2 colleague, Councilmember Brooke Pinto. During today's hearing, the committees will hear testimony on 6 bills and a policy package I introduced earlier this year called the Care for Youth Plan. Those 6 bills jointly refer to both the Committee on Youth Affairs and the Committee on the Judiciary and Public Safety are B26-0399, the Support Opportunity Unity Legal Relationships Sole Amendment Act of 2025, B26 0400, the Statutory Neglect Amendment Act of 2025, B26 0401, the Youth Records Transparency and Oversight Amendment Act of 2025, B 26-0404, the Safe Pregnancy, Delivery, and Postpartum Care for Youth at DYRS Amendment Act of 2025, B 26-0407, the Strengthening Capacity and Transparency at DYRS Amendment Act of 2025, and B26-0408, the Promoting Parental Engagement at DYRS Amendment Act of 2025. These bills aim to uplift some of our most vulnerable members of our community, centering a family-driven, holistic approach to issues facing youth in our city. Much of the legislation before our body today was developed from conversations directly with youth about what they need most, and we hope to deliver on our promise to optimize the child welfare and juvenile justice systems that serve them. For the SOUL Act, as of June 2025, there were 542 children in foster care. By recent estimates, about 30% of these children were aged 16 to 20 years old. This indicates that there is a need to provide for and support these older foster children on the cusp of adulthood. The SOUL Act will deliver this support by creating a new permanency pathway within CFSA. Created in partnership with Foster Youth, the SOUL Act offers CFSA-involved children the opportunity to establish a network of supportive adults known as a SOUL family without legally severing other kinship ties. Emblematic of a national movement, this dynamic legislation is designed by kids and for kids. Unlike other legal options such as reunification and guardianship, which are often structured for younger children, the SOUL model is designed specifically for older youth. With a SOUL support family, older youth will be empowered to grow with a community of their choice as they transition into adulthood. The committee would like to give special thanks to the Children's Law Center, the Family and Youth Initiative, LEX or LEX leaders, and the Office of the Attorney General for all of their help on this special legislation. Next, we have the statutory neglect legislation. The Statutory Amendment Act of 2025 attempts to standardize and clarify the current neglect code. Rather than reform the entire code, this legislation aims to make technical adjustments relevant to issues under the Committee on Youth Affairs' purview. For example, this legislation amends the code mainly in an effort to reduce racial and economic bias and neglect findings. In line with this goal, this bill will guarantee that family poverty cannot, I will repeat, poverty cannot be used as the sole basis for finding of a parental neglect by the Child and Family Services Agency. Again, the committee made this decision to make small technical changes rather than adopt a radical shift in our legislation. I've heard from several advocates that this legislation does not go far enough in amending the code. While I believe there are legitimate asks around more thorough code improvements, we are focused today on changes that are squarely within the Committee on Youth Affairs' purview. And I would be happy to work with other committees and my colleagues on changes that fall more under their purview. For instance, Councilmember Pinto. The bill also works to reduce legal ambiguity by separating the definition of abused and abandoned and distinguishing physical discipline from physical injury to limit misinterpretation. The bill mirrors changes made by other jurisdictions such as Alaska, Massachusetts, Vermont, and Illinois, who have shifted away from a focus on a parent's ability in favor of their unwillingness. Overall, the bill seeks to align code with best national child welfare practices that focus on reducing family removals. Finally, during deliberations on this bill, the committee considered several suggestions from advocates, including exempting cannabis use as an indicator of neglect, especially when a parent is with child. While the committee weighed those suggestions carefully and took multiple meetings with advocates about them, the committee ultimately decided not to make these changes in light of inconclusive empirical evidence and the need for further discussion on these issues. Today's hearing is an opportunity to continue the important conversations on this topic. Next, the Youth Records Transparency and Oversight Amendment Act of 2025 originates from the Committee on Youth Affairs' mandate to fulfill the entirety of its oversight responsibilities. At present, the agencies that the Committee on Youth Affairs has oversight of, DYRS and CFSA mainly, maintain access to juvenile records, but the committee itself does not. This presents multiple issues for the committee when faced with problems that fall under its purview, including those related to public safety. This bill would grant the committee access to these juvenile records and will also ensure that the Ombudsman for Children also receives access to these records. OFC, the Ombudsman for Children, is designed to investigate failures that take place in the child welfare system. Without having the same access to juvenile records as the system it is tasked to investigate, OFC will be unable to fulfill its mandate. The committee recognizes that juvenile privacy is a paramount concern. This legislation only allows a limited access to juvenile records and only offers that access to discrete parties charged with handling youth issues. It is also worth noting that the mayor, the Department of Behavioral Health, the Department of Human Services, and DC Public Schools all currently enjoy access, yet they do not have the committee or OFC's specific youth-centered responsibility. This bill will solve glaring gaps in the child welfare system. Next, we have promoting parental engagement at DYRS. This bill will require DYRS to make reasonable efforts to contact families of committed juveniles to invite them to a predisposition meeting. This meeting is essential to the development of each juvenile's individualized rehabilitation plan, and it is vital that these meetings happen under the Road Act. This bill will further require DYRS to continue to contact families at least every 6 months following the planned meeting in order for the family to have the opportunity to learn about their child's rehabilitative progress. It also requires the agency to keep a log of these attempts to encourage transparency. Countless research indicates that there is a strong correlation between family engagement and children's successful rehabilitation. Parental involvement is consistently linked to decreased delinquency and stronger mental health. Studies have also shown that parents serve as a protective factor for children, shielding them from dangerous social influences and other outcomes. Most importantly, juveniles that remain connected with their parents during commitment are statistically less likely to reoffend. This bill will help drive down recidivism by ensuring juveniles receive effective treatment that incorporates parental guidance. It is vital that the agency makes better efforts, stronger efforts to maintain connections between families and children in the care of DC, and this bill will help ensure those efforts are made. Next, we have the strengthening capacity and transparency at DYRS. This bill achieves 3 important goals. It establishes daily and monthly juvenile data reporting requirements for DYRS. It defines recidivism and provides recidivism as a metric to be used by DYRS, and directs the mayor to find pathways to reduce overcrowding at the Youth Services Center within 120 days of the bill's passage. This bill reflects the committee's dedication to promoting accountability at the agency and ensures that the council retains important data points for oversight purposes. Most importantly, this bill will ensure that DYRS and the juvenile justice system at large has information it needs to work to reduce recidivism. As of latest studies, the juvenile recidivism rate for serious crimes stood at a staggering 92%, depending on who you ask. The director of DYRS would argue that that number should be around 50%. Again, that is why it's important that we define recidivism in our code. In order to make inroads in public safety and ensure that these children are getting the rehabilitation they are entitled to, juvenile recidivism information must be continually updated and reviewed. This bill will ensure this information is collected for these purposes. Next, we have the Safe Pregnancy, Delivery, and Postpartum Care for Youth at DYRS. This bill requires DYRS to offer quality, culturally responsive care to every pregnant detained juvenile at DYRS. In recognition of the need for DYRS to establish a uniform and standardized pregnancy policy, the bill calls on the agency to create an intelligible protocol for pregnant youth and provide it to counsel and any youth at DYRS determined to be pregnant. It further requires that every detained female receive a pregnancy test upon admission and prior to the prescription of any medication. Over the summer, Dr. Maggie Wan, a OBGYN specialist, joined the committee to consult on this legislation. After reviewing records and meeting with DYRS medical staff, Dr. Wong made recommendations reflected in this bill in order to align the agency with best medical practices for pregnant youth. Recently, the Office of the Independent Juvenile Justice Facility Oversight published a study of youth at DYRS taking psychiatric medication, and this study concluded that 0 out of 12 patients on this medication were offered a pregnancy test upon intake. Given that the mortality rate for justice-involved female justice juveniles is 8 times higher than the general population, it is imperative that DYRS provide adequate, tailored health care to every pregnant youth at its facilities. In conclusion, I want to thank all of our public witnesses today, as well as our government witnesses and the Committee on the Judiciary and Public Safety and Chair Pinto for being a part of today's proceedings. I do want to acknowledge we have also been joined by my at-large colleague, Councilmember Robert White, and who is a member of this committee, and I'm looking for him to weigh in as well. I will turn to Councilmember Pinto for a statement and then Councilmember White before moving on to our government witnesses. With that, Councilmember Pinto.
Great. Well, good morning, and thank you so much, Chairman Parker, for introducing these bills and for holding this joint hearing with us today. I think these are a really important set of issues that we're going to talk about today, affecting our young people, children, and families across the city. I am Councilmember Brooke Pinto. I represent Ward 2, and I'm chairwoman of the Committee on Judiciary and Public Safety. And this joint hearing is not only a indication of our kind of shared focus on making sure that we can advance legislation that supports our young people and families, but also our shared goals around being holistic when it comes to our public safety and opportunities that we're providing for our young people. We have to continue to be proactive in ensuring our kids are engaged in positive opportunities that support their development and their public safety. Last week, the council passed emergency juvenile curfew legislation, which provides MPD a critical preventative tool to keep our city and our kids safe. And as I said then, and I want to underline again now, the juvenile curfew is just one tool, and certainly not the only one, to keep our kids safe and to foster their well-being. We also must continue to provide positive programming and supports for our young people and ensure that our kids have the financial support that they need at home to thrive. Earlier this year, I introduced the Expanding Community Access to Safe and Clean Recreational Space Act of 2025 to ensure that our young people have safe spaces to gather during evenings and weekends. And I'm excited that this bill is having a hearing in the Committee on Facilities on December 3rd. We must remain laser focused on supporting a learning environment in all of our schools that also helps our students learn, play, engage, and thrive in a healthy way. The council recently passed my legislation to prohibit students from using cell phones at school, and I funded the Early Literacy Education Task Force recommendations to ensure that our teachers have the resources and the training that they need to teach our students how to read. The data shows that it's working. Our students are making record gains in literacy, and the number of DC students meeting or exceeding expectations rose at every single grade level this spring. So supporting our young people requires a holistic approach, and we will all continue to move forward locally in ways that support our youth in all 8 wards. Well, I'm interested in all of the bills that we are considering today. I will be specifically focused on the bills that we have jurisdiction over with the Public Safety Committee. Not only because they support our goals in empowering our young people, but they also touch on the fiduciary, judiciary, and public safety matters of which we have jurisdiction. So Bill 26-399, the Support Opportunity Unity Legal Relationships Amendment Act, otherwise known as SOL, aims to create a new legal permanency option for children involved with the Child and Family Services Agency. This new permanency option would enable youth to acquire a stable network of supportive adults able to provide housing, care, and mentorship. In 2023, Councilmember Nadeau and I worked together to pass the Vulnerable Youth Guardianship Amendment Act, which established a special kind of guardian to ensure the legal rights, care, and support for non-citizen youth between the ages of 18 and 21, as we recognize that the existing system had gaps for this particular group. SOL promises even more encompassing change to support youth under and coming out of the foster care system. I'll be especially interested to hear from our public witnesses on ways that this proposal that we've already seen enacted in Kansas could be enhanced if enacted here in DC. My office has been holding conversations with the Children's Law Center, the DC Family and Youth Initiative, and youth with lived experience in the district's foster care system, some of whom I understand will be testifying today. And I want to uplift and recognize the lived experts and LEX leaders for their years of work and the ongoing work that has brought this important legislation before us today. Thank you all. Second, I share Councilmember Parker's concern that our current neglect laws in DC are not as consolidated or clear as they could be. Most of all, I share the policy goal behind the legislation that if families suffer from economic and housing insecurity, that socioeconomic condition on its own should not be conflated with neglect. And so we need to be very precise on what neglect entails. But at the same time, we need to ensure that the whole needs of the child are being met. This bill, Bill 26-400, the Statutory Neglect Amendment Act, aims to streamline and clarify the definition of neglect, and I look forward to exploring ways to improve upon and clarify the law. Third, Bill 26-401, the Youth Records Transparency and Oversight Amendment Act of 2025, seeks to encourage rigorous oversight by bridging potential information gaps between DC government agencies and the Committee on Youth Affairs and the Ombudsperson for Children. I would like to get a sense today from the government witnesses about the current legal landscape and systems in place to ensure privacy and confidentiality of youth records while ensuring that the council is able to exercise rigorous oversight over agencies involved in such important care for youth and young people. I know that we can find a better balance of protecting the privacy of young people and making sure that we are all operating on the same information so we can drive forward improvements. A blanket, everything is going to be private, it just can't be sustainable any longer. We need access to more information. And fourth, the Promoting Parental Engagement at DYRS Amendment Act intends to require DYRS to maintain an electronic record of its attempts to contact the appropriate parties, including parents and guardians, prior to a predisposition meeting, and make this log available to the chair of the council committee with oversight of DYRS. I'm interested in learning today from Director Abed about the logistical and practical challenges that may arise from implementing this type of electronic system. And I'm eager to discuss Bill 26-407, Strengthening Capacity and Transparency at DYRS, which aims to require the mayor to publish within 120 days a plan to address persistent overcrowding at the Youth Services Center and require the Department of Youth Rehabilitation Services to publish publicly certain population data pertaining to our youth. A cornerstone of much of the legislation that we have moved around public safety is around holding agencies to account by requiring more transparency and thorough accounting, such as the public performance dashboard that we moved in Secure DC for the Office of Unified Communications. And I think this is an opportunity to consider how that type of transparency can help us improve outcomes for our kids. And we look forward to discussing the safe pregnancy, delivery, and postpartum care for youth at DYRS Amendment Act, which will ensure that all juveniles at DYRS receive appropriate, confidential, and culturally responsive pregnancy care. Last year, we made some important changes around pregnancy care to adults at the Department of Corrections. And as we consider kids who may be pregnant or having children on their own at DYRS, it's especially important to ensure that they are cared for. So thank you very much again to Chairman Parker for leading on these important bills, and for all of you for being here today and being part of this discussion, and for the very difficult and important work that so many of you do to support our young people in the city. It is difficult work and it is crucial work. So we really appreciate all that you do. And with that, I will turn back to Chairman Parker.
Thank you, Councilmember Pinto. Now I will turn to my at-large colleague, Councilmember Robert White, for a statement.
Thank you so much, Chairpersons Parker and Pinto. And to everyone who's joining us today, I want to thank you both for convening this hearing and for the work that went into shaping this package of bills. I'm proud to have co-introduced several of these measures because they reflect something I've heard consistently from families and youth, that our system too often separates, isolates, or overlooks them when what they need most is connection, consistency, and care. The bills we'll discuss today share a common purpose: to bring more humanity, transparency, and accountability to DYRS. They are about strengthening relationships between youth and families, between DYRS and the public, and between this government and the people it serves. For me, this is about more than data or compliance. It's about whether young people in our care can see a path forward, one grounded in safety, dignity, and hope. And it's about whether families feel that the system, bless you, wants them at the table or on the sidelines. We know that the rehabilitation cannot happen in overcrowded facilities, in the absence of trusted adults, or without meaningful oversight. The bills before us today take real steps toward changing that. I want to take a moment to mention the SOUL Act specifically. Too many young people age out of the system without the kind of stable, lasting connections that help them thrive as adults. And if any of us imagine ourselves in that situation as young people, with the guidance that we had to make that transition, and compare it to what is likely to happen for young people trying to transition into adulthood without that, it is not hard to imagine that many of us would be in circumstances more difficult or dangerous than many of the young people who are aging out of our system now. This bill gives them another option: to formalize a support family made up of the people who have been there for them: mentors, extended kin, trusted adults, without cutting off ties to their biological families. It recognizes that family is defined by care, not just by paperwork. This bill aims to make sure every young person leaving care has a foundation of love, consistency, and belonging, something that we all need to succeed. One thing that worries me about some of these bills that I will flag is that many of them are administrative in nature. And when bills are administrative in nature, what that means is that these are things the agency could do without legislative approval. And I worry a lot about when we have gaps in cooperation between our agencies and the council. I will have to leave this hearing momentarily to chair a hearing on housing vouchers. Without passing legislation, we've cut in half the time it takes for people to get vouchers and get into housing, because we had cooperation of the agencies and partner council committees. Contrast that with housing conditions. The jury is out on whether the administration is going to work with us on housing conditions, but these are things that we can do without the long, laborious, costly effort of passing and funding bills. And so my hope is that as these issues move, our agency partners see opportunities to work with the council to do things that just make sense. If young people need pregnancy tests, give them pregnancy tests. Don't make us pass legislation, right? The point of data is to give transparency because there's an underlying problem. We've got to be focused on the underlying problem. We can't celebrate because we've gotten the data. The fact that we need data is pointing to a bigger problem. So I want to make sure we stay focused on solving the problems. And certainly my colleague Zachary Parker has advanced the slate of bills focused exactly at that, solving problems. So I look forward to being a partner in this work. And again, apologize that I will have to leave to chair my own hearing. Thank you both.
Thank you, Councilmember White. And with that, we are going to move to our government witnesses first. I do want to acknowledge I'm going to switch the order of some of the individuals then they are listed. We will first hear from CFSA and our Ombudsman for Children. So I'm going to ask that Acting Director Tanya Torres-Trice of the Child and Family Services Agency join us, as well as Ann Riley, the Deputy Director of Office of In-Home and Out-of-Home Care for CFSA, as well as Patrina Jones-Jez, the Ombudsman for Children. Followed by this, depending on how long this panel goes, we may or may not switch to the Office of the Attorney General or DYRS. It depends on time. Director Abid has a hard stop that I am going to honor. And so, Director, you may go next or you may go third in the panel, depending on the order of the. Yep. So with that, give me 1 second. All right, which is, we are going to ask you all to please stand and raise your right hand to swear you in, which is custom of the council. And do you attest that everything you are about to testify to is the truth and the whole truth? If so, please verbally affirm. Awesome, thank you. And with that, I will ask Acting Director Torres-Trice to begin.
Thank you, and good morning, Councilmember Parker, Councilmember Pinto, and Councilmember White. My name is Tanya Torres-Trice, and I am the Acting Director of DC's Child and Family Services Agency. I am here today to testify on Bill 26-400, the Statutory Neglect Act of 2025, and appreciate this opportunity to testify. I'm also joined today by Ann Riley, Deputy Director of CFSA's Office of In and Out-of-Home Care, who will testify on Bill B 26-399.
Sorry to interrupt.
Yes.
Director. If you could just speak into the mic more. They're having a hard time hearing you.
I am so sorry. Better?
That's much
Okay,
better.
let me start over. Good morning,
Good one.
Councilmember Parker, Councilmember Pinto, and Councilmember White. I am Tanya Torres-Trice. Move it closer. The Acting Director for DC's Child and Family Services Agency. I'm here today to testify on Bill B 26-400, Statutory Neglect Amendment Act of 2025, and appreciate this opportunity to share the agency's perspective. I am also joined today by Ann Riley, the Deputy Director of CFSA's Out-of-Home and In-Home Care, who will testify on Bill B 26-399, Support, Opportunity, Unity, Legal Relationships Amendment Act of 2025, also referred to as SOUL. Prior to the bill's introduction, CFSA collaborated with the Children's Law Center and the Office of the Attorney General on some of the provisions contained in the bill from the Child Welfare Agency and clinical practice perspective. If enacted, this bill will help clarify, consolidate, and streamline the district's current neglect code to align with the current child welfare standards and practices by creating a uniform standard for the determination of neglect. I want to thank the Thank you, Councilmember Parker and Councilmember Pinto, for moving this legislation forward. CFSA shares a sentiment that circumstances resulting from poverty do not and should not automatically constitute neglect. However, while I support the intent and purpose of this bill, I also want to take the opportunity to raise a few concerns. Financial means and reasonable efforts language. The language proposed in lines 41 and 42 of the bill is vague and unclear. CFSA is already required to make reasonable efforts to prevent a child's removal from the home under DC Code 4-1301.09A, which deals with preservation and reunification. Including this language seems to suggest that CFSA must make reasonable efforts to prevent the determination of neglect itself. CFSA does not agree with this approach and believes it will lead to unnecessary confusion. We agree that financial analysis is appropriate during the court phase, but recommend removing the following language from the bill, demonstrated by reasonable efforts by the Child and Family Services Agency pursuant to 4-1301.09A. repealing mental and physical capacity language. Repealing the current language regarding mental and physical capacity could be problematic. Currently, the law defines a parent's substance use or mental health adversely impacting their ability to parent as neglect. The existing language allows CFSA to consider whether the substance use or mental health has an adverse effect or impact on the child. Thank you for the opportunity to testify today. I will now turn it over to Deputy Riley, who will provide testimony on SOL, after which we both look forward to answering any questions you may have.
Thank you.
Good morning, Councilmember Parker, Councilmember Pinto, Councilmember White, committee, members of the committee, and committee staff. My name is Ann Riley. I'm the Deputy Director for In-Home and Out-of-Home Care at DC's Child and Family Services Agency, and I am here to testify on Bill B26-399, the Support Opportunity Unity Legal Relationships Amendment Act of 2025, also known as the SOL Act. CFSA supports the intent behind the bill. However, given the current financial climate, the executive will need to assess the fiscal impact of the bill, before determining whether it can be funded in the FY27 budget. As a proud social worker and a 17-year veteran of CFSA, I have managed various parts of the foster care program and the Child Protective Services hotline. For more than 6 years, I have served as deputy director, managing foster care and overseeing in-home community case management, kinship, parent engagement, placement, and resource parent support. My experiences have shaped my views on CFSA's critical work in supporting DC's most vulnerable children and families. CFSA operates at the deep end of the child and family well-being system. While critical for safety, the intervention of separating a child from their family is always traumatizing and has lifelong impact. While we celebrate success with some of our older youth who attend college or find employment, we must expand our work in permanency. Nationally, 8% of children in foster care age out or emancipate from the system. In the district, this rate is 16%, twice the national average. CFSA currently serves approximately 525 children in foster care, with 150, nearly 30%, ages 16 to 21. In fiscal year 2025, 65 youth in this cohort exited foster care. Of these, 16 reunified with their parents or caregivers, 9 achieved legal guardianship or custody, 3 were adopted, and 37, just over half, aged out of our system on their 21st birthday. Aging out means that during a youth's time in foster care, we were unable to achieve reunification or find an adoptive parent or legal guardian before age 21. As a result, these 37 young adults began their adult lives without family and the sustained support system everyone needs to succeed. Unsurprisingly, outcomes for youth who age out, the majority of whom are Black and brown youth, are often poor. They struggle with stability, mental health, housing, and employment. While some overcome these challenges, which you will hear from some of them today, as a city, we must do better by connecting all youth to the sustained love and support needed to navigate adulthood. SOL would establish an additional legal and supported pathway out of foster care, beyond the current options of reunification, adoption, or guardianship. These current options do not meet the needs of all youth. The bill seeks a youth-driven permanency goal for youth 16 and older that legally recognizes and supports the circle of committed adults in their lives. Developed by young people with foster care experience over the last 2 years, this option aims to heal and prevent harms caused by the current system. With SOL, youth are empowered to choose their pathway, build their chosen families, maintain legal relationships with birth parents and siblings, and exit foster care positioned for success. SOL permanency will be ordered by DC Superior Court and supported by CFSA through case management, planning, and subsidy payments. CFSA will obtain clearances, local police, FBI, and child protection register for SOL caregivers, similar to what we do with our other permanency options. We will share any criminal or child neglect history with the court and explain the mitigation efforts that support our confidence in the caregivers when there are issues. Since June of 2023, CFSA and community advocates have partnered with our city's youth and young adults with lived experience, we're calling them LEX, to bring SOL to DC. This partnership has been led by these young people. They've co-chaired every committee we have had for the past 2 years, along with adult supporters, and they have guided policy enhancements and strategy, keeping the youth voice central and authentic to their experiences. Thank you for the opportunity to testify in this legislation, and I welcome any questions.
Thank you. And last on this panel, we have Patrina Jones-Jez, the leader of our Ombudsman for Children.
Good morning. Good morning, Council members Pinto, White, and Parker, and Council staff. My name is Patrina Jones-Jez, and I'm serving as the Ombudsperson for the Office of the Ombudsperson for Children. The Office of the Ombudsperson for Children was established through enabling legislation in 2021. And as an Ombudsman office, we are structured based on the pillars of Ombudsman work, which include independence, informality, neutrality, confidentiality, and a credible review process. Our agency's mission is to work collaboratively across systems that impact CFSA children to foster improved outcomes, strengthen service delivery, and increase accountability. I appreciate the opportunity to testify at today's hearing regarding proposed legislation affecting the district's children and youth. Since the first constituent contact received by the OFC in February 2023, we have continued to gain information and knowledge about DC's child welfare system. Most complaints received by our office address violations affecting child welfare-related policy practice or the law. Ultimately, we are excited about the bills submitted for discussion with the purpose of improving the district system for addressing the needs of children and families. Today's testimony focuses on 3 of the bills for discussion: the Statutory Neglect Amendment Act of 2025, the Youth Records Transparency and Oversight Amendment Act, and the SOUL Amendment Act. So in regards to the Statutory Neglect Amendment Act, we support this act for the following reasons: the comprehensive approach to defining neglect and updating the definition to reflect current child welfare policy and practice. So in other words, addressing the issue of poverty as not a reason for finding a neglect or a substantiation of neglect. We also believe that there's an opportunity through this particular bill in regards to connecting families to the 211 warm line when they are in need of additional resources. And those vital connections will be important for those families to get those resources. Furthermore, we request the following considerations. We recommend strengthening the bill by adding specific examples of CFSA's demonstrated reasonable efforts. So for instance, are we speaking to family assessments, for example? Also, we understand the importance of parental relationships throughout the child welfare system and the children involved in the system. A quality relationship between the child and his parents is critical to his or her well-being, growth, and development, and plays a role in improving outcomes in the areas of education, emotional, and behavioral health. It is our position that 4 months without parental involvement is an appropriate timeframe for establishing abandonment. We have seen parents that have not had contact with their children for 4 months or longer. After 4 months, the caretaker will have the ability to apply for resources and assistance for the child due to the child's abandonment status. In regards to the SOUL Act, we are excited about this bill introduced by the committee to implement SOUL as a permanency option in the district. We believe a key component to an effective transition to adulthood is the mentoring and support from caring adults who are willing to guide the youth's development and growth. Of the many features included in the SOUL Act, the OFC supports the following: that this is a youth-initiated placement option. Only the youth can establish this family support option. The legal rights of the parents are not terminated due to the selection of SOUL as a permanency option. All legal familial relationships remain in place. We support the role of the guardians ad litem as they monitor and advocate for the best interest of the youth as well. The OFC had the pleasure of participating in the initial kickoff meeting hosted by CFSA and attended by agency stakeholders. We understand that the development of this legislation was done collaboratively and agree with that approach to create a studied and comprehensive permanency option. We also believe this legislation could be strengthened by ensuring a process for background checks on the identified potential caretakers or caring adults, and acknowledge that these connections will likely be safe connections. This process could be conducted with oversight from CLC as deemed appropriate by their agency. Further, we recommend ensuring that this option has been vetted with youth and that they have had a voice in the development of the SOUL Act. The last bill that I will speak to is the Youth Records Transparency and Oversight Amendment Act. The OFC fully supports this act. One of the office's many duties is to track and monitor outcomes for crossover youth. Those are youth who are currently involved, previously involved, or have had any involvement with CFSA, and also have a petition that was filed by the OAG, a juvenile justice petition filed by the OAG. So due to the OFC's legislated requirement and responsibility to these youth, access to DYRS case records will assist the office with addressing submitted constituent complaints by accessing case records on crossover youth residing in DYRS facilities. Strengthening transparency rules on access to case records will ensure greater oversight of DYRS's compliance with policy, law, and practice, and opportunities for the office to make recommendations for improvements to juvenile justice youth-focused services as appropriate. Further, to strengthen the language of the bill, we would like to see added language stating that the OFC will have access to DYRS facilities as appropriate and based on the need. For instance, due to an investigation based on a constituent complaint. Detailed recommendations for changes to the language in the bills have been sent separately to the committee staff. I am happy to answer any questions.
Thank you, and thank you all for your testimony. I'm going to turn to my colleague, Councilmember White, because he does have to run to another hearing, and then I will then jump in for a round of questions. We will put 10 minutes on the clock, and you may proceed.
Thank you so much, Chairman Parker, and thank you to our witnesses. How does CFSA work with DYRS right now when a young person becomes pregnant?
Sure. So if there is a youth in our care or CFSA's care, and they are also put at DYRS, we have a case caring social worker who works alongside their workers at DYRS, and we collectively case plan for the young person.
What's included in the case plan?
All encompassing. So health, mental health, behavioral health, any needs that arise. We're always striving to work towards permanency for our older youth, but health is considered and is assessed as part of the case plan.
Okay. And there's coordination between CFSA and DYRS?
Yes, there is.
And what kind of, so if the young person ends up at DYRS, what does that care plan look like?
If a young person ends up at DYRS and also is committed to CFSA, we work with the DYRS team and follow their case pretty regularly. The teams meet jointly. And again, our goal is not to overburden the youth, but really to ensure that the young person has what they need, whether it be from us or DYRS. So it is a collective effort. While they are in the care and custody of DYRS, we are planning for their release back into the community. So it is important that we do understand their needs, whether they be behavioral or mental health related.
And how would it differ if the young person was not in CFSA, was not a CFSA client, was at DYRS?
Then we wouldn't have any rights or responsibility to case plan or work with the young person.
Right. So who is responsible in that case?
In that case, it'd be DYRS.
Okay. So DYRS, what happens for a young person who's at DYRS and not CFSA and becomes pregnant?
I believe that'd be a question for Director Abed.
Oh yeah, he's up next. So okay, and I'm sorry. There were a couple of changes from the agenda that I saw, so I'm trying to remember who everybody is. Okay. And do you have a written agreement or policy with DYRS that spells out who handles what when a youth moves between the two agencies?
I don't know that we have a written agreement, but I will double check on that. But we do have regular communication, and our two teams meet on a weekly basis, sometimes daily, depending on the needs of the young person.
Okay. And I'm sorry, our last witness, can you remind me of your name? I'm sorry.
Katrina Jones-Jez.
Okay. All right, Ms. Jones, Jez, I was following your testimony. I didn't read it in advance if you had submitted it. I was trying to understand which bills do you support, which do you not support, and are there some caveats?
We support all of the bills. So for instance, the Statutory Neglect Amendment Act, we have made some recommendations in terms of language changes, some details that we have shared with CYA staff, but generally speaking, we believe that it is time to improve that particular act, and specifically the definition of neglect for the district. And we think that this act does that.
Okay.
In regards to the Youth Records Transparency and Oversight Amendment Act, we are also in support of that specific act. So as I mentioned, our office has specific responsibility around identifying, tracking, and monitoring crossover youth. So those are youth who have had involvement with CFSA currently, previously, at any point, but also have a petition filed by the OAG. So they have juvenile justice involvement basically as well. Some of those youth may reside in a DYRS facility. We expect, and we have actually received concerns about youth in DYRS, residing in DYRS facilities for our review and to investigate. And so this act gives us a lot more, or much more, of the resources that we need in order to complete a comprehensive investigation, if that is appropriate for that particular complaint.
There was something you mentioned in your testimony that
Yeah.
I wasn't sure I heard it. Did you say you disagree with poverty being an indicator of neglect? Or did I misunderstand that?
Yeah, essentially, that is what I was saying.
Okay.
So I see poverty as, let me step back. There was a time in child welfare where youth and children were being removed from homes because there was no running water in the home. That is not neglect that's our position. That is a family that is in need of assistance and resources. So that's the position that I'm essentially coming from.
Okay. What would then be an indication of neglect?
So if there is a family that has adequate, the means for adequate housing, food, the ability to provide the resources so the child can have a good education, or meet their educational needs, and they're not supporting their child in those ways, would be a neglect situation for me.
Okay, I appreciate that. Look, growing up there were times our water wasn't on, and right now, what these utilities are costing, there's gonna be a lot of us without water or power soon. There was something else you mentioned though that concerned me, but I didn't fully understand it. You had pointed to the 211 warm line as a resource. Instead of what?
So not instead of, but going back to this discussion of, is if a family is in need of support because there's no running water in the house, they're behind on the water bill, they don't know how they're going to pay the water bill. The 211 warm line becomes a resource to that family, an organization that they can reach out to to request assistance. It could be financial assistance, it could be some other kind of assistance to help them get the water turned back on, just using that as an example. So we see the 211 warm line as being, and we like to promote the 211 warm line because we think it's a wonderful option for families in the district. But as opposed to removing children from their homes because there's a utility not on,
Right.
here's a wonderful resource that can help families meet the needs of their children.
Okay. Okay.
So
Okay. I appreciate it. Thank you.
Yeah,
That
no.
makes a lot more sense
sure
now.
thing.
Last question for me. Do we need legislation to require pregnancy tests?
Are you directing that question to me?
Anybody who wants to answer it. Why do we need legislation to require pregnancy tests? Can we move that forward without legislation? Like, is a show of partnership, like, unless there's a really good reason, in which case I'd love to hear it.
I would like the opportunity to consider your question a little more deeply, if possible. I don't know that I certainly see your point, absolutely. There are things that we should just be able to do instead of going through this process, bringing everyone together, hearing from the community. There should be ways that we can establish internal policy and guidelines and procedures of how we're going to do things. So from that perspective, I would say that I agree with what you're saying. But for me, I don't have all the information as to why this bill was created and presented.
Mhm.
So that's why I'm thinking about more details around this bill.
Okay. All right. I just think there are opportunities for partnership here, and maybe some of these things do need to move as legislation for various reasons, but maybe some don't, right? Maybe there are some opportunities for us to work together, and this is a time when we really are going to have to do that on many levels and talk to each other. And I appreciate the testimony; has been very helpful and enlightening for me. So thank you, and again, thank you for your graciousness, Chair Parker and Chair Pinto.
Thank you. Thank you. We are now going to reset the clock. While we do that, I would just say it's not just about pregnancy tests. It's about the agency creating a protocol and guidance in addition to providing pregnancy tests and bringing our juvenile justice system in alignment with our Department of Corrections, where this is a similar policy, so that all young people, not enforcing gender, all young people can be safe even if they are in detention. I'm going to jump in with you, Acting Director Torres Trice. I know the answer to this, but I'm going to ask on the record.
Sure.
Does CFSA currently use poverty as the sole factor in determining neglect for a family?
No, CFSA does not use poverty as a sole determination of abuse or neglect.
Understanding that families are at times struggling when you are investigating, can you talk about what resources, if any, you provide to families and how you determine whether or not something is a result of poverty or a family may just need more resources versus there actually being a legitimate neglect finding?
Sure. As Katrina mentioned, the Warm Line is a resource that we use. We use our community collaboratives. We connect them with partners in the community, both public and the community partners to ameliorate any issues that we are finding. We do not want to separate children unless we must. It is traumatizing. It is has lasting impact on their lives. And so we do everything within our power to try to address the needs that we are seeing in the investigative process. So that could look like connecting with a resource to turn back the lights back on. Could mean finding adequate food, transportation. It could mean working with the schools to get an IEP so that the young, maybe they're not going to school because they are feel like they are not learning or whatever the reasons are. We try to resolve those first. We do not want to separate unless safety is at risk right now. So we work very hard to keep families together, and we do so with our community partnerships and with our resources that exist here in the district.
And so, furthering there, one of the critiques of CFSA I've heard is from parents that say, I didn't know I was under investigation.
Mhm.
CFSA showed up at my child's school and interviewed my child alone for hours. And I'm only finding out later that I've been under investigation. In that type of scenario, how then do you pivot to provide resources to the family if they aren't even clear that they're under investigation?
So I have heard that feedback, and what I would say is the parent, we must interview the parent always. We cannot separate a child. We cannot go and ask questions. We must always interview the parent. So I haven't heard that feedback in a while, but I do understand that it can be a stressful process, and people aren't happy when we come to their doors and come to their schools and their homes and interview the people in their lives. But if safety is a concern, we will interview the child separate from the parent, because we do want to be able to understand from the child's perspective, if they're able to speak, what is going on in their home.
Understood. Data-wise, how many youth are separated from their families each year due to neglect findings? Do you have that
I
figure?
don't have that with me today, but I definitely can get that for you.
Okay. As you know, the legislation takes steps to separate terms abuse from abandonment, as those are two distinct findings. Can you speak to the challenges of the current code and how abuse may be misconstrued with abandonment?
Sure. Currently, it's not clearly defined, and there's no time frame in the current code, so it is left to the agency in the courts to determine what abandonment looks like. Abandonment for a 3-year-old looks very different than what could be construed as abandonment for a 15-year-old. And so I think the current code is vague, and then that leaves it to interpretation, opens it up for interpretation on what abandonment is.
Can you speak to the range of findings that you've seen in your experience? Like what time length has been used to determine abandonment by the courts or the agency?
I don't have that today, but I can look into the data and get that to you.
Okay.
Mhm.
But to your point,
Mhm.
you would agree that clarifying abandonment in the code would be important so that there is alignment between the agency, the courts, and the public.
I agree.
Okay. I'm going to ask this on the record, although we talk about it all the time. Why isn't educational neglect a greater priority for CFSA?
Educational neglect is a priority for CFSA. We do believe all children should be in school, and we do believe we should support parents in getting children ages 5 to 13 to school. It is a priority, and it will continue to be.
Would you agree that the code is currently vague on educational neglect, like you're speaking to the vagueness of abandonment?
I would agree there is some ambiguity, yes.
Yeah, because right now there is nothing that says this is what constitutes educational neglect. We kind of fill it out.
Yep.
And I bring that up because we have a truancy crisis in the district, and parents are allowed to just keep their kids at home. And I'm screaming from the rooftops that I think educational neglect is as serious as other forms of neglect. I will get off my soapbox, but I wanted to use this opportunity to bring that up. Specifically, you talk about concerns with lines 41 and 42, specifically the use of the phrase reasonable efforts. Why wouldn't we want to clarify CFSA's actions, reasonable efforts in determining neglect?
Because it is covered in DC Code 4-1301 as part of the investigative process. So it just feels a little confusing where it's written. So we do cover reasonable efforts in as part of DC Code 14.1301.09.
Okay.
Mhm.
I will look at that.
Okay.
But thank you for the clarification. And I want to ask, does the agency support this bill?
The agency supports the intent of the bill.
The intent of the bill. Okay, well played. I'm going to move to Ann Riley and talk about the SOUL Act. It sounds like you all have long been a part of this process, likely well before it was even on my radar. So thank you for working with our young people to create a new permanency option. Can you speak to why, if CFSA has been at the table working with youth, believing in this policy, it has not been implemented by the mayor or included in the budget? Like, why am I having to bring this forward versus you all bringing it forward?
Sure. Yeah, we have been working on this for some time. I was at a meeting with some national partners in February of 2020 where this was introduced as a concept before Kansas went forward. And then while Kansas was in process, we started working again in DC. We do need the legislation on this because it is a legal permanency option. So we need DC code to list it as a legal permanency option, just like adoption, reunification, and legal
But
guardianship are listed.
why not the mayor send down a bill or include it in the budget? What I'm getting at, and it's not meant to be a gotcha. The young people who helped craft this bill came to the committee to say, we're desperate. We were working with CFSA and we ran into a roadblock. They weren't clear whether or not the bill was moving forward. It sounds like the agency's position is you support the bill. Is that accurate?
We do.
CFSA supports the intent of the bill, but will have to complete a fiscal statement.
Okay. So is the financial cost of this implementation, is that the issue?
That is a large portion of this. And again, we do support the intent of the bill.
Okay. Can you speak to the current outcomes for youth who age out of foster care and some of the challenges that young people, when they age out without a supportive unit, experience?
Sure. We have a hard time tracking that specific for DC with our data because once they leave our system, CFSA is no longer tracking and we're relying on other parts. But the national data is very clear, and I think we see it play out in the city. There's increased homelessness. There's increased very young pregnancy. Youth who have experienced foster care are more likely to be incarcerated as adults. Youth who experience foster care are more likely to have their children enter foster care. It becomes very cyclical for families. There's some national data showing that over 40% of kids who leave foster care are incarcerated before they're 25. And 50% lower earnings than their peers who didn't experience foster care and high unemployment rates.
That is compelling. And so I would just say again, this is more than just about creating a permanency option. It's about making sure these young people are able to live well and thrive. And it informs public safety. It informs the vibrancy of our city. And so we will be working to do everything we can to get this across the finish line. And I appreciate your support along the way. I'm going to stop there. I do have more questions, but I'm going to turn to my colleague, Chairperson Pinto, for a round of questions, and then I'll come back.
Great. Thank you very much, Chair Parker. And thank you all for your testimony. And as I said at the outset, all of the important work that you do for our young people and for our city. Ms. Jones-Jez, I want to continue the discussion you were having with Councilmember White around economic needs versus neglect. And I want to push back a little bit on something you said and understand it a bit more. When you were talking about the example of the faucet not being able to go on, and you said something like, well, if a family has the means to be able to provide these resources for their children and they're not, then that's neglect. But what about the family who doesn't have the resources, but that child is still suffering the consequences? Like how can we distinguish so greatly that we're not putting our children with the least resources at more risk because we're not recognizing that regardless of the circumstance and the additional services we need to get to that family, that child is suffering?
Yes, thank you for the question. So I do not disagree with your statement. From our perspective, the family that has financial needs and may not be able to keep the utilities on that family has a greater need for resources and supports. And I would agree with you, it is neglect. The situation would be the same if you have a child that is denied, housing for some reason through a family that actually has the means to provide housing, and then you have a child that is not in a certain form of housing due to the family not having resources, would both be neglect. However, with families who are experiencing poverty, and I think we have a great opportunity to talk more about the impacts of poverty on people. I see that, and I think we see that as an opportunity to help that family with the resources that they need in order to meet the child's needs, as opposed to the family that can provide those needs and chooses not to.
But how do we measure that? Like what about the interim where that child doesn't have water or access to utilities? What are we doing to help that child today as we try to address the longer term needs of the whole family's stability?
Yeah, and I think that's where the 211 Warm Line and other resources can come in. Certainly, the Child Welfare Agency should be assessing the needs of the family as well, identifying resources for the family to take, to use in order to get the resources that they need.
Do you think, just sticking with the utilities example, there should be some demonstration that maybe you have applied for assistance or gone to the utilities to access any of the programs that they offer to low-income families to demonstrate you are trying to get your child access to basic needs?
I think that's a great example of advocating for yourself and taking the steps needed to ensure that your family has the resources that they need.
Okay. Okay. Well, thank you. I want to turn to Acting Director Torres Trice. As we think about going back to the truancy conversation, I appreciate you saying that it is a priority of CFSA, but how are we turning the prioritization of that into action to ensure that families know and parents know they are responsible for getting their children to school and staying in school, and they're part of that mission and on the hook if they are unsuccessful in that mission?
Yeah, so again, education is a priority. It will continue to be. We work very closely with our parents when the schools call or whoever calls and says that X child is not in school. We make sure to tell them, we work very closely with the parents to speak to them about the importance of education, the importance of getting your child back into school if they're not in school, and finding alternatives if it's not the right fit. Oftentimes we go in for educational neglect and we see other issues. So we work very closely with the parents that we encounter around the importance of education.
But what happens if that work is unsuccessful and the
Uh,
child is still not going to school?
Then at times they may be separated and found for educational neglect, separated from their home.
And how often does that happen?
I don't have that data with me, but I can get that for you. It's not as often as some might think, but it does happen. The line is a parent's inaction or action, so that if a parent says that they are not going to school because they have transportation issues and we help the parent get transportation, child's still not coming to school, we may go into the home and separate that child. So the parent has to willingly not participate in their education. And that's it's rare, but it does happen.
But do you have any sense of about how often? Like, are we talking or a range of how often that happens on an annualized basis?
I don't want to misquote the data, but I will get it for you.
Okay.
It's not
And
often. Mhm.
yeah, and that's, I mean, we again, back to the data point,
Mhm.
like we need to know that basic
Mhm.
number so we can determine if the system is working. And I talk a lot about a community school that I visited in Maryland where I met with the students and every single one of them knew all of the rules about truancy. And they all told me, we can't miss school because my parents would be in trouble if we did. And we don't want our parents to be in trouble. And I just was so moved by how informed all of these young people were. I mean, I'm talking 10, 11-year-olds who came to school every day because they knew that they had to. And we do not have that sense for a lot of our schools and a lot of our kids missing school or our families. And so I appreciate your comment that it's a priority, but if we can't demonstrate how we are measuring that priority, it's doesn't give me a lot of confidence that it really is a priority. I want to understand better the process for updating and changing permanency from the agency's perspective. I think having those guardrails is important, and we want to be sure that adults who sign up for these plans honor their commitments. And so can you walk us through how that works? And again, what happens if a parent does not honor their commitments? What's the next step?
Thank you. I'm actually going to turn that question to Ann Riley.
Okay.
Sure. The Office of the Attorney General, who's here today, can also talk about this because they represent us in court. But in most cases, when a child enters foster care, the goal is to get them back to the family that they were separated from. Families have about 12 months to do that. So we make a case plan, we put services in place, we want to see demonstrated different behavior. We observe parents and their children together to see how their relationships are. And we make recommendations to the court about what we're seeing and what we think the court should do. The child's guardian ad litem also weighs in on that. And so we go to court about every 3 to 4 months and say we are making progress towards reunification. Parents are doing better. Kids are spending more time with them. They're spending weekends together. We can move forward and having them go home. If we're not seeing progress around the 12-month mark, we start talking about whether we should change their permanency goal. Right now, that would be to adoption or legal guardianship, and start exploring who would do that. In our system, most of the time, children are adopted by the caretakers they're with, either their kin foster parents or stranger foster parents at the time their goal changes. For teenagers, that is more difficult, right? The child welfare system is built on thinking about very young children and what their path will look like. And that is different if you came into care at 14 and you're now 16 and we're saying to you, do you want to be adopted? And do you think this person should adopt you? That doesn't always go well. Adoption does require the termination of parental rights. So we would go forward in court proceedings to say we have an adoptive parent. We want to support this adoption. We need you to terminate the birth parent's rights so that we can legally free this child to be adopted by this other family. That also severs sibling relationships, which is very difficult for many of our kids. And so that's kind of how it works now. The agency makes recommendations to the court. The court has evidentiary hearings where we put on evidence, other people put on evidence about what should happen next in the trajectory of a case.
Okay. And how many children are in the foster care system in DC?
About 525 today.
And has that gone down or up in the last several years?
It's significantly down in the past 10 years. We have seen a little bit of an increase since COVID. Our lowest numbers were during COVID. We were below 500 kids in care, and we have seen that creep up over the past couple of years.
Thank you very much. Thank you, Chair Parker.
Thank you. I'm going to continue there. Ms. Riley, you talked about the national average for youth aging out of the system being around 8%, but here locally it's 16%. What are some of the factors that you believe are informing our rates?
One thing we know to be true nationally is that Black and brown children age out at a higher rate. And in the District of Columbia, 98% of kids in care are Black or brown. And so it's a very disproportionate system that we have here. Starting at the hotline, who gets reported to us, who we investigate all the way through. We also, in the past 10 years, have seen more children entering care as teenagers, which has impacted our ability. Many times that is because there's a conflict in a home, pretty normal teenage behavior, at least how I grew up, where there are arguments, but parents and we can't get to resolution. And the parent will say, like, this kid can't come back home. And so now they're in foster care, and trying to mediate that through our usual case planning and services doesn't really work. There are very few services that repair a teenage parent relationship in a way that allows us to do that and move forward with reunification for a 16 or 17-year-old. So what we have seen is the older you are at the age of entering our system, the less likely it is that you will leave.
And that makes sense. That makes sense. For adoption, does the youth have to approve of the adoption family
Yes.
in order for it to go forward?
Yeah, in DC code 14 and older. So if you're 14 or older, you have to consent to your adoption. Under 14, the guardian ad litem, their attorney makes a recommendation, but they don't have to. Younger
Understood.
kid don't.
And you also talked about some of the consequences that come with adoption, namely the severance of relationships with the birth family or siblings. And so it's not surprising that some teens, older teens, may not want to go that route given the consequences, which again speaks to why a new permanency pathway is so important. What can you just also spell out what would be different if SOL were in effect in the district for some of those older foster youth who are at risk of aging out of our system?
Absolutely. I mean, as you said, I think our experience is often we have youth who are saying, well, I don't want to live with my mom, but that's still my mom. Like, I don't want you to legally tell me that's not my mom. But yes, also I'm not going to live with her. The really incredible thing about SOL that is different than adoption or legal guardianship, it really is a chosen family, and the adults do not have to be related or in relationship with each other. One example I've used a lot over the past couple of years is thinking about a youth who's very connected to their grandmother, but she lives in a senior building in a one-bedroom apartment. We are not going to be able to place that child with grandma ever, probably, right? And we don't want to destabilize her. She's in a good place. She should stay where she is. That youth also has a coach who is committed to helping them with their sports and their college plan. With SOL, the grandmother and the coach could both be SOL caregivers, and we would delineate out their rights and responsibilities through the court. So grandma would be responsible for maintaining family connections and medical decisions maybe, and the coach would make education decisions and be willing to provide housing. And so it really is a youth-centered plan where unrelated adults can come together, facilitated by the agency. We don't want strained, they should know each other and work together, but really be able to wrap themselves around those youths instead of saying, well, grandma's the only option. She lives in a senior building, so I guess you're staying in foster care.
Understood. That is a really helpful example. One of the concerns I had originally when youth brought this concept to me is, well, how do we vet these youth-informed family units? How do we ensure that the young person knowingly or unknowingly is not putting themselves in danger? And you spoke to the background check process, but can you speak more to how CFSA would ensure that these youth-informed family units are actually constructive for the young person?
Sure. I think it's really important to not just know like what is on someone's police report or on their child protection registry, but also have context for it. The youth over the past couple of years of talking about this, we have had some very heated debates at CFSA with people on all sides of whether we should do clearances or not for people. Again, going back to some racist behavior and other things that lead to some people having more on their record than others. But what we know is, again, taking that same grandma, maybe she had been substantiated in the past for leaving children, a 4-year-old alone for 24 hours. We're talking about youth 16 and older. So like you could leave an 18-year-old alone for probably far longer than 24 hours, but the agency wants to take that responsibility seriously and not just say, well, you have a record from 1992, but really get behind what happened and what would be different for this particular kid, especially thinking about their age. There's a lot of protective capacity in planning for youth 16 and older that would be different if we were planning for a 3-year-old who needs all their needs met.
Super helpful. Super helpful. Ms. Jones-Jez, I wanted to come to you. The Youth Records Oversight Act, how might that bill enable your office to do your job, your work? And if you can give some examples of roadblocks that your office have run into trying to do some of your work.
Thank you so much for the question. So yes, we're very excited about this bill. I think it will enhance our work. So I will go back to the crossover youth population, which are youth who are involved with CFSA or have had involvement with CFSA and also have a legal petition filed by the OAG, a juvenile justice petition attached as well. This particular act, because we are open for complaints that are involving youth who, for instance, reside in a DYRS facility. In those instances, if we decide to investigate those complaints, then we would need to be able to do a comprehensive investigation. If there was an event that occurred in a DYRS facility, and that's part of the basis of the complaint, that DYRS is not following through with the law or with their own policy around safety for the youth in their facilities, we would want to have access to the facility itself, quite frankly. But I would say as well, having access to the records would give us an opportunity to see the casework and get a sense of how that child's case has been handled to that point.
And I do know some of the challenges you've experienced as a committee. We're not provided information just to make it clear to people. When we hear about some of these high profile incidents involving youth, my office is at times bombarded with questions, sometimes directly from family members, community members, and I'm learning information from the media because the Office of the Attorney General, CFSA, or others are saying we can't provide juvenile records. And so again, I think the term earlier that was used was these bills are administrative in nature. I would push back strongly on that and say these bills all address very tangible issues that have come up in the line of our committee's work. Ms. Jones-Jazz, in terms of the SOUL Act, you reference lines 228 and 229, pushing to specify the background check. Can you elaborate more on like what you're referencing there and how we could be more specific?
I think my line numbers might be slightly different
Okay.
from yours, but so a belief of our office is to ensure the safety of children and youth. And we love this bill because it gives youth that opportunity to say, these are the people that have looked out for me and will support me. And these individuals will kind of help me, mentor me, and guide me going forward into adulthood. And I'd like for them to be a legal part of my life along with my biological family. I would add to that I think much like we look at other types of placements, if you will, placement options, of adoption would be one, placement or identification of foster parents. We do background checks, or the child welfare system does background checks. I think it'd be important to know the, what the legal background of those individuals who will be providing this ongoing guidance and care for this young person, what that looks like.
Absolutely.
So
And I agree with that. But I also appreciated Ms. Riley's clarification that we wouldn't want to necessarily disqualify someone because they do have a pass.
yes,
Because we do
understand.
believe in rehabilitation. I know I'm out of time. I'm going to ask a quick follow-up, and then I'm going to turn to my colleague if she has any more questions, just for the sake of time. Can you spell out some of the referrals or calls that your office are receiving about youth who are aging out, or any trends that you're noticing that we should keep in mind as we consider the SOUL Act?
So, one of our goals is to really promote our office to young people, so that they know that we are a resource that they can come to if they have a constituent related complaint about whether the child welfare system has followed policy, practice, or the law appropriately. So in terms of reaching out from youth, we have had youth reach out in regards to, for instance, whether, being able to contact their caseworker, having some difficulties in that area. We've had youth reach out for other reasons. There was a particular case in regards to the allowance policy, and they didn't feel like they were receiving the appropriate allowance based on policy. So we're still kind of gathering information from youth on that topic, and I'm hoping that I can provide a more comprehensive response to that question in the future.
Yeah, if you could follow up with trends, I think that would be helpful for both Councilmember Pinto and I as we consider this bill. And last question, I wanted to come back to you, Acting Director Torres-Trice, in terms of the abuse portion of the neglect code. And there's a distinction made, I don't have the bill in front of me, I recall at age 3 for youth under the age of 3 and physical violence. Can you specify how the agency treats referrals related to physical violence, which in some families might be represented as a spanking or a whooping, and how you treat that currently when you receive a call of potential neglect?
Yeah, so yes, we currently assess physical violence by, again, seeing the child outside of the care and eyes of the parent first. So if there is an allegation of spanking or abuse or physical violence, we do need to see the child. So we do go into the home or wherever the child is at and look at the child from top to bottom.
So let's say there's a toddler, they have welts over their body because they did in fact receive a spanking. Grandma sees the kid as a concern, call CFSA.
Mhm. We go into the home and we say, we have this allegation that you are physically abusing your child. We ask to see the child. If there are welts present, we need to understand what happened from the parent's perspective.
And the parent says, yep, I spanked my kid, that's my right. I have to teach them not to do that.
Mhm. Then we, depending on the age, talk about age-appropriate discipline. If they are physically abused to the point that we feel that we need to separate them, we will do that. But if there's welts from spanking, we will talk about the age-appropriate discipline. We will talk about protective capacities, individuals in their life who they may be able to turn to instead of spanking their child.
But would that necessarily constitute a removal?
Not necessarily, no.
Okay. This legislation draws a line in the sand for youth under the age of 3.
Mhm.
And that's controversial,
Mhm.
but it defines physical violence. So you would not be able to spank a kid under the age of 3. Now, I'm someone, I don't believe in physical violence to youth. I don't think I ever received a spanking in my life, and I turned out okay, I think. Anyway, I digress. Does the agency have any concerns around us putting in the code an age range that essentially says you cannot physically harm, touch, discipline a young person under a certain age?
Of course, we do not believe that children should be harmed, disciplined, but there are some concerns with putting an age limit to it, yes. A 3-year-old can't talk, and so of course, I think that increases our responsibility to assess the home further. Again, I do understand why that line was drawn. We don't currently have an age range, so I do understand why that line was drawn, and 3-year-olds can't talk typically and can't speak to what's going on.
Okay. I think that's important to get on the record. We do not want to separate families.
Yes.
At the same time, the mission and the charge is to keep young people safe.
Agreed.
And physical neglect and abuse is a very serious issue for all of our young people. I'm going to stop there. Chairperson Pinto, do you have any more questions?
I just have a couple follow-ups, and I actually want to ask about this conversation, because what I just heard you say is we have a concern about a line in the sand because it would increase our responsibility to go into the home and further investigate. Why is that a problem?
Not that it would increase our responsibility. We are here to investigate abuse and neglect, but believe that families do belong together. And it's if we, let's just say, received a call from a parent who continues to abuse their child, that's a problem versus we receive one call, there are welts. We are able to coach the parent, teach the parent that this is not appropriate. You should not be spanking your child. There are other ways, and we don't receive subsequent calls. That's the outcome we want. We, though, would look at it differently if we continue to receive calls. So it is not that we have to increase our responsibilities. That's what we're here for. We are here to investigate abuse and neglect.
But I mean, spanking is unlikely to leave a welt, right? I mean, when we're talking about signs of physical abuse, it's more like bruising or burns or something like that. So I don't want to go down too much the conversation around the spanking example, because like the signs of physical abuse, even if that happened one time to a baby, I mean, I guess what is the concern about having a line in the sand with that age, if it's not the increased responsibility for something that is so egregious?
I think that anytime you put an age or you draw a line in the sand, you can't consider other factors.
Okay. I'm going to get into this a little bit more with OAG, but can you describe a little bit the different rights and responsibilities and roles as you see them for parents, supporters, and caregivers?
Parents are responsible for the overall health, wellness of their children. Supporters support the parents in their role, the village. I see them as the village. And caregivers are people who provide direct care.
But how do you see the distinction of the rights versus responsibilities that those
As it
caregivers
relates
have?
to SOUL?
Yes.
Yes. So parents are still, as Deputy Riley said, still may have their rights intact at times and can currently, how it is set up, if a parent has their rights intact, they still are able to make decisions for their children in our current system. But with SOUL, we would not have to move. They would still be part of their case. Their child wouldn't have to choose.
Okay. Well, I know we have a lot of witnesses to turn to. We'll stop there for this panel, but I appreciate the discussion. I feel like it has almost shifted my feeling of urgency about some of these issues. And I just want to go back to this faucet example, because it's really distressing me that I completely understand the compassion that we all want to provide and the great serious resource challenges that so many of our families have. But taken to its logical end, we cannot be a city that is saying, if you're a child whose parents have resources, that means neglect. And if you're a child whose parents do not, you're not neglected. That cannot be the city that we live in, because our children deserve more than that. And so that is just most on my mind right now, to keep pushing towards figuring out how we address that in a serious way. So thank you all very much. And thank you, Chairman Parker.
Thank you.
Thank you. And that's going to conclude our questions for these government witnesses. And I think we are doing okay on time, Director. So I'm going to call next our friends from the Office of the Attorney General, Emily Petrino, the Deputy Attorney General of the Family Services Division, for the Office of the Attorney General, and Aaron Cullen, the First Deputy Attorney General for the Office of the Attorney General. It's great to see you all again. I'm going to ask you all to raise your right hand. Stand and raise your right hand. Awesome. And do you affirm that the testimony you're about to provide is the truth and the whole truth? And if you can speak audibly?
Yes.
Awesome. Thank you. And with that, I'm going to ask Ms. Petrino to go first in your testimony.
Thank you. Good morning, Chairperson Parker and Chairperson Pinto. My name is Emily Petrino, and I am the Deputy Attorney General for the Family Services Division of the Office of the Attorney General. I'm joined by my colleague, Aaron Cullen, the First Deputy Attorney General, who will assist me in answering questions today. We're grateful for the opportunity to testify on behalf of OAG on 6 of the bills in the Care for Youth package. OAG strongly supports B 260399, Support Opportunity Unity Legal Relationships, the SOUL Amendment Act of 2025, and applauds Chairperson Parker for advancing this legislation crafted for and by young people. While we support the goals of B 260401, the Youth Records Transparency and Oversight Amendment Act of 2025, and B 260400, the Statutory Neglect Amendment Act of 2025, we have identified several provisions that could be further clarified and enhanced in these bills. As the Deputy Attorney General for FSD, I oversee attorneys that represent the district in cases of child abuse and neglect, working to ensure the safety and well-being of the district's children. The bills before the committees today cover both the abuse and neglect system and the juvenile delinquency system. And while FSD handles abuse and neglect cases, our Public Safety Division, oversees juvenile matters. However, I will be testifying to both. OAG strongly supports SOL. We again thank Chairperson Parker for introducing this legislation, and we urge Council to advance this legislation with two recommendations that we believe more closely align the text with the intent of the young people who developed the proposal. Retain the term sole family and eliminate the term incumbent rights holder. Today, 50 to 60% of older youth in foster care age out of the system instead of exiting to a stable and permanent home. Youth aging out of care lack the familial and social supports necessary to navigate transitioning to adulthood. Thank you. Putting them at risk of joblessness, housing instability, and other difficulties. Stability in adolescence is a critical component that leads to stability in adulthood. The system current options are not working, and we need SOL and an alternative path for young people aging out of care. For B 26-400, OAG appreciates Chairperson Parker's effort to update the district's definitions of neglect and to clarify that conditions of poverty alone do not constitute neglect. Families must not be separated solely because of economic status. I first want to clarify current practice around this issue. We are already required to demonstrate that the neglect is not solely due to a lack of a parent's not solely due to the parent's lack of financial means. But the bill proposes, and we support, strengthening that financial means test. If the bill passes, we will have to show more than a parent's eligibility for or receipt of public benefits in order to establish that neglect is not solely due to a lack of financial means. This increases our burden, and we support it. When poverty is conflated with neglect, there's a greater risk of unnecessary and traumatic family separations, increased systemic and racial bias, and hindrance to effective intervention. The proposed language contained in our written testimony reinforces this principle and ensures that families receiving public benefits are not unfairly stigmatized or subjected to unnecessary child welfare investigations. We urge the Council to adopt the language that explicitly affirms that poverty is not neglect. We also recommend removing the clause demonstrated by reasonable efforts by the Child and Family Services Agency pursuant to section 4-1301-09A from the proposed definition of neglect under 162301-9A2. Under current DC law, CFSA is required to make reasonable efforts to prevent or eliminate the need for removal of a child unless doing so would place the child at risk of harm, and to preserve and reunify families. CFSA's current obligation applies regardless of the type of abuse or neglect alleged and is separate from the determination of whether a child has been neglected. Incorporating the reasonable efforts requirement into the definition of neglect blurs the line between the neglect determination and the removal decision. And this conflation risks confusing the legal standards and could improperly shift the focus of the court's inquiry. Next, we recommend reinstating a revised version of section 162301-9A3 into the statutory definitions. While OAG agrees that the condition of the child is the appropriate focus in determining whether government intervention is warranted, we also recognize that there are instances where the parent's substance use or mental health may have a direct and adverse impact on the child's well-being. In such cases, it is essential that the law provide a clear basis for intervention when there is a demonstrable nexus between the parent's condition and harm or risk of harm to the child. We propose edits in our written testimony that maintain the appropriate focus of the child's condition while ensuring the law remains responsive to serious and foreseeable risks. It also affirms the government intervention must be grounded in evidence of harm or risk of harm, not merely in a parent's diagnosis or behavior. Next, we recommend striking section 162301-23A4, which lists exposure to domestic violence as one instance in which a child could be considered abused. Eliminating this provision would not impact OAG's ability to prosecute these cases, but it would allow for us to continue to be thoughtful when one parent is a victim or survivor of domestic violence themselves. We have 3 additional proposed amendments to reflect current practice, and these are included in our written submission. But I want to take a moment to touch on some of the information shared by the previous panel. Abandonment is currently defined in multiple parts of our code. It's defined as 10 days if a child is left at a hospital and 4 months in other circumstances. The current proposal simplifies that definition and combines both timeframes into one definition, which we strongly support. For B-26-401, we agree that council may need to access additional information than that which is publicly available to legislate effectively and conduct robust oversight. The district's juvenile confidentiality laws are stringent, recognizing the critical need to safeguard the sensitive information of vulnerable underage youth and their families. Further, these juvenile confidentiality protections cover both delinquency and neglect proceedings, so any change would affect access to both delinquency and neglect case records. We have concerns that the legislation as drafted is overly broad and that it grants full access to juvenile case records and the social files. We look forward to partnering with council to strike the right balance between safeguarding sensitive information and ensuring that our legislative body can nimbly respond as issues arise, develop legislation based on data, and provide oversight of agencies. In addition, as both committees consider amending the juvenile confidentiality provisions, OAG has a technical amendment that we would like to include during markup, and we'll share this language after the hearing. Finally, OAG supports B-26-407, especially its efforts to promote transparency and address overcrowding at the Youth Services Center. We're concerned about the definition of recidivism, primarily that OAG should not be the sole source to supply the data, and that the language used is broad and not reflective of common measures such as arrest or papering. These concerns are laid out in detail in our written testimony, and we look forward to working with the committees to draft a definition that addresses these issues. In sum, we are grateful to both committees to testify on these important issues. We look forward to partnering to advance legislative changes that benefit all district residents, and we're available to answer any questions.
Thank you for your testimony.
Ms. Petrino's testimony covers both of ours, so I'm here to do Q&A.
Oh, brilliant.
We
Brilliant.
split the bills up.
Brilliant. Brilliant. No, thank you. There's so much to cover. Let's start with statutory neglect. There's a part of the bill that would subject parents to a neglect finding if there is a finding of domestic violence, if the parents are not trying to rectify the situation. It sounds like through your testimony, you're taking issue with that. Can you elaborate?
Yes, so currently, so that's the current standard. So we are able to prosecute cases alleging that a child has actually been abused if they've been exposed to domestic violence, and neither parent has taken reasonable efforts to prevent that infliction of harm. It's actually considered a mental injury under the current law. We at one point supported the idea of codifying that case law, making it clearer to parents that this is considered abuse and putting it in the statute. In doing some further research, discussing with our partners in the community, different advocates, we understand now that including that language in the code, while the intention of that we believe is appropriate, would actually be setting us backwards on that issue. So taking it out of the code doesn't mean that we could no longer prosecute it and keep those kids safe, but it does mean that we would have more discretion to consider the circumstances of the domestic violence. Is one of the parents the survivor or the victim of the domestic violence? And are there ways we can be thoughtful about handling those cases that also are informed of how the parent is the victim themselves?
And when I hear discretion, I hear we get to determine in some instances a parent is the victim of domestic violence and is not trying to resolve the exposure of the child or the young person to said violence and still leave that young person with that family. That's what I hear when I hear discretion, that you may choose at times that this doesn't warrant removing the kid from that environment. Is that fair?
I understand that it could be interpreted that way. I think it is perhaps a fair interpretation, but a bit more complex. Any definition of abuse or neglect that we currently have doesn't necessarily. Oh, I'm sorry. Sorry.
No,
Not
yeah.
this chair. Our current definitions of neglect, just because a parent is found to have neglected their child, just because they're substantiated for neglect, doesn't mean that their child is necessarily going to be removed. So regardless of the definition of neglect, just because you're found to have been neglectful doesn't guarantee that the child has been removed. That is a separate inquiry or separate part of the process. And
Yes.
not all substantiations come to the Office of the Attorney General. Not everything is court involved. I think what putting this language in the statute in terms of the domestic violence does is sort of create a bright line for instances of domestic violence. It makes it very explicit that exposure to domestic violence alone is abuse or neglect, and doesn't give us the ability to assess what protective capacities that survivor parent has. Maybe we're not wanting to remove because the victim parent has moved to a new home and no longer lives with the abusive parent. Maybe the protective parent has put their own protections in place. If they share a child in common, maybe they've worked out a schedule so that that parent can see the child that doesn't involve the victim parent having to be present for those interactions. There are other safety precautions that victim parents can put in place to protect themselves and their children, and we just want to ensure the law honors that.
Okay. Just for clarification, what I'm hearing you say is the current practice is what we're codifying. It's not that a young person only being exposed to domestic violence would warrant a neglect finding, but that the parent is also not trying to rectify the situation. So it's two parts. You're exposed and the parent is not trying to get away or solve the problem. I also hear and take to heart what you're saying. The rigidity of having it in the code limits, I guess, or ties the hand of the Office of the Attorney General potentially during these proceedings. I will commit to looking at that with Councilmember Pinto. It does give me pause though, because again, what I'm hearing is, well, there's sometimes we may want to leave the kid in that environment, and I think that's harmful. I do want to move on.
Can I just say one more thing?
Yes.
I would like to perhaps reframe your perspective that it's not leaving the child in that home. It might be leaving that child with the victim parent who can protect the child, rather than taking them from their victim parent, the survivor parent, and placing them with strangers.
Yes. We don't want to separate kids from their families.
Right.
What I'm arguing is that what the bill says is that if the victim parent is exposing willingly or unwillingly a child to domestic violence and not trying to rectify the situation, in other words, I am the victim of domestic violence, my child sees this day in and day out, and I'm not taking steps to seek safety for my kid. That is what the bill is saying. It is not just simply saying you're the victim of domestic violence and now you lose your kid.
So to that extent, I think the bill could be clearer, and I think the advocates from Children's Law Center will probably explain or suggest some explicit language that could be put back into the bill to make that piece clearer.
Understood. Okay. It is my understanding that the Office of the Attorney General does not support the carve out for cannabis in the existing neglect code.
The Office of the Attorney General's current position is to maintain the status quo as your bill has drafted.
Yep. And can you just elaborate on what is the status quo? And I'm happy to talk more about what some advocates would want us to change the code to as it relates to cannabis use.
Sure. So the current status quo is that hospitals are supposed to call when a child tests positive for any illicit substance at birth. We know that not every hospital calls and not every hospital calls every time or tests every child that's born in the District of Columbia. And to that extent, we would like to work with your office on trying to resolve that if there is some way to increase those protections and limit those disparities. Taking it one step further, a positive tox is how we refer to it, is not enough alone to be substantiated for neglect. There must be something more than that. And that language specifying that is in a different part of the code. So for example, our office, OAG, could not petition a neglect case based solely on the fact that a child tested positive for something at birth. It would have to be more than that. It would have to be, and the parent has ongoing substance use issues that adversely impact their ability to care for the child or other things.
And what advocates wanted or petitioned the committee to do was to essentially carve out cannabis use, to say if a mom and a child test positive for cannabis, that cannot be inclusive of any neglect findings. As we did our research, the research is mixed and inconclusive at best.
Right.
What I was wanting to know is that actually harmful for the kid? And there's some research that says, yes, cannabis use by a mom during pregnancy is harmful. There's other research that says it's not. And so the reason why the committee opted not to make any changes there is because the research just doesn't support it.
Right. And we support that.
Yep. Okay. I'm running out of time. Still on the neglect statute, how will the proposed updates in the bill, notwithstanding the list of changes you have, impact OAG's work in the neglect space?
I think ultimately what the changes to the bill, what the changes in the bill will do is make our practice clearer. We appreciate the confusion around the definition of abandonment, the fact that you have to look in 23019A and then also in 162316 to determine what is abandonment causes unnecessary confusion. And we think bringing all of that into the definitions of neglect and splitting abandonment from abuse will be helpful. We believe that the most important thing I think about the bill is the explicit language regarding poverty not equating neglect. We've heard the advocacy community on that. We already incorporate it into our practice, as does CFSA, but we think it's important to be explicit about that so that it can be ensured that that practice continues regardless of who is in our seats in the future.
Yep. And I do support the inclusion of the affirmative inclusion of poverty is not neglect. And we'll take that into consideration.
Thank you.
Before I move to any other bills that you testified on, I'm going to turn to my colleague for a round of questions, and then I'll come back. So with that, Councilmember Pinto.
Great. Thank you. Thank you both for being here. So nice to see you. So I want to pick up there around the neglect definitions, because I appreciate your clarification that just because someone has been designated as or neglect being determined doesn't necessarily mean it's going to enter the court process. And so as you think about the current gaps in the law for neglect, where would you like to see those gaps filled?
Specifically pertaining to the definitions.
Yes.
Yes, I again would reiterate the importance of clarifying different provisions. Splitting abuse from abandonment, I think, is important. I also think what the bill proposes regarding explaining some examples of what constitutes physical abuse is important. Our current statute doesn't do that. Right now, it explains what is not discipline. I know there was testimony earlier about the physical discipline or the physical violence of children under the age of 3. And I just want to note that currently physical discipline is prohibited for children under the age of 18 months. So this bill did increase that age, which we support. I also think it's important that we codify some of our case law. The provision 1623.019A2, which is sort of what we refer to as general neglect, requires a risk of harm requires harm itself or substantial risk of harm. And so I appreciate the bill adding that language to the law itself, making it clearer. I know that the current bill takes out what is the current 3, the mental and physical incapacity, and we're asking to put that back in. But the language we provided updates it to include that same explicit language about the harm or substantial risk of harm, because we do think it's important to focus on the condition of the child and not just the status of the parent, because the condition of the child is what brings the case to court. Our court is very remedial. It's not meant to be punitive to the parents. And so maintaining that focus is important. And one thing I'll add is that we worked very closely with the Children's Law Center, but we also worked very closely with parents' attorneys, the attorneys who actually represent parents in our neglect proceedings, when discussing these changes. And they pointed out the difficulty that they sometimes have in explaining what the law is to their clients who are being accused of these things. And we do think that Councilmember Parker's proposal does make the law much clearer and will be beneficial to the parents as well.
Okay. What is the mission of the Family Services Division?
Oh, that is a great question.
Thank
I could
you.
talk about it for longer than 7 minutes and 12 seconds. The mission of the Family Services Division is to represent the district and CFSA, largely in abuse or neglect cases, and really to help children and families in the District of Columbia to ameliorate the conditions of neglect that bring families and children, across our desk. The neglect world is a special one. There's not a lot of us in this division. It's quite confidential, as we've seen from the records bill. And our division works very closely, again, with the Children's Law Center, with our opposing counsel, to ensure that we are handling these cases in a way that addresses the needs of the child and ensures the child's safety, but also is very cognizant of the circumstances of the parents who are involved in our cases. Some of the things that Ms. Riley spoke to earlier, we're very mindful of and try to ensure in our practice that we're eliminating bias and we're treating everyone fairly under the law, and working to keep kids in their homes, or if they have to come out of their homes, to get them back in their homes. And then, of course, if unfortunately they're not able to go back, we continue to work until they have a permanent home. I think that's one of the unique things about our division. Our job doesn't end once a parent is found to have been neglectful or a child is found to have been neglected. We at the Office of the Attorney General stay on those cases, and we work for the next year or 2 to get that child home or in another permanent arrangement.
Okay, so that is a big mission.
It is.
And how do you advise the attorneys in this division about how to weigh the immediate safety concerns of a child versus all of that around the amelioration mission to
Sure.
address the underlying challenges?
Sure. So a lot of that work is done very closely with our client agency. We are co-located in the same building. We spend a lot of time on co-training, learning the clinical side of things, so we are not the clinicians ourselves. We have honest conversations about the work that the agency did or didn't do prior to a child coming into foster care. And we have honest conversations about what we should expect of parents going forward in order to have their children's returned home. I think it's very important to keep the standard that we aren't looking for perfection. There are no perfect parents, right? We're looking for parents who can keep their kids safe and have appropriate parenting techniques. And it's the government's responsibility to help them, achieve those goals if they aren't able to do it on themselves. And we spend a lot of time in court talking about what the agency has or hasn't done, and whether the child is safe and what safety risks still remain if we are considering sending the child back home.
Okay, and when you say it's the government's responsibility, it's always of interest to me to figure out kind of who plays what role in which lane.
Mm-hmm.
And so as the prosecutor's office, like where does that role come in versus the responsibility of CFSA versus a court versus what we are not just asking of our parents, but expecting and really demanding of our parents in order to advance their children's safety?
Mm-hmm. I would say that sometimes the lines are a little bit blurred. But generally speaking, it's the agency's responsibility to assess a parent, assess what their needs are in order to keep their child safe, assess what services are available to them, work with them on obtaining those services. Then it's the parent's responsibility to engage in those services, to learn from them and demonstrate changed behaviors. It's our responsibility as the Office of the Attorney General to ensure that CFSA is providing those services. By providing, I mean identifying and referring the parent. If it's not a service, the agency provides itself. And, you know, we have court hearings. We're supposed to have them every 6 months. Most judges bring us back in every 3 or 4 months. And at every single one of those hearings, we're outlining in a court report that the social worker previously filed what the agency did in the last 3 months to help this parent reunify. We're outlining what the parent has or hasn't done in terms of progress towards those goals. And then the court and the guardians ad litem, the parents' attorneys are holding the entire government accountable in those hearings and arguing whether we have or haven't, whether the agency has or hasn't done that due diligence of reasonable efforts to reunify. Reasonable efforts is a term of art in our world, and it's one that is considered at every stage of the process.
Okay, thank you very much for that. And I want to follow up with you around truancy from our last conversation with the last panel. How many truancy cases have you prosecuted in the last year?
In terms of the data that the Office of the Attorney General keeps, it's hard in the neglect system because there's up to 11 allegations of neglect that we can petition in any one case. And so often we petition multiple allegations. I do believe in CFSA's oversight data that they provided back in February. It will say how many calls they got for educational neglect. We are trying to drill down in a more comprehensive way how many cases we see exclusive to educational neglect to help inform counsel in that regard. Often when we see educational neglect, it's coupled with another behavior issue of the parent, whether it's mental health, substance abuse, etc. And so it's difficult to separate those two out.
Okay, understand. But from a prosecutorial perspective, how many educational neglect cases have you all brought?
I cannot give you that data right now. We can try and see. I believe I'm going to defer to Ms. Petrino because she has some numbers with her.
Okay,
Yes, so educational neglect, the way it's currently defined in the code is part of that general neglect provision. It's 162301(9)(a)(2). So I can tell you that an overwhelming majority of our cases involve that allegation, which includes the lack of education or subsistence or control. So it's the general neglect provision. We can work to drill down on those numbers and determine what is exactly educational neglect versus the other forms that fall under that number.
okay, thank you. I would be very interested in that number, not just in the allegations that have been brought, but in the actual cases you all have brought.
Yes, that would be the number we can provide.
Yeah, okay, thank you. I want to talk a little, oh, I'm kind of out of time. It's time really ticks down. Okay, thank you both.
I want to pick up there on educational neglect. I'm glad you're picking up on this. I think the answer is there haven't been any findings of educational neglect. And I think for context, it's important to remind folks last year, I believe, or maybe it's 2 years ago at this point, I introduced a bill that tried to define what educational neglect was. And I thought it was pretty lax. It essentially said 30 missed days of school that are unexcused, where the parent is not trying to rectify the situation and get the kid in school, constitutes educational neglect, and all hell broke loose. Advocates, I think the OAG opposed it, CFSA opposed it. And I am still struggling with the fact that we say we have a truancy problem, we invest so much money in our schools, yet everyone's very squishy about holding parents accountable to ensuring their kids show up to school. I'm just going to say that for the record. Feel free to weigh in. We're old friends and we go back and forth.
Of course.
But yeah, your thoughts.
We've talked about this on more than one occasion and definitely could continue to talk about it. A couple clarifying points I would like to make. First is the standard which CFSA uses at the hotline to determine whether they will screen in or screen out. I will let the agency speak to that. What you are asking is what
And
it,
if I could just interject for
course.
those that are watching that, and I'm not sure where the feedback is coming, if you could just.
Sorry.
CFSA receives calls for young people under the age of 13. I wasn't going to even go here, but since we're going here, they receive calls for educational neglect referrals, namely from our schools for young people under the age of 13. They screen in or screen out. To screen in means they are going to investigate the family. What we know is that the vast majority, I want to say over 7,000 referrals have come in over the last year or to date. And I think 98% of those calls have been screened out because CFSA would argue that it doesn't rise to the statutory definition of educational neglect, which we don't quite have. Okay, keep going.
Excellent. And so you have that pool to begin with, which then CFSA makes its own determination. So then you have a smaller pool that then comes to the Office of the Attorney General. We do file petitions on educational neglect and do have adjudications in the family court based on educational neglect. Those are the numbers. I think if we quoted you a number, it would be that all encompassing subsection 2. What we're going to try to do is drill down exactly of the subsection 2, how many were on educational neglect. And the only other quick thing I'll add is it was 3 years ago, I believe, the council very generously granted our request to add another section to the Family Services Division, which is CPS 5, which is actually working more in the in-home population. And one of the things they are focused on is getting the cases of educational neglect brought to our attention sooner in the process, because we want to be able to do that intervention at the court level if we need to.
Would you agree that educational neglect is not clearly defined in our code?
I would agree that a per se definition of any definition of neglect could actually cause more harm.
That was such a lawyer.
Lawyer
Yes,
answer.
that was such a lawyer answer. Okay, let me get back to my line of questioning. Let's go to the SOUL Act.
Yes, please.
One of the points of feedback provided is that you want us to refer back to the SOUL family.
We do.
So for context, this legislation was crafted by and with foster youth, and the SOUL Act made reference repeatedly to the SOUL family. And I'm fine with that, but there was ambiguity about what SOUL family actually meant. The committee's attempt to change the language was to provide a level of clarity that we're actually talking about the support family structure. I hear the testimony loud and clear, and I have a feeling we're going to hear this testimony a lot today, so I get it. What I wanted to ask about was the second critique provided, that originally the language in the bill spoke to birth parents and the rights of birth parents, and it was changed to incumbent rights holder in an effort to be more inclusive because not all birth parents have family obligations. Maybe it's a grandmother, maybe it's another family member that's not quite the birth parent. And that's what we were trying to get at. Can you speak to why you're advocating that it go back to the term birth parent?
Absolutely. And we'll acknowledge that this is a very difficult part of the SOUL legislation to really narrow down to what is the most appropriate way to handle it in the law. For example, we took a lot of information from Kansas and what they struggled with, and we thought it was best in the district, and I'm sure you'll hear this from our colleagues at the Children's Law Center who co-led the legislation work group, that we wanted to look at what was already in the statute here in the district. And so we relied a lot on how legal guardianship is already handled. And so we started with that sort of as our central point, and that differentiates, as does legal custody, the rights that stay with the birth parent and the rights that go to the third party, whomever that may be. In the SOUL legislation, because we're putting it at age 16 is the earliest age one can exit care to SOUL, you have that population from 16 to 18 that you need to be very specific and very clear about, since the youth is still a minor. And so that's where you really have to designate what does the birth parent retain, similar to in like legal guardianship, and what goes to all the people in the sole family. And in that category, you have someone who's providing housing. Okay, well, they might have more rights or need more rights. Then you have someone who's going to handle education, someone who might handle medical. And we just felt that introducing a whole new term that we don't already use in our system would actually confuse instead of clarify. And so our intent, and happy to work with the committee on what the best language is just to really differentiate who in the group gets what right, particularly for the 16 to 18 population.
I'm persuaded by that.
Thank you.
I thought that was really,
Thank you.
you won me over. So I'm happy to
But
make that change.
I did my job today.
Yes, yes. Outside of those two areas with the SOLE Act, are there any other concerns that the Office of the Attorney General has with the legislation?
My understanding, I think, is with Children's Law Center, we have provided some additional red line edits, but overall, I think as it's written really gets to the heart of what we're trying to achieve and really hope that council will be able to pass this as expeditiously as possible. You're going to be very moved when you hear the testimony of the lived experts.
Yes.
And so really proud to support them in that endeavor.
Love it. Love it. Thank you. I wanted to move to the Youth Records Transparency Act. For context, there have been instances, high-profile cases that many people probably know about, where I've gone to MPD to say, what is going on with this case involving this young person? MPD will say, we can't tell you. We can't tell you any more than what the media is already reporting. Go ask OAG. Then I come to OAG, and what the issue is our very strict juvenile or access to juvenile records. Just for the record again, and I know you spoke to this, but would you agree that the committee should have access to juvenile records as it relates to our juvenile delinquency system?
We definitely agree that the committee in some capacity needs access to information. We completely acknowledge the place that it puts you in without being able to do your job because you don't have access to that. We are just inherently cautious about who gets access to the information. As Ms. Petrino outlined in our opening statement, you could start in the neglect system. That social file follows you into the juvenile delinquency system. The neglect system could be about me and my 5 siblings, and you want information in the delinquency system just about one person. So I think with the right guardrails in place, we absolutely can reach an agreement on the council getting access.
And can you distinguish the social file
Sure.
from one's criminal record file, if
Sure.
that makes sense?
Absolutely. So Title 16 talks about law enforcement records, it talks about the legal file, and it talks about the social file. There's also going to be reference to CFSA's file, which is codified in Title 4. So there's a lot of different places and different components of what could actually end up in a child's record. For example, in the legal record, you're going to get the neglect petition, the delinquency petition, motions, pleadings, court orders. In the social file, you're going to get evaluations from DBH, DCPS, from the agency if they've done their own assessment, both DYRS and CFSA. So a lot of the clinical social information is in the social file. The court proceedings are in the legal file. Both of those are spoken to in Title 16.
And when you say some guardrails, you would support the committee having access. Do you want to speak to what those guardrails should be now, or?
I think if we could have a conversation after the hearing about that, absolutely. But I think fundamentally know that you need to have access in some shape or fashion.
Got it.
Yep.
And for the record, I don't need a young person's entire file.
Right.
That is not the
Yeah.
goal, but it is important for the committee to do oversight. And
Absolutely.
and this has been a barrier. And we heard from also the Ombudsman for Children that it's been a barrier for them as well.
Right. And if I could say 2 quick things on that. One, for the ombuds, definitely agree in their ability to identify crossover youth that they need access. They currently have access to CFSA information, but they don't have access on the juvenile side. And second, we alluded to this in our written testimony, but even within the Office of the Attorney General, we have challenges with the confidentiality. For example, the code speaks to those assigned to the Family Division, which is Family Services, Public Safety, Child Support. But when our Civil Litigation Division goes to defend the district, they're not considered an assistant within the Family Division. And so we're also going to ask for a modification to the code to allow our Civil Litigation Division to have access to do their job as well.
Okay, I'm gonna stop there for time. I'm gonna turn it to Councilmember Pinto for another round of questions.
Great, thank you. I just want to raise the survivor parent issue, because we've talked to several advocates who've raised concerns around the definition of neglected child, that there's no provision specifying that a failure to seek a civil protection order is not dispositive of a failure to protect a child from abuse. And as we've seen, in certain cases, that seeking a CPO can directly incite violence against survivors by the abusers. And so I understand that concern of not wanting that to be dispositive. So I just wanted to re-raise that if you have any thoughts on those particular cases.
Yes. So currently, the way the definition of abuse is defined, it includes that language, which intended to provide just one example of how a parent can make reasonable efforts in that way, and obtaining a civil protection order being one of them. What we have found is that it has sort of been misinterpreted in that the expectation is that that survivor parent will go or is required to go get a civil protection order in order for CFSA to not substantiate them or for their child to not be removed. And that was certainly, we don't believe, the original intent of that. So I think the bill takes that language out entirely. So I think that taking it out entirely gets at the same, has the same effect as putting that language back in, but certainly wouldn't oppose that language going back in. And in fact, I think if council is to leave the exposure to domestic violence in the definition of abuse, then I do think in that instance, that language must come back in, or it's going to be sort of a per se definition that just because you're exposed, you are therefore neglected, regardless of what, if anything, was done to protect that child.
Okay. Thank you very much for that. Moving to the transparency and privacy issues, just at a high level, can you explain kind of where OAG's position is around youth privacy, to protect the young person versus what I hope you can understand our interest is in understanding the data so that we can drive forward policy that's going to be most impactful?
Absolutely. And I think that's a great way to frame it, is there's the individual person's history, record, information versus how that factors into a larger data portfolio. And I think the larger data portfolio is where we get, obviously through the Criminal Justice Coordinating Council, which we're a part of, is how we can look at the system and say, are we doing the right thing? Are we putting our resources in the right place? Are our laws legislating what we need to legislate to keep the community safe? And so from informing overall data, absolutely, that is crucial for all of our agencies and all of our entities for oversight capacity. I think the nervousness we have is with the individual's record being given to multiple people and the context not following it. I think if you looked, for us, even in our job, you were asking earlier about the Family Services Division, and we can read a court report and come to a whole conclusion of a family. Then I sit down and I talk to the social worker, and they add so much more of a perspective that's not captured in the written word. And I think we're just making sure that for the individual person's experience, nothing is taken out of context, and nothing is given to anybody who should not have access. You, of course, need some form of access to do your job, and that's not something we have a problem with. I think it's that individual identifying information being put out into the general atmosphere that we have concerns with.
Yeah. I guess you can never really divorce the need to have more context from any data set,
Mhm.
whether you're dealing with an adult population on any issue. And so, like, I appreciate that that context is important for justice and to make sure that each case is handled with care. But from a data perspective, like, there's never going to be a perfect contextual environment to understand each piece of data,
Yeah.
right?
And I would say the bigger issue I have seen in this current role with data is that we have so many agencies putting their data into one system or hopefully into one system that we are then being able to say, okay, this in the District of Columbia is where we fall on this issue or that issue. And I think the data validity, I am certainly not a data scientist and probably not the best person to speak to that methodology. But I do think that having access to that for overall data lessons is crucial to the work that we all do.
Okay. And, you mentioned the CJCC and the work we do there, but I mean, to be honest, it has also been difficult getting data from OAG for that purpose, even in an extremely controlled environment with principles in the public safety ecosystem.
Yes, no, and I understand that. I think a couple things can go to that. I think first of all is where we fall in the system and what data is exclusively ours and what data is part of the court system, for example, or in relation to our data with the Metropolitan Police Department, for example. And I think the other thing that you might be speaking to kind of gets to our hesitancy and our skittishness is with not releasing individual records on 10 or fewer or not, which I know in oversight has been discussed with the Attorney General. I think that we as a system need to continue to examine and evolve in terms of who needs access to what to make sure we're doing our job correctly.
Okay. And, I was moved listening to Chairman Parker talk about getting some information through the press as opposed to through our own work. And in the juvenile privacy space, I mean, there have been multiple instances where everyone in a particular community knows the young person we're talking about because the incident might have happened at school or down the street and everybody in the neighborhood saw it. And so we're continue to have these conversations about like no personal identifying information. And I totally understand in order to protect the young person's future, we want to be really careful about that. At the same time, in practice, it's a little bit of an odd experience when like people in a particular community know what happened, saw what happened, but we can't get any information. Not even, I don't need the person's name or all those things, but there is an imbalance, I think.
Yeah, yes, and we were actually having this conversation with Councilmember Parker's staff yesterday about so you hear something in the ward that you serve and or a constituent comes to you and you want to be able to know more about it. I think the two things are how can we get you that information as quickly as possible and in a way that adheres to the confidentiality standards. And also number two, obviously the restrictions it then puts on you as to who you can share that information with. And I think the intent of what we're hearing from both of your offices and absolutely open to working with you on that is you have to be responsive to the people that you serve. And that requires you to have access to information.
Okay, thank you. And I, appreciate that commitment. I will say I have been on the council for 5.5 years now, and we have been having this conversation with OAG for 5.5 years of this issue around privacy. And so it feels as though something new needs to happen in order to, I always appreciate the conversation and the partnership. But this issue has not advanced in a serious way in that time. And so that's, as we think about other legislative recourse, that's part of where we're coming from too.
Sure. And having only been in my current role officially since September, I can certainly take that on as a hallmark item.
Thank you very much. Thank you both.
Absolutely.
Okay, a few more questions and then we're going to turn to DYRS. In your testimony, you argue that MPD and the courts, rather than solely OAG, should be responsible for providing juvenile data for tracking recidivism. Can you speak to your reasoning for that?
Sure. I think recidivism is another hard topic because I think it's, we've been asked by the CJCC to define it. I think we've shared our definition that we gave to CJCC with your office as well. I think I'll try to do this as succinctly as possible. MPD makes an arrest. They have an opportunity to divert at the time of the arrest and not even present it to the Office of the Attorney General. Then they can present a charge to the Office of the Attorney General, which we then have to analyze and determine if we have enough to move forward with the case, or for social factors if we're going to divert. So that's putting us at step 2 in the process. Then if we do move forward with a court case, there's then the whole disposition that occurs in the court system. So I think the confusion with trying to determine an actual definition of recidivism is either looking at each individual agency or looking at the life of the system. If you look at the life of the system, we are not the exclusive agency in that spectrum.
Got it. And I remember when your office introduced the Road Act,
Yes.
this came up, and this was a point of tension where the OAG press release, I recall saying there was a 92% rate of recidivism, and then the director from DYRS took issue with that, and the issue was that you all were defining it and looking at it very differently. What we're hoping to do is in statute define how we are looking at it. I hear your point though, depending on what stage and or what purpose you're using the data available might determine how you define recidivism.
Right, exactly. And I think we're all in agreement that we need one central definition of recidivism for all of the criminal justice partners that participate in the larger ecosystem for the district.
And for the record, what was that definition that you provided?
I think it is quite long. I'm not sure if you want me to read all of it
While you pull that up, I will say I remember Director Abed's definition that I was persuaded by, which essentially was that a juvenile in particular is accused of a new crime once out of detention. And I'm probably oversimplifying that, but essentially it was to not conflate charges or incidents that may happen while a young person is in detention. And I thought that was pretty reasonable. But what is the definition that you would recommend?
Yeah, and I think we haven't settled on a singular definition, but the other thing that I would add to what Director Abed said is also, if you want to analyze at what point the intervention occurred, like I was arrested on Monday and I was arrested on Wednesday. There probably wasn't an intervention between Monday and Wednesday. But if I was arrested on Monday and had a whole year of rehabilitation services, and then I was arrested a year later, wouldn't that be different analysis than me being arrested on Monday and Wednesday? I think it's the ability to have services, the engagement with the services, the impact of those services on the young person's conduct have to also be factored into our analysis of recidivism.
Okay, I think I was following.
Yeah, I think it's just not being arrested again and making a conclusion. It's also the looking at the services and the engagement with those services.
Okay, the subtext to this, and I'm wrapping up, the subtext to this is that our rates of recidivism for juveniles is way too high. And so I forget what the director's definition, I think, had recidivism at 50 or 52%. You all's definition had recidivism at 92%. What that is saying to me is, even in the best case scenario, half of young people that are entering our juvenile detention system is coming right back. We have a revolving system. And I believe that's because we're not actually rehabilitating them. That's another conversation for another day. But I think that's important for us to name. Does OAG have the data necessary to fulfill DYRS's mandated reports under this bill? So we are requiring DYRS to publish data that the Office of the Independent Juvenile Facilities Oversight, I probably butchered that, used to report. As you know, that office sunsetted.
Yes.
is there any information that you are working with DRS to publish and that you all have access to?
If I may get back to you on that, I was like phoning a friend while you asked that.
Understood,
I think
understood.
I'll need to get back to you on that.
Okay. I think I've exhausted all my questions. Councilmember Pinto, did you have any others?
I just have one more question. As we are in this moment in our city, where we have federal forces and incursions here, and a uptick in what we're seeing around immigration enforcement and the traumatization that that's causing to many of our families. What are you seeing in terms of, family support or cases that, OAG may be involved with or exposed to? And what efforts do you think we need to be doing more of in the city, to protect our families?
I'm gonna see if Ms. Petrino might have something to say about the neglect system. As I left that position a few months ago, I don't know if we've seen any instances of that specifically in FSD, impact to FSD cases.
I don't think we've seen much impact. I think that there was some impact regarding our unaccompanied refugee minor cases at one point, though I think we're addressing that, or it's picked back up again. But what I would say in terms of keeping families safe, I think the references to the warm line earlier and the whole point of putting in that poverty is not neglect is one way to keep families safe from unnecessary government intervention, encouraging families to take advantage of the community services that we have here in DC, that they can learn about through things like the warm line or the family collaboratives. Minimizing that need for intervention unless there truly is a safety concern, I think is one of the things that helps keep children and families safe in the current state.
Okay, and I guess as I continue to hear from families who might have fear about sending their children to school in this climate,
Sure.
are there other efforts underway from OAG or from CFSA to do outreach to those families to make sure that they have supports they need and that their children can continue to be educated?
I'm sure that there are. I'm not sure if Ms. Cullen might be able to speak to the public safety side.
And I think also on the CFSA side, it would be interesting when you have some of the advocates up later to ask them as well, because I know at the beginning of the school year, there was a lot of effort put into educating families about their rights and about sort of like secondary care plans that they should always have in place, so that there is a family member or a loved one able to step in at any moment, regardless of the circumstances, to take care of a child. So the child doesn't have to come into foster care hypothetically because the parent was arrested or because the parent is no longer available. So I know there was a lot of effort with our community partners in the advocacy world to do that. I don't think on the public safety side, we've seen, I will say on the juvenile side, that we've seen a direct correlation. The Attorney General is very keeping an eye on this, talking to our community engagement department, seeing what we can do in terms of making sure the community has the right information and the access to resources as a result of this issue.
And the last thing I would add is that I think that just underscores the importance of the work that CFSA already does in between the time that a referral is made and determining whether or not neglect exists. And then if it does, if a court case is necessary, allowing parents to articulate or make those plans for the child, for their child's care in instances in which immigration or incarceration could be an issue.
Okay, thank you.
Thank you both.
Thank you. I would just say poverty is not neglect. I fully agree with that. I will, I'm going to use this as a public service announcement that if we take that adage to be true, which I believe it is, it also charges us to address poverty, which is on the rise in the district. And it's especially on the rise for certain residents in the district, namely Black and Brown residents. This council has advanced any number of measures to address poverty. Most recently, we passed and fully funded the child tax credit. It's worth noting that we passed it before, we funded it before, and unfortunately the mayor cut it. And so while I appreciate the mayor's agencies and the Office of the Attorney General joining us and agreeing that poverty is not neglect. I hope you too will stand with us to champion the child tax credit and other measures to address poverty, but also call on the mayor to maintain its funding so that we can extend lifelines to residents across the district, namely Black and Brown families. But thank you for your testimony. With that, we are going to turn to our friends at DYRS. And Director Abed, I know you're on a time crunch, and thank you for being patient with us. If you could raise your right hand and repeat after me, or affirm that the testimony you're about to provide is the truth and only the truth. Okay, awesome. With that, you may provide your testimony.
Good morning, Chairperson. Shoot, it's still morning. Good. Good morning, Chairperson Parker and Chairperson Pinto, members of both committees and all members of the public who are present and watching today. I'm Sam Abbott, Director of the Department of Youth Rehabilitation Services, and thank you for the opportunity to testify. I'm here to speak about proposed legislation that would have a significant impact on DYRS operations. Before I begin, I'd like to thank Mayor Bowser and Deputy Mayor Apia for their inspiring leadership. Mayor Bowser's unwavering focus on public safety reflects her commitment to supporting DYRS's mission, which pairs accountability with meaningful rehabilitation to help youth turn their lives around and become contributing members of society. I also extend my appreciation to the entire DYRS team. Their dedication and resilience are truly commendable, especially given the challenges that we face every day. DYRS shares the Council's commitment to improving outcomes for young people and to maintaining public confidence in our juvenile justice system. Several of these proposals would pose significant operational and fiscal challenges for DYRS. They exceed our current capacity and in some cases could divert resources away from services that matter most to youth, rehabilitation, and public safety. So I'll start with promoting parental engagement at DYRS, the Amendment Act of 2025. DYRS strongly encourages family involvement. It's the foundation of rehabilitation and a vital part of our mission. To that end, we already have systems in place to keep families connected and engaged throughout a young person's commitment. The Promoting Parental Engagement at DYRS Amendment Act wouldn't be difficult to comply with, but the added documentation and reporting requirements would create additional administrative burden. It would require time and resources taken away from actually engaging families. The recently passed Road Act has several meetings that require parental engagement, and there's no need to duplicate that requirement in a standalone bill. The Strengthening Capacity and Transparency at DYRS Amendment Act of 2025. DYRS strongly supports transparency, and much of what this bill requires, we already report publicly on our website. However, this bill extends well beyond what is practical. The new reporting requirements would necessitate at least one additional FTE, and the time needed to produce and verify this data would detract from our small research team's other essential work. I'm also very concerned about how the bill defines recidivism. It is not tied to arrests or adjudications, but instead to decisions by the Attorney General on whether to file charges. That is not a valid measure of youth behavior or DYRS performance. It's a measure of prosecutorial discretion. Using a definition that differs from national standards would also prevent DYRS from comparing our outcomes to those of other jurisdictions, limiting our ability to align with best practices. I urge Council to align with national standards rather than adopt a definition that measures decisions made by the Attorney General. The bill also requires an overcrowding action plan to be implemented within 120 days and caps the Youth Services Center at no more than 90 youth. This is simply not operationally realistic. The population at YSC is determined by daily activity of the District of Columbia's Superior Court Social Services Division and intake decisions beyond DYRS's control. An arbitrary limit on the number of youth who can be housed at YSC is impossible to enforce, since the courts determine by order to the agency who is detained. Additionally, turning away court-ordered youth from detention, if it was possible, poses an unreasonable risk to the safety of the community. I respect the intent behind this bill, but as written, it places DYRS in an untenable position. It overreaches and it could have unintended consequences that weaken rather than strengthen our system. I'll turn to the Safe Pregnancy, Delivery, and Postpartum Care for Youth at DYRS Amendment Act of 2025. This act is a bill that DYRS is aligned with. However, we are opposed to enshrining medical guidance into statute. The state of the art in medical care is an ever-changing landscape, best left to medical professionals and the standards that they are legally and ethically required to follow. DYRS is already operating under procedures that align with the intent of and requirements outlined in the bill. We share the council's commitment to providing comprehensive, compassionate care for pregnant girls and postpartum youth. However, when the standards of care are inevitably updated, the existence of this law will force us to adhere to an outdated standard until the law is changed. Turning to Youth Records Oversight and Transparency Act of 2025. Transparency is essential for maintaining public trust, and council maintains substantial access to youth records through C.A.R.E DC. As it relates to the Council of the District of Columbia, this bill duplicates access already established. However, the Youth Records Oversight and Transparency Amendment Act would expand that access far beyond what is appropriate or necessary in another way, granting the Office of Ombudsman for Children unrestricted access to all DYRS youth records raises serious concerns. These records often include sensitive and confidential information such as medical, educational, mental health details that must be carefully protected to safeguard youth privacy and comply with confidentiality laws. The purpose of the Ombudsman for Children is to provide oversight of the care and services provided to children who are residents of the district and who are involved with or who are at risk of involvement with the Child and Family Services Agency, and to promote accountability, transparency, and systemic reform within the district's child welfare system. OFC should have access to DYRS information that relates to their oversight role over CFSA and youth who touch both systems. However, granting blanket access to all records expands their access to information well beyond the scope of their mandate. I request the council clarify and narrow the scope of access provided under this proposal and establish appropriate safeguards to protect youth confidentiality. I'm ready to work with the committee and the Ombudsman for Children to develop a process that strikes a balance between transparency and safeguarding sensitive information while supporting our shared objectives. In conclusion, DYRS remains committed to accountability, transparency, and collaboration with the council. However, taken together, these bills represent a significant and unnecessary expansion of administrative mandates that would require significant resources to implement. I encourage council to strike provisions that duplicate existing law, avoid legislating medical standards that should be guided by medical professionals, and collaborate with DYRS and our partner agencies to refine our practices to meet the needs of our youth and council's oversight role, as DYRS has already demonstrated by implementing the data reporting that is sought after in the strengthening capacity proposal. Through collaboration, we can achieve the goals of these bills in ways that are practical, sustainable, and promote youth care and rehabilitation. Our common goal should be legislation that enhances outcomes without sacrificing safety or overburdening staff capacity. And I'm happy to answer any questions that you have.
Thank you, Director. I'm going to jump right in. And with all due respect, I would just say, out of all of the agencies I'm dealing with, DYRS gives me a little heartburn. I hear the testimony about collaborating, but it's been challenging to collaborate, and I'm happy to go through that. For the promoting parental engagement at DYRS bill, part of your testimony is that you already have these systems in place. This bill is duplicative. These are measures embedded within the Road Act. The reality, though, is you often say, Director, we're meeting with parents regularly. Parents and youth are saying it's not happening. We then say, okay, can you show us proof that you are actually meeting with parents? And there is no proof. What this bill does is not seek to duplicate any systems that are already in place. It requires the agency to maintain a digital log to say, for this detained youth, we engaged this parent in this meeting on this date. I don't think that's a high bar to meet, assuming the agency is actually meeting with parents. I'm happy for you to respond, but it's been challenging to verify and get information. I will go a step further since we're talking about collaboration. I am someone, no surprise, I care about education. I heard directly from the contracted provider for education services at DYRS that they did not have sufficient resources to provide the education needed at YSC. YSC, or Youth Services Center, is a 98-bed facility, 98 beds. And at a high watermark, I think we had 130 plus young people in the facility. So, and I'm going to get to that next, but in the budget, we secured additional funding so that that educational provider could hire more teachers, could purchase equipment. And to date, I don't think that money has been granted or dispersed. In fact, the message we've received from DYRS is we don't agree with it. Mind you, when the council passes a budget, that is law. So quite frankly and respectfully, you as director of the agency, you don't get to tell the council, I'm not going to do what you enact in a law. I'll go further. You say on the bill about strengthening capacity and transparency that the requirement for 120 days would somehow jeopardize the operations at Youth Services Center. What that bill is pushing for is that after 120 days of the passage of the bill, the mayor or the deputy mayor or you, the agency, would outline a plan for how you are going to address chronic over capacity at Youth Services Center. Again, for context, it is a 98-bed facility. However, it is routinely over capacity, so much so that young people are sleeping in office spaces in the hospital suite. You are doubling young people in unsafe conditions, and there are heightened incidents as a result of it. I will go further. We are in no way suggesting that DYRS release young people early as it relates to this bill. What we are saying is, Mayor Bowser, Director Abid, please outline a plan for how you are going to address overcrowding at YSC, because we deem it unacceptable and it's unsafe. Last thing I would say, because I was a little taken back by your testimony, about the safe pregnancy and delivery and postpartum care. We are in no way suggesting or trying to tie the hands of medical professionals. You suggest that right now there's already guidance on the books to deal with pregnant youth at DYRS. When my team reached out to DYRS to say, what is the policy? What is the guidance for pregnant youth in DYRS? We were told there isn't a policy. When we've reached out about other policies, we are told there isn't a coherent system of policies at DYRS. We're kind of piecemealing it. Fine. We're not finger pointing. But again, we are endeavoring to bring our juvenile detention system in alignment with the Department of Corrections, where this is in fact a policy. All that to say, I just wanted to level set because there's often this back and forth. I heard my colleague earlier suggest that these are administrative changes. I heard that as a tenor in some of your testimony, and I strongly reject it. I think what is happening at DYRS is problematic. I'm going to use even stronger language. I think what is happening at DYRS is dangerous, and you're failing on your mission. And over the last year, the oversight that I have conducted, we have pinpointed clear gaps in systems, from overcrowding to poor education services, to poor intake records, to poor parent engagement. And each of these bills are attempting to address those gaps. We've attempted to meet. We've attempted to work collaboratively in good faith. I think you have, for the most part, been a collaborative partner, but I also understand, and this is me talking behind the third wall, that you have higher ups that you have to report to. And so collaboration has been difficult because every problem we've tried to solve with you, although you've been collaborative, we haven't quite frankly seen traction. So last thing I would just say here, the reason why we have these bills is because when we meet and meet and meet, When I receive complaint after complaint after complaint from parents and youth directly about the conditions and what's happening in the agency, the next step is for us to legislate so it happens. Now, I'm going to go to my question. I didn't even mean to go on that rant, but I take issue that we have a failing agency. We have overcrowding conditions that are unsafe. We have parents that are decrying that their rights are being abused. And repeatedly, we have the agency come here and like, oh, everything's fine, when we know it's not. And I'm not making this up, nor are we trying to overburden the agency just for the sake of doing it. How is DYRS currently ensuring that it meets the requirements of the Road Act to invite parents and guardians to predispositions meeting to determine a youth's individualized rehabilitation plan?
Chairman, I think I need to respond to your comment
Please do.
before we get into these
Please do.
questions, because when you say that we haven't responded or we haven't done anything, I'm going to point directly to this bill, the bill that requires us to provide data on our website. All of the data that's encompassed in that bill is now on our website, and we did meet about specifically those individual data points
Yes.
that are articulated in the bill. And the offer you made to me, or the suggestion that you made to me, is if we can collaborate and put this on our website, we won't need to do any legislation on this.
That's right.
And we responded, and that is currently on our website, all of that data that
And
was
for
requested.
additional context, there's incident data reports that, quite frankly, maybe don't shed the agency in the best light. And what I was told is, oh, we can't quite do this data reporting because it's going to be a burden for our staff. And so we'll get to it. Is the incident reports on the website?
The incident reporting is on the website.
Okay, we'll take that into
Yes,
consideration. So
is.
part of having this in law is that whether director of bid is there or is someone else, that the agency doesn't get to pick and choose what you're going to opt to do. In terms of educational services, have you dispersed additional funds to the educational provider so that they can hire more staff?
We were in negotiations with the educational provider. We had an agreement at the last meeting that we had, and since then they have withdrawn that agreement. So that's up to them. I can't force them to do anything.
Okay, I think it's a bit of doublespeak, respectfully.
Well, it's not doublespeak, because
because
I think that there is a problem with the council trying to impose terms into a contract.
No, I think what the agency is attempting to do is to get the provider to agree to your terms, which, not to get way in the weeds here, but again, it's the law. Repeatedly, we see executive agencies picking and choosing which laws you're going to abide by. And quite frankly, you don't get to do that. If the council allotted money for the educational provider to hire more teachers, it would be great for the agency to say, this is how we're working with the provider to get more teachers, not to say, we don't agree with this, which is what you all said. So let us renegotiate the contract so we can nullify the original goal. So of course, I'm not surprised that they rejected your offer, because what you're attempting to do is to say, even though it's a 98-bed facility and we may or may not have 120, 125, 130 kids, you're trying to tie their hands so that they can't hire a sufficient number of teachers to provide. That's how I interpret it.
That's not what we're trying to do. We offered additional money both before and after the budget was passed to account for the additional youth that are being housed at YSC. And yes, we did require some changes to the terms of the contract, and we are absolutely within our rights to require those changes.
The
because
Road
to
Act.
do
The
otherwise,
council passed the Road Act to deal with the very slow process of placing youth. And repeatedly, you come to hearings to say, we're going to do our best to implement it, which the subtext of that is, we're not going to follow the law. We're going to try, but we may not do it. And it's also worth noting from the very beginning, you objected to the Road Act. So again, excuse the passion behind my questioning, but repeatedly you say, let's collaborate, but in the same time, you're going to pick and choose when you're going to do the things worth collaborating on. I'm out of time for this line of questioning. I didn't really get to my questions. I will, but Councilmember Pinto, I'll turn to you.
Okay, well, thank you. And thank you for your testimony and for being here today. I want to start with the promoting parental engagement bill that we're considering today. And as we think about the impetus for the bill, I mean, how do you think about the current communication processes and existing gaps as you see it in making sure that parents are getting access to the information that they need and that there's a clear, robust line of communication with all those in the ecosystem, whether that be the young person, the parents, the legal representatives, and the courts. It would be helpful to hear your perspective of those gaps as we think about the best way to fill them.
So I think that there are numerous places where we are required in the law to engage with families. Now, that doesn't always take place for a variety of reasons. And so I understand the desire to document the efforts. My only point with this is that we do get legislation oftentimes that requires some kind of data reporting, and oftentimes it does not accompany any resources to do it. So we get stretched very thin. As my testimony mentioned, complying with this is not the problem in terms of the family engagement piece. It's the reporting piece that I have concerns about. When we get a notice of intent to commit from either the court or for court social services, this is a youth that is being proceeded against in court, and they're giving us notice. Yeah, we think we're going to commit this young person. We will engage a YLS, which is a youth level of service. It's an evaluation, and that requires meeting with not only the youth but the youth's family. So even before they get committed, we start that engagement. With the Road Act, we have to have a predisposition meeting that requires us to engage with the family. When a youth is released from our care, we do a community placement agreement that requires us to reach out to the family. We have family engagement events. We have a partnership with Parent Watch, who engages with families that are reluctant to work with the agency in a more direct way. We also have a provider called Anchors in Strength that provides support to families and a support group to families. So we have a lot of opportunities where we do engage. I think the only issue I have with the bill itself is to ensure that we get the resources to do the reporting, because what we do, reporting when we have a successful contact with a family member is a lot easier than reporting when we don't, because you have notes in a system that say, all right, we engaged with the family, we did this or we did that. To make it into a report about, well, did you engage at all these occasions, means that we have to have something else that, or individual fields, not in a notes field in a case management system, but some individual field that says yes or no. We had an engagement here, or we had an engagement here. And if we didn't, what was the reason? Did we reach out or all that? What efforts did we make? That's the part that becomes burdensome. And all I'm advocating here for is that we get the resources. If you want to get those reports, I'm certainly open to that. But we shouldn't be tasked with that, because if we don't get those resources, it's going to be those people that are supposed to be engaging with families that are then going to have to develop those individual reports. We don't have a system that can just automatically detect all of that. We would have to build that out.
Okay. And kind of speaking of the balance of new requirements and then fulfilling your existing mission, how have improvements been made over the last year around the rehabilitation plans for each young person?
So the first step in developing those was to do the YLS. We had a significant challenge of resistance from our staff, frankly, to completing those YLSs. So we reorganized the care coordination team to have a dedicated team that exclusively does the YLSs for the agency. And we engaged with a new technical assistance partner to provide quality assurance over that. Once we have a YLS completed, that is what drives the development of a success plan for our young person. And so we have completed that stage where we've now got a dedicated YLS team. And they now are moving into developing these success plans. We do still have work to do in terms of the quality assurance over those plans, ensuring that they're done timely. That still remains to be done. We've also developed a team, a dedicated team for reentry, so that when young people are exiting our system, that they have dedicated workers who are evaluating the work that they've done while they're in commitment to help develop a community placement agreement so that we have the supports in place. We still have to do quality assurance over that as well, but we have made significant progress in putting the pieces together.
Okay, and what does that progress look like in terms of the amount of cases that are in compliance per your own compliance hire?
I'm sorry.
Sorry, that sounded confusing even to me. Now that you have this person in place, what are they finding about how many cases are going through the appropriate?
So when we look
measures?
at the YLS completion, what we're finding is when we get notice as it's sort of in the normal course, which is supposed to be 30 days before a youth is committed, we're completing YLSs. But we're also finding that we're getting commitments without a notification prior to their commitment. So there will be situations where a young person is committed because of a plea agreement. So there wasn't an anticipation of whatever happened, and then suddenly that young person's committed. So we've developed a procedure for how to catch up with the work and attempt to do that evaluation that should have been done earlier as quickly as we can while we make efforts to place those youth. We've also made significant strides in expanding the breadth of placement options that we have within the district. As you know, I mean, we have nearly 200 youth that are committed to DYRS, but we only have 60 beds at New Beginnings. So the majority of kids need to be housed in private providers, and private providers can choose to accept the youth or not. So we need to have a range of private providers, and we've had to put a tremendous amount of effort to convince these providers to work with us and to accept youth from our system. And we've made progress there as well.
Okay, and I appreciate all that, but what does that progress look like in terms of the number of kids or the percentage that are in compliance with that planning process?
So, to say they're in compliance, I mean, we are in compliance when we have the proper notification. When we don't have the notification, yes, we're not in compliance with the law because it's impossible to comply with the law in those circumstances. And so we have to just do our best to finish those evaluations and make those placement decisions and work to get those young people placed. We have lots of discussion in Chairman Parker's committee about youth awaiting placement. And that is one of my chief concerns, that we get youth into their programming as quickly as we possibly can. But that means every step of the way we have to make tweaks or make improvements. And so we could have 90% of the work properly done, but if that last 10% something goes wrong, it's still not going to result in the outcome that we want, which is a placement within 30 days. So, it's hard to say like, oh, we haven't made any progress. When we have made significant progress, it doesn't always result in the outcome that we're looking for until we get all of those pieces in place and everything lined up. And we're not quite there yet, frankly.
Okay. What do you think the definition of recidivism should be?
It's a new adjudication or conviction in the community. That's what it is. So if you have received treatment from DYRS, you've been a committed youth, and you go back into the community, right? We've released you back into the community, and you obtain a new conviction or a new adjudication of delinquency, which is the equivalent of a conviction in the juvenile parlance.
And how do we square that with what you were saying in your testimony about not being reliant on OAG's prosecutorial discretion in our definition?
So the definition that's in the legislation is looking at what did OAG did OAG open a new delinquency matter? And the other, section B is, did OAG seek prosecutorial action? And so neither of those gets you to, did they commit a new offense? It's just looking, well, did they open a case or did they seek to move forward on a case? Recidivism is you got convicted of a new offense. So it doesn't hit what, it misses the whole point of court, which is like, you can be accused of something, but unless the court finds you guilty, you didn't do it.
Right. I mean, I guess you're saying that recidivism is as though it is totally agreed upon by all. Like, one of the things that we're considering in this bill is around the definition of recidivism. And so I don't think it's not is in the way that maybe it seems obvious to you, because that's kind of one of the topics of.
Well, if
what
I
we're
could
dealing
just
with.
elaborate, there is a national definition for recidivism. And there is a lengthy white paper, I believe I've shared it with Chairman Parker's committee, and I can share it with you as well, Chairperson Pinto, that goes into what is that definition and why did they arrive at this definition? And it was put together by a group of scholars and administrators from around the country. And it is the definition that the vast majority of jurisdictions around the country use to define recidivism.
Okay, that's fair. But in our juvenile justice system, when we have the regular use of consent decrees and deferred prosecution agreements and deferred disposition agreements, that will necessarily mean that there are fewer kids who are ultimately adjudicated and convicted by traditional means, because we have those other mechanisms for accountability and response. Wouldn't only defining it as like a final adjudication undercount the challenge that we're trying to measure, which is a repeated offense?
I wouldn't say it's an undercount. That is the accurate count of somebody that recidivated. If you're trying to see a measure of juvenile crime, is there more offenders or more offenses happening? I would suggest you look at arrest rates rather than prosecutorial decisions. I think that's an overcount, but if you want to look at the whole picture, look at arrests and then look at adjudications of delinquency or convictions. And then if you want to get a sense of the magnitude of the new offense, look at reincarceration. Those are the three traditional rates that you would view to sort of see the system and offending behavior, rather than looking at the decisions that the prosecutor makes, because every jurisdiction has a prosecutor that has discretion to do these things.
Yeah, I mean, I would agree that arrests would probably be an overcount, but it just seems to me that a final adjudication could be an undercount. And so this bill seeks to strike a balance, and it appears a reasonable, like, if there's and I'm sorry, I know I'm over time here. This will be my last thought on this, but if we have a young person who is rearrested, let's say, for a violent offense, the reason that we want to measure this is to see if our rehabilitation efforts were effective, right? And so this young person has been committed, DYRS, they've been released 6 months later, they are arrested for a violent offense. They come in and OAG, with their prosecutorial discretion, looks at all the evidence and determines that they are really better suited for a deferred prosecution agreement, where there's going to be a set of conditions associated with their accountability, and they're not recommitted. Why wouldn't we want to measure that young person as an example of somebody who recidivated? Because by all accounts, they did, right? I mean, not your definition of final adjudication, but that's just because there was a conditions associated with their prosecution.
So I mean, I think, if somebody is committed to the department and then released and commits a violent offense, I just think it's deferred prosecution is probably not going to be the method that is particularly used unless that allegation of the violent offense is not quite what it seems, right? I mean, we wouldn't take a twice now convicted carjacker and just divert them after they've been through the system, would
Well,
we?
I can't say for sure because I cannot get access to data.
So, so then you may have an interest in doing that as a
Yes, I
oversight
do.
role
Yes, I
or
do.
OAG. I would just argue that's not recidivism. A recidivism analysis could look at arrests and look at adjudications, but that particular piece is looking at AG's decision-making. That's a different measure and it's just not recidivism.
Okay,
That
I
shouldn't
think
be
we
a
might,
measure of.
I think we might just disagree on
We
this
do.
because that is what the legislative process is about, right? Is determining what the right standard is for the law. So just because it is not, doesn't mean it can't be. And so I just want to make sure that we are focused on the goal that we are trying to accomplish. And maybe this isn't the right standard, but I want us to be creative in figuring out the standard that does address the challenge that we're trying to measure so that, again, it's not just data for data's sake, but so that we can drive towards improvements around these rehabilitative plans. So I won't say I'll stop there now that I'm double over my time, but thank you very much.
Thank you.
No, thank you. And we're being flexible here. Before I jump back into my questions about promoting parental engagement at DYRS, the Road Act went into effect as of October 1st. I think what Councilmember Pinto was getting at is how many individualized plans have been created to date?
I don't have data on the Road Act. I was prepared to speak to these bills. And
But anecdotally.
we are still in the recruitment phase of the few additional positions, not sufficient number of additional positions that we were given in that piece of legislation. So we haven't even recruited the people. So we have drafted the procedures, but we cannot implement them until we have the people in place to implement them.
And my team has asked for copies of those protocols that you keep referencing.
I thought we sent those. We didn't send those?
We were told that we would receive them by the end of the year.
Okay.
Can we
we'll
have
make
them?
sure- We'll get them to you by tomorrow.
Awesome. And we want to work with you. And this isn't meant to be a gotcha, but again, it's been a little challenging at times. How is DYRS currently ensuring that it meets the requirement in the Road Act to invite parents and guardians to a predisposition meeting to determine a youth's individualized rehabilitation plan? And if you want to speak about what the protocol is, even though it may not yet be acting in reality, that's fine.
Right. So it's literally a procedure that requires that we reach out and contact the parents and organize the meeting before that predisposition.
And as
hearing takes
director,
place.
how are you verifying that that is happening? So I imagine you're not in each of these meetings. I'm assuming you're planning to look at something to say, are we following our own protocol? How are you ensuring that parents are affirmatively engaged?
So we are putting together a quality assurance process to oversee this. We've required our staff to document that they've reached out and that they've made that effort so that we can see that in the case file. And then, obviously if they choose not to attend, we still have to move forward with their case planning. But we will enforce the rule that they have to reach out and make the request. And then we can review that to ensure that they've made, reasonable efforts to engage with them. And there are other engagement opportunities after that, even if they aren't available or they choose not to participate, we will continue to engage with them. So in terms of the bill that you have submitted, its spirit, I'm completely aligned with that. It's just a matter of ensuring that we have resources to report on it.
Okay. I think an Excel spreadsheet would be sufficient to simply say, by this date, we contacted this person, they joined this meeting, because I have heard directly from more than a dozen parents that are saying, I don't hear from DYRS. DYRS made decisions for my child, and I had no idea. I came to visit my young person at Youth Services Center. And wow, I found out once I was there, they're not even there anymore because they were shipped or transferred out and no one contacted me. My child had COVID. I'm giving real things I've heard. My child had COVID or my child was sent to the hospital suite and no one notified me. And so I hear from you, yeah, we have these protocols and we're doing it. I hear from parents, it's not happening. The natural question is then how do we prove, because I want to believe that it's happening, we need some type of documentation to say that the parent engagement is happening. It's not meant to be burdensome. It's not meant to be duplicative. We need to verify that it's happening. How does DYRS plan to address instances when a parent doesn't respond? And so I totally agree with you. The process has to keep going. Is that we're going to reach out one time? Is it going to be we're going to reach out 3 times? Maybe a phone is disconnected. Can you just elaborate, if it's hard to get in touch with a parent, how you're going to what is the protocol around that?
So, obviously we can't know if there is some barrier like that in the moment. And because we have these timeframes, we do have to move on with the case planning. But as I said earlier, we have other opportunities to continue to engage with families. And so at each phase of a youth stay with us, for instance, when we do their success plan, we have to go back and engage with the families. And if we're finding that we can't find them, then yeah, we need to make other efforts, ask other people. We generally will talk to the young person and say, are you in touch with your parent? How do we get in touch with them? And they can give us the information that we need.
Okay, and for additional context, the bill requires that DYRS is meeting with parents at least every 6 months, which is essentially twice a year,
Mhm.
and that parents are included in the creation of the rehabilitation plan. Those are processes that are already happening. The bill is not requiring new meetings. We're just saying by law, you have to, in fact, do it because we are hearing reports that it's not happening. And the bill requires a digital log, an Excel spreadsheet, a data report, so that there's some proof. So I just want to clarify, we are not trying to add new meetings. These are meetings that should theoretically already be happening that we are including in the law.
So if I
Yep.
could just address
Yep.
the issue of an Excel spreadsheet, that's just not the way we should be doing our business. I know it's in isolation, that sounds like, yeah, reasonable solution. You just do an Excel spreadsheet. But we have multiple people that are going to be responsible for different phases of contact, and they all have to be able to document that information. We do have a case planning system called FamCare. We have to drive all of those things into FamCare. And when we do one-off Excel spreadsheets for this and one-off Excel spreadsheets for that, we don't have a single record that can get everything that we need when we need to research an issue
That's
if you have
fair.
a question. So that's why
That's fair.
I say it's resource, because it is hard to.
But I'm challenged by the argument that, oh, we need 3 extra FTEs to document meetings that are happening that should already be happening. So if I take you at your word, the meetings are happening, it doesn't seem to be that far of a stretch just to record that somewhere.
It's not recording that the meetings are happening. It's when we don't have contact and having a log of all of the efforts. That's the new piece.
Okay. The TDM meetings, we have heard a lot of, these are the team decision meetings. Can you just quickly explain what is the purpose of the TDM meeting at DYRS?
The TDM meeting is a meeting that we bring together team decision making. So we have members of the treatment team, members of the youth's family, to go over the progress of their treatment and their progress on their goals. And yes, there have been issues with the TDM meetings taking place. We have a employee that was out on leave that has now returned and has been made responsible for organizing those TDM meetings. And we are getting those TDM meetings done now.
Okay. And are parents expected to be a part of those TDM meetings?
We would prefer them to be part of the TDM meetings. Yes.
Do you have data on how often parents are included in those TDM meetings?
I'll have to check with our team if we have that data.
Okay.
And if we do, I'll provide it.
what the committee routinely hears is that parents are not being invited to be a part of those meetings, and the agency is making decisions for young people outside of the purview of parents. And so again, when we don't have data, it's hard to verify or challenge what we're hearing from parents. How are you recording information as it relates to the TDM meetings? Do you have a software technology? How is that being recorded?
Yeah, it's recorded in the case management system.
Okay. Now, could that case management system be used to adhere to this law, this bill?
Yes, it could be, but we would need to add additional elements. That's the part that
Got it.
we have to do.
Okay. I'm going to move on to the strengthening capacity and transparency. And I do want to acknowledge we are a little over time. If I could.
Absolutely.
Okay, just a little bit more time. I do want to respect your time. This bill is asking, in addition to defining recidivism and reporting out on it annually, it would ask that the executive come up with a plan within 120 days. Now, to your credit, I know you're already thinking about this. We agree that overcrowding at YC is a problem. I know behind the scenes you've been engaging, thinking about how to address the overcrowding issue. This bill is wanting it to be on the public record and to document what the plan is. In your testimony, though, it sounded like you were suggesting the bill is wanting to release young people from detention, and that's not what the bill does.
Okay, so I'll take up the issue of the plan first. We had a hearing on overcrowding.
Yes.
And I did give public testimony about what could we do and what we were doing. And the concern that I have here is that a lot of the decision making about who is detained is outside of DYRS's control. So we can let me say, what was the plan that we articulated? Unify the system. That is the best plan that we could go forward with, so that we have
If I
an
could interject
opportunity
quickly,
to.
but you would agree that that's a long-term plan.
Yes.
That's not going to happen anytime soon, especially with our friends down the street.
But there are no short-term options. So acquiring a facility or building a facility are long-term plans as well.
I hesitate to say, I'm not advocating to find more space. There are some that would say DYRS finding more space incentivizes us to just lock up more kids. That's not what I'm advocating for. The conditions at YSC are dangerous. I think that is a state of an emergency. It would be great for the mayor, for you, for the deputy mayor to say, here's our short-term plan, whether we're going to send some young people to New Beginnings, whether we're going to use another office space. But the answer can't just be, yeah, we know it's a 98-bed facility and we're 130 and we're going to just keep rocking how we're doing it. Like, that's what I'm hearing you say. This bill is saying within 4 months of this bill passing, the executive has to come up with a short-term plan to address overcrowding at the facility.
You're asking the executive to come up with a plan for things that she doesn't control, and that's the problem. The courts can we can make all the plans that we want, and if they continue to detain youth, we're obligated to house them.
The length of stay due to placement is within the executive's control.
Yes.
To determine whether or not a young person is going to be placed in secure detention or in the community is within, oftentimes, the executive's control. The executive has at its disposal any number of district-owned properties and buildings. It seems to me the executive has a lot of control if the executive thinks this is a problem. If, God forbid, something happens at the YSC facility, I would imagine then there will be a level of urgency that we're just not seeing now. I hear what you're saying. I reject it, because what you're essentially saying is, well, the courts determine who is detained. And so therefore, maybe that number will get to 200, 250. Like, we can't operate like that. I'm not suggesting go build a new building, but there should be an emergency plan dealing with overcrowding at YSC.
But the bill that you have here puts a cap at 90 days, does it not? I mean, 90 youth at YSC.
It's
says
a 90.
no more. the
It's a
90
98-bed facility. I would have to look at the language. There is no cap in terms of the number of youth detained in the facility.
So I'm going to read from the bill itself that within 120 days and after the effective date, the mayor shall submit council a one-year action plan to address overcrowding. The plan shall specify how the department will permanently reduce the juvenile population at the Youth Services Center to a maximum of 90 youth.
Yeah, to ensure that you are under the capacity of the facility. That in no way is saying that we are requiring the agency to release youth. I want a plan for how you're going to bring the population under the capacity of the facility. I don't think that's rocket science. It's to say 100 people can sit in this room. What's the plan to ensure that we're not over that capacity? I think what is most alarming is that we're treating this as though it's okay. And I would suspect that's informing the rehabilitation or the lack thereof of the young people in custody of DYRS, which is in part why our recidivism rates are so high.
Now, I don't think it's okay at all because I have
Okay.
advocated on numerous
if we
occasions
both-
about the different populations that we are serving.
If we
I
both
don't
agree
charge
that it's
youth
not
with
okay,
adults.
why is it so hard to come up with a plan to address the problem?
Because we don't have the levers of control to engage a reasonable plan. So I have articulated, we need to be given the levers of control. If we could influence the intake decision-making, if we could put a structured decision tool about who gets detained overnight and provide that risk assessment to the court so that they can make better decisions, then we could actually
I fully
influence.
support the goal of unification. I'm with you, but that's a long-term proposition at best. The facility is overcrowded now. It has been overcrowded for years. And again, we're talking past each other, but I just think it is not a good look for the executive's formal testimony to be, it's out of our control to deal with overcrowding at DYRS. That cannot be the
Our position is that we should be given control so that we can influence that population. It isn't we're not structured properly. And so we should move to structure the agency
I would
with the
just say
levers that
we
we
have,
have.
as a council, interestingly enough, been blamed, but also asked to pass emergencies, to enforce a curfew, and to detain youth for this or that or the other. And so it is just curious that we can move with urgency when we want to penalize young people, but when it is about ensuring their well-being, there just seems to be a lack of urgency.
The curfew doesn't impact the detention population. Those youth are not detained.
But I'm talking about, I would argue, a lot of the young people probably running around the city, I would imagine a fraction of them have encountered DYRS. This is tangential to my point. The argument I'm making is we can move swiftly on an emergency basis when we want to. We could treat things urgently when we want to, and we should. It's curious that we're not treating overcrowding at YSC as an urgent crisis. I think it's an urgent crisis. This bill is asking the mayor in 4 months after this bill is passed to come up with a plan. There should be a plan right now. It's not rocket science. I'm going to keep going. But I want to make clear on this. We in no way are advocating for the release of juveniles in detention. I don't want the narrative to be, oh, you know, those soft on crime council members are trying to ensure we don't detain youth. That is not the nature or the purpose of the bill. It is to
So-
ensure that it's not overcrowding at YSC.
So that 90-day cap is not a cap? Is that what it,
It's not about 90 days.
if there's 90 youth maximum capacity?
To come up with a plan.
But if
there-
we say in law that we can only house 90 youth at this facility,
That's not what we're asking for. We're asking for a plan, not a law. We're asking for, what is your plan to ensure that there are no more than 90 youth housed at YSC at any given time? What is the plan? Not change the law, not release anyone, to ensure that there are sufficient resources. Now, This dovetails with the education thing we were talking about before, because the education provider would say, we are contracted to provide education services, assuming there are 98 youth at the facility. We don't have enough teachers when there are 130 youth at the facility. That makes a lot of sense to me as a former teacher. I can't teach 100 kids at one time. We provided more resources so that DYRS can provide resources to the education provider so that they can hire more teachers. We've gone through this already. It's all connected. But DYRS's position is, well, we don't think they deserve more money. And
That's not true. We offered substantially more funding for the additional population. They chose to walk away from that.
okay, I'm gonna keep moving. I'm gonna keep going. The safe pregnancy, delivery, and postpartum care. Does DYRS have any internal policies for pregnant youth at this moment?
We have a draft policy. We do not have an implemented policy. And
Okay,
I can
so
provide
this
the draft
bill-
policy.
And essentially your testimony was this bill is not necessary. This bill requires DYRS to have a policy. So right now DYRS does not have a policy. Maybe you don't need a bill to tell you to create a policy, but it's not duplicative because right now you don't have a policy.
No, the point that I'm making about this is that you're enshrining the current medical standards into a law. And those are things that change over time. Medical standards are not static. They change. So in any case, when any youth comes to us, whether we have a procedure that covers it or not, we have physicians and nurses that have medical licenses and they have ethical obligations, professional obligations to provide a standard of care. And they provide that standard of care. Now we can articulate that standard in whether it's for pregnant women or for other populations, but it doesn't absolve them of that responsibility. They always have that responsibility. So what I'm saying is if we enshrine this into law and then the standards change, then now we're stuck with these standards and we have to come back and change the bill.
What standards? I'm not following.
These are standards of care for a pregnant youth.
We
Okay.
are asking the agency to create a policy, provide pregnancy tests before the administration of any medication, because right now it is our understanding that well, let me ask, how often are pregnancy tests provided to young people at DYRS?
They will be provided to every youth, but they have not been provided to everyone that comes in.
Okay, so we
So-
don't have a plan. There are no pregnancy tests provided.
Now, they are provided now. That I said that they were not provided in the past. We have updated that and we are ensuring that young ladies that come in do get a pregnancy test.
And so you would agree that that is important. All this is doing
Yes.
is ensuring that whether Director Abed is here or somebody else who may not agree with that, that is the standard. That's all. We're not trying to overburden. And again, we're bringing our juvenile detention system in alignment with what we do at the Department of Corrections.
Understood.
Okay.
And just for the record, I don't disagree with anything that's in that bill
Okay.
in terms of the care of young people.
Okay. On the recidivism front, I hear what you're saying and I'm persuaded by it. Essentially what I think I hear you say is our definition of recidivism should be about the harm caused by a young person for a new offense once they are released from detention, not simply whether or not the OAG presses charges. The challenge, though, is how do we get data to inform our metric of recidivism outside of the data that the OAG would be collecting?
Well, so, MPD has arrest data on juvenile offenses. So we have arrest data. And I totally agree. That is not recidivism, if you will, because it is essentially an allegation, right? That a young person has committed an offense. The objective way to determine, well, did you actually do that, right? Versus the allegation is the court process. If you're adjudicated delinquent, if you're convicted of an offense, then the law says, yes, you have done that. That is exactly what the trial is. They are a trier of fact. They are determining this is what actually happened. That's the record now. And so that is what I would measure objectively as a recidivist. So, looking at the decision-making of the OAG is sort of, well, how did they subjectively decide to handle this case or divert that case? I don't know what that really shows, council for the performance of DYRS, because that's really just their decision-making. And I don't know, I mean, you may have legitimate interest in overseeing the AG about their decision-making. I'm just saying that that's not a definition for recidivism.
Okay.
It's just a measure of OAG.
As we move forward, I would love to work with you and your team, but to strike the right balance there, because I think what you're saying makes a lot of sense. And I think there's probably a balance somewhere in there. For the sake of time, I'm just going to, at a high level. So the promoting parental engagement at DYRS, the headline I have from you all is a lot of this is or already planning to take place in terms of these parent meetings. And we're fine with logging the parent meetings. We just need the resources to do that.
Absolutely.
Okay, that's fair. The strengthening capacity and transparency, maybe we just don't agree here. That would require a plan from the executive within 120 days of the passage of this bill. It would define recidivism and ensure that we're tracking that as a metric. The headline that I have is that your plan is unifying our system, there's no need to create a plan within 120 days. Is that fair?
Well, for the entirety of that bill, I would like to also say first, there are a number of data requirements that are in that bill that the department has already stepped forward and begun reporting on.
And I appreciate that.
And those are on our website. So to that extent, we're already in compliance with what's being requested. We've already talked about the recidivism definitions. I think, we just have a difference, or I don't think we have much of a difference, but
and we'll align on
with
that.
with the
It seems
language.
like the greatest distance is on creating a plan to address overcrowding.
Yes, because, we've had that hearing and I've articulated that, and, we can articulate it in a document. I understand
Yes.
what you're asking for.
And ideally take action.
But what I want to impress upon you is that when we're looking at the population and you're just looking at DYRS, you're missing the bigger picture. The contributors in there are the ones that we really need to address, and that never gets addressed. And that's where we get
The contributors
friction.
being the courts, I'm assuming you.
The courts, court social services, the controls that you would typically put in place to manage a detention population don't exist with DYRS. They exist within these other entities.
And that is, I take that. As you know, we don't have jurisdiction or oversight over the federal government. Our courts and court social services are federal entities. I certainly meet with them. We do have jurisdiction over DYRS. And so I do think there are things we could be doing in the district to address dangerous overcrowding at YC, which is what this bill seeks to do. And then the Safe Pregnancy, Delivery, and Postpartum Care Bill, it sounds like generally we are aligned now that it's good to have a policy in place and provide pregnancy tests. And it sounds like you all are already in the work there. Is that fair?
That's correct.
Okay. On the education funding matter, I know that's not relative to these bills, but it matters a lot to me. And the reason, just for those watching, what I saw at YSC, and I know there's some disagreement here, but I saw young people being handed a worksheet, and that was the extent of their education services provided that day, with no guidance, no teaching. And part of why, after we did some investigating, I was told that was happening is because the educational provider didn't have sufficient number of teachers. Okay, let's solve that. We'll give you more money so you can hire more teachers. I won't belabor the point because I think I've made the point, but I would just say, Director, every day a young person at YSC is not receiving adequate education services, I think is to their detriment and to the city's detriment. And I hope I will be working with you all to come up with some agreement, but I just continue to be challenged that we can't just disperse the money for the agency to be able to hire more teachers. I don't think it's that difficult. I know I'm oversimplifying it, but I'll give you the last word there. But it's now November and we still don't have more education staff at the facility.
Mr. Chairman, I think that having these conversations in public has been one of the barriers to getting to an agreement. As I mentioned, we had an agreement prior to our last
I
meeting.
reject that.
And
I reject it. I don't buy it. I don't, and so I
I mean,
think
you
there's
can reject it, but we've been in earnest negotiations with the provider. What we can't do is just give money or pump money into a contract. There are legal requirements for a
asking-
contract, but you're saying, no, just give this money to this particular vendor. And
the
that's
executive every day reprograms money, every day renegotiates contracts. We have to approve it all of the time. This is not some one-off decision. I'm not asking you to strike a new deal with them. We acted swiftly because we had communication with you. We talked to them. We said what is needed. I think the dollar amount was $200,000, $300,000, which in the grand scheme of things isn't a ton of money, so that they can hire X more teachers at the facility. Let me ask this, is every young person at YSC provided in-person instruction every day?
once they're out of intake, yes. But the first 5 days, we don't have their education records. They do not get instruction until we get their education
So
records.
you were saying every young person is receiving in-person direct instruction, and no longer are young people receiving these worksheets.
Yes, what we do is when, if we have too many youth for a particular unit, they still go into the classroom and get their education during the day, even if they're not housed in that particular unit. So we have found the
That's not what I saw.
solution.
I saw,
Well, I think that you were seeing youth that were in that 5-day period in the intake portion of the facility. And I have looked and drilled down on this issue. Youth are getting their education. It's when we move them into their unit, they get their education, and we move them into that after the 5-day period. That's the way that we've
I'll
been
end on a
operating.
positive note, but again, for context, there are about 11 youth on one unit. The youth could range in age from, let's say, 14 to 17. 11 young people at all different ages, oftentimes with one teacher that's pushing in to provide what I would call subpar education. That is what is happening. Now, kudos to you. We talked about earlier this year, can you use technology to provide more individualized instruction at that young person's level so that they're receiving an adequate education? And I'll give you credit, you've done that. And so we're pushing at this because I think when we talk about rehabilitation, education plays a major part in that, in my opinion. I think there's still some more work to do and we can handle that offline. I don't know where Councilmember Pinto went, and I don't see any of my colleagues, but I want to thank you for your time and testimony on these bills. We will keep pushing. But I will just end by saying again, each of these bills address very distinct gaps that we have identified over our year plus of oversight of the agency. So thank you again, Director.
Thank you, Mr. Chairman.
With that, the time is now 12:44. I am going to recess for 6 minutes and resume this hearing with public witnesses at 12:50. And so with that, we will recess and resume in 6 minutes. I am going to call this hearing back into order. And I'm going to ask if people in the chamber could quiet down as we move on to our public witnesses. First, we have Jamari Kane White. Next, Sierra Bailey, Princess Sims, Olivia Thomas. And Jamari, you may begin when you're ready. For this panel, that will be it.
Hello. Okay. Yeah. Good afternoon, everyone. Good afternoon, Councilmember Parker, and here we are again to discuss the Soul Family Initiative. I'm glad we were holding this joint hearing. So, I am Jamari White. I am a native Washingtonian and recent Howard University graduate. I've lived here and occasionally Maryland my entire life. I've also spent half of my life in foster care up until 2020 when I was adopted at the age of 19. During my tenure in the system, I had about 10 placements, various foster homes, congregate care settings, failed kinship, even almost missed out on my loving family if I hadn't come to my senses and realized those people loved me more than anyone. And they continue to show it day in and day out, no matter what situation I'm in. I'll always ask my parents for help. But I dream of that feeling for every youth in care. Unfortunately, most older youth here in our city age out or choose emancipation because they never experienced that love, nor do they believe it exists after their traumatic experiences within the system. Such as the state I was in before meeting my family. Experiences that could be avoided if we enact the Soul Family Initiative and move it forward. This permanency pathway will essentially allow youth to choose their family, building lifelong connections with their most trusted adults. And quite frankly, the system now feels more like a lottery system where some children have the loving foster care experience that's so coveted, while others have to endure hardships to no end, ultimately finding their own way in life after being thrown out the system at age 21, regardless of if they are ready or not. A trend that should not be so consistent. A trend that would have saved me years of trauma and otherwise negative experiences with parental figures. I watched every adult I actually wanted to live with pass the opportunity up due to financial anxiety, the process is being too drawn out, not having their things together, etc. My father had passed as soon as my little brother was born. My father had passed as soon as my little brother was born, not having things together, and we just couldn't be taken by anyone because various loopholes such as my aunt not having her name on the lease, grandma couldn't take me because she didn't have enough money, and etc. The supports just were not in place. And I found what I thought to be a great home in my father's sister's home, only for the kinship to fail. And as you know, most prospective foster parents would like a younger child, one that's easily moldable, and not a teen who's trying to find a way in the world. So I was separated from my younger brother, and tossed in a group home. I begged for a lifeline every day in the group home, almost to the point of tallying the walls. Every adult I had a meaningful relationship with could not take me due to the complications of the guardianship process or financial strain. Now, where my story differs is I went back to my now family on my own, and they accepted me back. If they hadn't, my fate would have been much like that of my peers, aged out, incarcerated. Some were even trafficked, and others had the life squeezed out of them and only wanted to get money to survive. And we can get coffee and discuss those things later, but the point is we need the Soul Family Initiative. The city's youth needs the Soul Family Initiative. This is the most transformative legislation I've seen in all my years of living as it relates to the child welfare system. It takes a village, and this gives youth the keys to build their own. Leaving the system early, know what a family is, knowing people have your back and it's not against the wall. A shorter process that is less invasive and more open to be trusted by youth and adults. By allowing youth to live with one member and having other support where they can is the ultimate way of letting the youth decide their pathway as opposed to feeling like just lambs to the slaughter. This will help ensure many of our city's youth can envision a future for themselves beyond where their next meal is coming from. A future where death, incarceration, or being trafficked hasn't even entered their minds because they are so entrenched in love. During my public speaking appearances, panels, and all, I've come across many nonprofit directors and professionals alike, and I've always heard long, drawn-out plans, many of which are feasible. However, the Soul Family Initiative, it is a no-brainer. Me and all the youth who've actually experienced the system feel the same. It is the ultimate way of letting the youth be in control of their life when many of them feel quite the opposite. It is the ultimate way of showing youth that people will still stand with them instead of demonizing them here in our city. That is why me and my peers give all the time we have to advocating for this initiative. Our time in the system may have passed, but it's not just about our experiences. We are trying to ensure that our ordeals are not consistencies in this system. This is for all the youth who are trying to and will come to innovate even more than we could ever imagine. By passing the Soul Family Permanency Pathway, you'll be doing a great justice to our city and the foster youth who inhabit it. Thank you.
Thank you. I gave you a little extra time. If you could just push the button to make sure you turn your mic off. And then next, we will have C.A.R.E. Bailey.
Good morning. Good morning, Chairperson Parker, Chairperson Pintos, and members of the committee. My name is C.A.R.E. Bailey, and I am a LIV expert from Washington, D.C., testifying today in support of the Soul Amendment Act of 2025. When I first heard about Soul, there were three parts that stood out to me. One was that you got to take initiative over your own life by building your community or family, if you will. I'm from a big family. I'm one of 10. And although we all went into care at a young age, I still value and share strong bonds with them. I know all too well the benefit of having a family and support around you. Another huge part of it was the name: support, opportunity, unity, and legal relationships. I believe we named it this to encompass all of the things that it takes to make a family real. So isn't just another saying or a name made up to sound catchy. It gives life to a thing that was created for the youth of the system today with community and resources in mind, intent on creating forever families. The last major one was I had never heard of youth leading the process and advocating for what they wanted for themselves. It would have been ideal if so could have been an option for me personally, because I had a lot of people who loved me. But at the time, I did not feel like I wanted to disassociate with my siblings for the sake of permanency. But since it could not be an option for me, I would like to say why I think it should be passed into legislation here today for the current youth of today's system. I've been working on SOUL with CFSA, OAG, and other professionals and LIV experts for about a year and a half, sharing ideas, creating policy, and building practice and implementation plans. The LIV experts who are currently in care drive me the most. In my experience in working with them, the current youth seem a lot more insightful about their rights, permanency options, planning for the future, and they are adamant about being the change they would like to see, which is a lot different from when I aged out in November 2019. I wanted to be a part of helping them do that for themselves and also being a part of how we implement that moving forward in the best way. I personally feel like the current permanency plans do not fully address the current climate for the older youth in care and who are aging out of care. We have young adults who are faced with choosing services or community. For SOUL, we are talking about older youth between the ages of 16 and 21 without a permanency option that includes a family. APLA is not a permanency plan. It's a plan to say we have no plan. With SOUL, we do have one that sets the youth up for now as well as in the future. I do not know how much it will cost, but I know that it will save DC some money. The estimated annual cost of Soul Family is about half for the cost of the current foster care placement. We want to create a real permanency plan for all youth. The more people, the bigger the community, the better it is. The reality is you can have all the services in the world, but if you don't have a community to teach you basic skills, then you won't be able to reach your full potential. Youth with APLA age out with resources, fuck housing, insurance, but they don't have a community to help them do small things like applying for apartments in their range, moving into their apartment, and even signing a lease. You need somebody to teach you about life. When I aged out, I had support. I had a mentor. I had DCFYI. I had siblings. He helped me at the highest of highs with me, the birth of my son. He was there, and now he's the godson of my father. He brought me books, of my son, I'm sorry, bringing me books and holding my son while I was resting. He taught me how to be a woman, how to be an adult. And a lot of our youth don't have that. I think about it now, and it's heartbreaking. I ask the committee to please move this SOS legislation forward as soon as possible. Thank you.
Thank you. Well, you got a round of applause. Since there's an empty chair now, I'm going to ask Zanaya Torres to join. But next, we're going to hear from Olivia Thomas. And if you can make sure you speak into the microphone and the light is on.
Okay, is this good?
Yep.
All right. Good afternoon, Councilmember Parker and member of the committee. My name is Olivia Thomas. I am 18 years old and from Washington, D.C. But honestly, I like to say that I'm a little bit from everywhere. I spent a good time of my life in Baltimore too, and I've also been connected to D.C. I got in foster care when I was going to the 7th grade, and I've been in and out ever since. This past summer, I was adopted, and that was a huge moment for me. I finally felt like I had the family and stability I've always wanted my whole life. I'm here today to speak in support of the SOUL legislation. I'm a Lex leader, and I was part of helping build this idea because I really believe in what SOUL stands for. For me, SOUL means having a family that goes beyond just blood. It's about having people who love you, support you, and stay in your life no matter what. Youth like me need that. There are so many young people in the system who age out without the permanent support system. So gives them a chance to create their own version of a family, people who make them feel safe, wanted, and loved even after their case closes. One thing I think that should be changing the bill is that it shouldn't be on the youth to explain why certain adults disagree with their soul family choices. That puts too much pressure on us. Adults should be responsible for explaining their own reasons, not the youth. I want to thank Councilmember Parker for introducing this bill and all the other members who co-sponsored it, including Councilmember Pinto, Louis George, Allen, Robert White, and Nadu. I really hope you all move this legislation forward because it could make a difference for so many of us in care who just want to know we'll always have someone in our corner. Thank you for listening to me and my story and for supporting youth like me.
Thank you. With a minute to spare. So thank you. Next, we will have, I'm sorry, Princess. Did I skip you? Okay, I'm sorry. I didn't mean to do that. Next, I'll have Princess Sims.
No shade, no shade.
No shade.
Good afternoon, Chairman Parker and members of the committee. My name is Princess Ariel Loveland Sims. I'm one of the former foster youth, now lived expert, who for the past 2 years has worked diligently on creating and designing Soul, essentially bringing it to life. I am testifying today in support of the SOUL legislation. I entered foster care when I was 16 years old, but I had experienced neglect and abuse as young as 5. I have been in the juvenile justice system, group homes, experienced being a runaway and having to couch surf even while in care. I stayed in the system until I aged out at 21. Even after finding good foster parents towards the end of my foster care journey, there was not enough support to strengthen and maintain the bonds created. So I decided to venture out on my own without the default support system that is supposed to be available for youth when they age out, otherwise known as APLA. I am supportive of the SOUL family option because of its uniqueness. SOUL is tailored to a youth's individual needs. SOUL can grow with a youth because of its flexibility to adjust and shift based on what a youth's needs are at the time. The term soul family is important to me because your soul family is not just supporting you, they are also providing opportunities, unity, and creating legal relationships. A support family, as currently written in the legislation, sounds separate from the family. Soul is the family. The term support itself is generic. Additionally, we took a lot of time and put a lot of thought into creating that term, and I believe it should be well respected, just the same as any title you earned or name you create. It is not fair for it to be shortened or abbreviated by people that did not have a hand in creating it and who will not be directly impacted by it. No shade, no shade. Now more than ever, strengthening familiar bonds and providing youth with positive outlets is especially important. You should be able to build, create, and receive support from your own community as quickly as possible. It has always been urgent, but in this day and age, it is ever now more so. I ask this committee to please move the proposed SOL legislation forward. The future of the youth of tomorrow begins with our efforts today. Thank you graciously for your time and consideration.
Thank you. And no shade taken. Next, we will hear from Zanaya Torres.
Good afternoon. Good afternoon, council members.
If you could just make sure you speak directly into the mic.
Good afternoon, council members. Can you hear me?
Yes, but if you could project, or yeah, let's use this one. And make sure you turn that one off, so it's there.
Can you hear me?
Uh-oh. Okay, let's just go to the original one, and if you could project as much as possible, we'll make it work.
Good afternoon. Okay.
That's
So my name is Zanaya Torres and I'm a Lex leader. I'm 18 years old and I'm a DC resident who is currently in CARE. I'm here today to testify in support of SOL legislation, and I want to thank Councilmember Parker for introducing it, along with Councilmembers Pinto, Janice Lewis George, Charles Allen, Robert White, and Brianne Nadeau for co-sponsoring. As a Lex leader, I collaborated with others to develop the legislation and contributed to the development of the SOL concept. SOL is deeply meaningful to us because it embodies what we all need and deserve: a sense of love, belonging, and a lasting family, even after foster care. The name SOL is significant because it stands for support, opportunity, unity, and legal relationships. And this signifies a relationship that goes beyond the name support. For this reason, it is crucial that the word SOL remains in the legislation and not be substituted with support. I believe that words matter, and SOL reflects the purpose behind our efforts. Furthermore, the term support will conflict with our other terminology, such as supporters. We want this legislation to move forward and pass because it offers young people in foster care a genuine opportunity to create enduring, chosen familial connections that continue after the system ends. I have firsthand experience, and I know how difficult it can be to be without a network of support, and it is evident that youth are purposely aging out with other permanency options. By empowering young people to shape their own families and futures, SOL works to alter that. The mission of SOL is to empower youth and allow them to feel comfortable with their decisions and to choose their family by giving them autonomy to create it. Additionally, I would like to recommend one key modification. As of the moment, legislation says that youth must explain why an adult disagrees with the proposed SOL family, and I think this puts too much responsibility and emotional burden on the youth. The adult who disagrees should have the responsibility of explaining why the youth isn't supported. Instead of making young people feel blamed or overwhelmed, I think the process should uplift them. Lastly, I urge the council to ensure that SOL supporters get to take part in the process without having access to all the confidential records related to the neglect case. It is crucial to protect the privacy and the dignity of the youth, and I think that we can still do that while allowing meaningful participation. Thank you again to Councilmember Parker and all of the co-sponsors for supporting this vision. Please move this legislation forward soon as possible, so DC youth and foster care can finally have what every young person deserves, which is a permanent family and a sense of belonging through SOL. Thank you.
Thank you all. We will ask a round of questions each. And I just have two simple questions. How do you believe, can you give one specific way you believe this legislation can empower older foster youth who are at risk of aging out of the system? And feel free to answer in any order. If you could push the button so your mic is on.
What I'll say is a lot of older youth are staying in the system, as she mentioned, purposely for services. If you affirm a youth to say, this is where I want to go, this is where they're ultimately going to go when they're 21 anyway. It's been proven, like when you turn 21, it's a lot of places that you could not go when you were in care, a lot of homes that you couldn't be in because of different licensing.
Can you say more about what do you mean youth are choosing to stay in the system?
Because basically we're choosing to age out. Like I did the same thing. I'm speaking specifically because I was one of them. I specifically chose not to do adoption. I already knew adoption wasn't for me, so I aged out in independent living. I didn't even want a foster parent. I didn't want to live with anybody. I didn't want to be around anybody else, but I needed the services. I needed FUP. I needed insurance. And I turned 28 in a few days and I still have it. These are things that I needed because without it, I did not have a community to lay the foundation for me. I needed help. So I stayed in foster care when I could have aged out. I mean, I had jobs and different things like that to get apartments, but I needed the services part. And part of it was I didn't even know how to apply the services. You gave me a voucher, but didn't even tell me that I had to apply to apartments and not even knowing which ones I could apply to. This is why you need community. This is the reality of where we have kids choosing, like, where am I going to go? Where am I going to be? What am I going to do?
And as part of the challenge with adoption, that you don't have a choice in the matter?
I think it's twofold, right? I think when you're older and you're in the foster care system, is adoption present for you? Like, is it something that they're pursuing for you or you're pursuing for yourself? Even if your goal is adoption at a certain age, is it realistic for you or the families that you're coming and sitting around at a certain age personally? And I know people who've been adopted at 30 years old. I'm not saying that they're wrong or their family didn't care about them, right? That's not what I'm saying. But I'm saying that situation doesn't happen a lot of times for most of our youth.
Understood. And Princess, you wanted to jump in?
Yeah, I wanted to speak a little bit just about like what you necessarily mean by like a choice. So youth can choose to emancipate at age 16. You can choose to emancipate yourself from the foster care agency at 18. But oftentimes they do choose to stay within the agency because let's say like you're like Olivia, you go, you get adopted, everything's going well. But then what happens when things don't? What happens when you get into a really big argument or fight or something with your, chosen family and you don't have any of those services. You don't have any of those supports. You don't have anybody you can turn to. It's between you and whoever you living with at the time. And especially like when you're even faced with being in somebody's foster home, you're at their whim in a sense, because you don't necessarily get to make any real decisions for yourself. You didn't get to choose that foster parent. You don't really get to choose how long you really get to stay with them. When you age out of 21, that's solely up to you or between you and that foster parent, whether you get to stay there or not. Even when you get adoption finalized, they can still choose to kick you out and say, hey, well, on paperwork, you're my family. So the choice is somewhat of an illusion. So they choose the lesser evil, what actually gives them the most control, the most sense of power to be able to choose what happens to them in the future. And, of course, like we've been consistently reiterating, with Soul, you won't have to choose between those services and supports. You'll be able to have that autonomy of family, and it won't just be you and whoever you're living with. It'll be whoever you choose to be a part of your soul family, and they will all have legal ties to you, and they will all be able to support you. And not only that, but to be able to say, we're not just going to throw you in somebody's home and say, go figure it out for yourself. To be able to say, we're going to help you navigate the system. We're all going to help support you, and we're all going to be having your back. So that way you never feel like you only have one choice.
Understood. Well, I want to say, did you want to jump in? I'm being really lenient with the clock, but that's only because I really appreciate the work that you all did to draft this legislation.
I definitely believe that most youth decide to age out due to the fact that they feel like they cannot create a new family or a new family dynamic. And I can speak from experience myself. I have seen so many children decide that they want to age out only because of the fact that they don't think that the person that they're living with, whether that's your foster parent or the person you're doing guardianship with, or your adoptive parent, is going to completely take that role of your birth parent. And I could say for myself, I feel like I have to age out because I know that I will never really be able to find that relationship that I have with my mother, or the relationship I'm supposed to have with my mother, with my foster parent at the moment. So I don't know. I just feel like when you have a normal relationship with like a child and a parent, there's certain things that are expected. And I just feel like a lot of kids don't feel like that is guaranteed. And I feel like that's why they kind of shorthand themselves of creating that relationship or even being dependent. And that's why they look towards these services instead of trying to find a foundation within these other people.
Makes a lot of sense. One other quick question, if you could just answer briefly while I have you. What I hear you all talking about is to improve youth well-being in the within the foster system through the SOUL Act. There's a lot of discussion generally around young people across the district. What should we as a government be thinking about or doing, not just for youth in the system, but just young people in general? I'm thinking of, we just acted on the youth curfew. I'm not asking you to weigh in on that, but what's top of mind is youth well-being. Thoughts, reactions, what should we be doing?
I believe that we should be informing youth of their rights and generally just educating them on what they're entitled to, what supports are available to them, and what outlets are available to them. I cannot tell you how many times when I was a teenager, oftentimes my friends and me, we would get into trouble simply because we had nothing else to do. Like, not to get too nitty gritty, but I literally became a stripper because I was bored and I was getting kicked out of my foster mother's house. And literally, there was like nothing else to do. I would try to go to the library, and they said because I was 18 that I could not go to the library before 3 o'clock. But my foster mother was kicking me out at 10 o'clock in the morning, every morning. And every night she would say, you can't come home. And I decided to go to a strip club because when I would ask around what other, what other services are out there, what other, things are there to do, whatever activities are available. And I kept using the money I earned from that to get my own hotel rooms and to house not only me, but several of my other friends who were not in foster care, but that were also same age as me, getting kicked out of their homes, having nowhere to go, laying in Union Station, laying on sidewalks and benches, and that would dance on the street corners for money because they had absolutely nowhere to go and absolutely nothing to do. I'm not saying that the end all be all will be okay when they are aware of their rights or when they know what rec centers to go to, or even if you point them to the right services and supports, that'll be the only answer. But it is a huge answer and a huge step in the right direction. Oftentimes I ask teenagers, like, why do you destroy this? Why do you go there? Why do you do that? Why do you feel the need to stay house away? Because they have nowhere to go, because they have nothing else to do, because they have no one supporting them or saying, hey, instead of going to go and learn how to roll a J, how about you learn how to do some robotics? How about you learn how to take these chess classes that are free at the library? I literally went to the library the other day just to go work on my testimony, and I was stumbling trying to find the bathroom, and I literally came across this program called Dream Lab, and they literally offer 3D printing classes, Cricut classes to teach you how to make your own stickers and whatnot, teaching classes on how to do audio and visual. You have so many young people out here that want to be rappers, and you can literally learn the audio and visual tech and become the engineer, become the owners, become so much more than what is initially offered, but they do not know, they're not aware of what is actually available. And that was like 5 minutes down the street from the strip club I was working at.
Understood.
And nobody told me that. It was there.
Understood. Thank you. I didn't want to have young people here and not take advantage of the opportunity to ask about what's top of mind for all of us in government. I'm going to turn to my colleague, Councilmember Pinto, for a round of questions.
Great. Thank you, Chairman Parker, and thank you all for being here today and all of your extremely important work. And congratulations on putting this bill together. And as far as we've gotten, it is a real testament to all of your courage and intellect and commitment to making improvements for the system for everybody. And so thank you very much. I guess just following up on that conversation around making sure young people are aware of the opportunities and the programs that we have in DC. What is the best way to reach young people with that information? We try to do some education with our schools. We post things on social media. I think we need to do more of, flyering in various communities, but how should we be getting the information to where it needs to go?
I think social media is also a good place, and maybe actually like going out to people personally, like not just doing social media, like how we are interacting today. I think you guys should actually like go to like different wards. I'm in Ward 8. I don't see a lot of people trying to see things like they could do for us or how they can help us. For me, like how I like stay out of stuff. Honestly, I'm in band. I go to Baloo. That's kind of what I do, and I notice all the time, like a lot of people don't, have anything to do after school. They go roll J's, like Princess said. They don't do anything. So I feel like if y'all just went to schools, if y'all actually like stayed, you know, like going to other schools, things would like probably change. And not just being like on this side of town, actually going like to the south side or something else.
Mm-hmm. Okay, go ahead.
I just want to note that children are going to be children regardless. And I do feel like even if things were on social media, I feel like teenagers or young adults probably wouldn't look directly towards that due to the fact that, like I said, kids are going to hang out with their friends after school and they're going to do certain things that they want to do, whatever their piques their interest. I personally felt like when I was like younger, I would usually find like most of my activities from either my social worker or my GAL or even my foster parent in general. And, I feel like especially if you have some type of relationship, that those type of people can suggest certain things that you might want to do. They can even do those things with you. And I feel like, that would also help as well. So.
Thank you.
I just want to briefly state, I think also getting the adults to engage with the youth, not just saying, here you go do this, get out my face. I cannot tell you how many times my fiance's son, he do not want to read books at all. He will not read, but let me read it in a funny voice, or let me read it with him, or let me, actually allow him the time to sound out the words, or even let me throw in a couple of funny terms like 6, 7 in there. And it'll engage him because that's something he can relate to. A lot oftentimes, nobody knows what it means. Like, honestly, it's just a coin term that like, being able to like get it caught your engagement though. Look, see it, stuff like that. It caught everybody's engagement. Now everybody's let me pay attention because that's a term that everybody has heard. That's a term that kids have popularly, socialized on social media. Being able to have those little fun interactions and stop putting up these barriers like, I'm above you, I'm separate from you. You all used to be our age at some point or another. And now it's your job to be able to maybe turn the hands of time backwards just a little bit and actually engage with the youth. Actually, take off the suits a little bit and throw on the sneakers and be able to say, we're not just going to tell you, go do this, get out my face and go be a productive citizen of society, but to be able to say, we are the society and we are one. And we need to stand together as one, not as separate entities that stand as a pyramid scheme, just trying to topple each other.
Thank you. Go ahead.
I'm a mom, so I will say, I want to say one thing, representation is very important. You don't see enough people in our neighborhoods doing good work. If you want somebody to do good, you have to show them that there's good to do, right? I'll say my brother just got sentenced to 24 years, and I don't want anybody that's in the system or not to have that same fate. There has to be something done. And I'm not saying that there isn't supports out here that are available, but you have to affirm a youth enough for them to want to do it, to be honest with themselves enough to change and be something different from their reality. We have to do something.
Very powerful. Thank you. Thank you all very much.
Thank you for your testimony. Thank you.
Thank you.
6, 7. I'm gonna have to add that to my list.
I'm so happy that 6-7 is now officially becoming part of the legislative record, which will live on in history
Yeah.
for all time.
Yeah. Learn something new every day. All right. Susan Punnett with the Family and Youth Initiative. And then Ernest Elliott with the National Center for Children and Families, Jasmine William Ashford from the National Center for Children and Families, and Sharika McCarthy from the National Center for Children and Families. And you may begin.
Good afternoon, Chairman Parker and
if you can really try to speak into the mic. Awesome.
good afternoon. My name is Susan Panett. I'm a District of Columbia resident and Executive Director of Family and Youth Initiative. For 15 years, DCFYI has been connecting teens who are in foster care with adults who make a commitment to staying in their lives. We believe that every person, and especially every youth who happens to be in foster care, deserves family, however they define that family. We're proud to have introduced many teens to the people who become their adoptive families and to have connected many other teens with adults who have remained in their lives through foster care and into adulthood. Often young people think of these adults as family despite having no legal relationship. We are strong believers in adoption, especially for older youth, and will continue to ensure teens who want to be adopted have every opportunity to meet adults who could become their families. We also understand that many teens are not open to adoption, often because they don't trust the system to find them a new family, they don't trust adults enough to allow one to become their new parent, they're worried about losing services when their case closes, or they don't want their legal relationship with biological family to be severed by a termination of parental rights. What we have never heard a young person say is that they don't want the benefits that come from having a permanent family. A place to belong, people who will cheer you on, support you as you make life choices, help you figure things out, walk you down the aisle, be a grandparent to your children, and love on you always. The problem is not that youth don't want family, but that the processes designed to create new families for children in foster care are adult-driven, not child or youth-driven. SOUL is the first type of permanency that is both youth-designed and youth-driven. SOUL will allow youth to achieve permanency without having to choose between services and lasting relationships, and without having to choose between maintaining birth family connections and building connections with a new family. The District of Columbia can be the second jurisdiction in the country to enact this innovative approach to permanency that addresses the reasons many young people do not currently achieve permanency. Having SOUL as a permanency option will reduce the number of youth who age out of foster care. It will also ensure more youth have the love and support of family now as they enter adulthood and for the rest of their lives. For the last 2 years, DCFYI has worked with and learned from the insightful group of lived experts or LEX leaders who are leading the design of SOUL. We have all been impressed as they have brought their personal experience of being or having been in care to the process of designing a DC-specific version of SOUL. As they have learned the legislative process, drafted legislation, now drafting regulations and creating policy as we continue to work toward passage of this legislation and implementation of SOUL. I urge the committees to listen to the LEX who you've heard from today and the testimony that others are submitting and make the changes they're requesting so that SOUL will be even stronger and better aligned with their vision. Creating SOUL has been a collaborative process, including the lived experts, staff at Child and Family Services Agency, the Office of the Attorney General, and Children's Law Center. In addition to helping more youth achieve permanency, we believe this collaborative work will create practice changes that will result in better outcomes for all youth who are in foster care. And best of all, implementing SOUL will not cost the District of Columbia additional money. There will be some upfront costs, but over time, SOUL will save money. CFSA spends more money when a youth is in foster care than they spend on youth who have achieved permanency, including through SOUL. A fiscal analysis conducted in 2024, when we were still early in the design phase, documented that the costs associated with implementing SOUL would be more than offset by the cost savings of youth leaving foster care. While those numbers might look a little different if revisited, the bottom line remains that it both costs less for a youth to achieve permanency and that achieving permanency is a better outcome than aging out of foster care. In closing, we look forward to working with you to moving SOUL legislation so that more youth can leave foster care to real permanency, meaning they will have the family that all of us need and deserve. Thank you for the opportunity to testify.
Thank you for your testimony. Next, we will have Ernest Elliott.
Good afternoon. Okay. Good afternoon, Chairperson Parker, excuse me. Thank you for allowing me to provide testimony in support of the SOUL Amendment as a social worker at the National Center for Children and Families, otherwise known as NCCF. NCCF is a nationally accredited child and family serving organization with programs in the District of Columbia, Maryland, and Virginia, and the primary private provider of family-based foster care in DC with partnership with CFSA. Everyone here today who believes in foster care also believes that families can form differently. Being related by blood isn't necessarily the only way that family finds each other. We recognize the importance of fictive kin and other essential members of the village that it takes to raise a child for many years. So then why should we not explore these same principles when reevaluating adoption and guardianship for youth? We don't want children languishing in care. If we don't want children languishing in care, which we don't, we need to explore new and creative ways to approach permanency for youth in DC. NCCF supports the SOUL Act as an important progression for moving youth safely out of public systems and helping them transition into successful adults. In my role at NCCF, I have worked with many teens and young adults and seen just how difficult it is for them as they get older and they want more independence. This is a time developmentally when youth are supposed to be separating themselves from their caregivers, and guardianship and adoption is not always an ideal resolution. Placements such as these are not as appealing to someone who is 18 years old and ready to go about and be economically stable. Youth are tired, are always having to do what other people say and want to finally have control of their own lives. In fact, placements can cause them to lose access to crucial economic and educational supports at a time when they may most need them. Adoption can cause a youth to lose access to housing assistance opportunities, Medicaid, and an in-state public school tuition rates outside of the district. So will allow these youth the flexibility to choose who they wish to be a part of their lives and who will help guide them into adulthood. It will allow youth to include their blood and non-blood relations to the level that is best for them. It will allow youth to continue to receive crucial supports that they need and divert them from non-positive methods of earning income. So is also particularly important when considering the cross-jurisdictional dynamics specific to this region. Although Maryland is often referred to as the district's Ward 9, the laws governing permanency and licensing can look quite different and create unintentional barriers for adults who want to play a caregiving role in the life of foster youth. These people may only have one bedroom in their home or have a possession charge from a substance that was illegal 25 years ago and are unable to meet any of the regulations that are required by the state, but they still have a deep invested interest in the welfare of the child. With SOUL, these caregivers can be allowed to step up and participate at the level best suited for the individual child, which is a net positive for all involved systems. I'll be happy to answer any questions you might have, and thank you for the opportunity to provide the testimony.
Thank you. Next, we'll have Jasmine William Ashford.
Thank you. Good afternoon, Chairpersons Parker and Pinto. Thank you for the opportunity to provide testimony in support of the B26-0339, the Soul Amendment Act. My name is Jasmine Williams Ashford, and I am the Youth Services Coordinator at the National Center for Children and Families. What I would like to discuss today is how important the SOUL Act will allow our youth to be able to take the initiative to create the family that they desire, but also important to allow those that they identify as most important to them, and we are supporting them in that direction. Children are penalized for returning home and not being in the placement considered illegal placements, puts on a mercilessly unnecessary label, non-compliant when they just want to be loved and cared for and seen. I also want to mention the importance of how this act will allow the youth to have a voice, because youth are always being told what to do, and it kind of creates the dynamic of them being seen and not heard. But this act will do the exact opposite. And lastly, I just want to thank you once again for the opportunity to provide my testimony today.
Thank you. Next, we'll have Sharika McCarthy.
Good afternoon, Chairperson Parker. So my name is Sharika McCarthy. I am a Kin Network Specialist at the National Center for Children and Families. And of course, I'm testifying in strong support of the Support Opportunity Unity Legal Relationship Amendment Act, because I've seen firsthand how current laws make it difficult, sometimes impossible, for youth to remain connected to their families who love them the most. Every day I work with relatives who agree to open their homes and their hearts to children in care. Those are grandmothers, aunts, uncles, older siblings, mentors, and family friends who step up during crisis. They want to provide stability and love, but under the current system, too many of these caregivers are faced with challenges to become a foster parent for their own family members, who they would naturally care for if the government were not involved at all. This SOUL bill changes that. It's groundbreaking. And that's because it finally centers family preservation in a culturally competent way. From my experiences, families are too often separated because of poverty, bureaucracy, and bias. Birth families are faced with barriers like complex licensing rules, background check hurdles, and inconsistent financial support. These obstacles disproportionately harm Black and Brown families who already carry historical and emotional weight of over-policing and the legacy of policies that have long criminalized rather than supported family resilience. The SOUL framework is a healing model. It acknowledges that belonging and identity are not legal technicalities. They are protective factors. When young people maintain ties to their family and community, their outcomes improve across the board, whether that means fewer placement disruptions or stronger emotional health. This bill also gives back power to the youth. It allows them to define their support network and participate in legal decisions about permanency. I urge the council to adopt the sole permanency option to ensure that implementation is equitable, accessible, and culturally responsive. That means providing outreach and support for kinship families to understand and access this option, much like they were saying before. They don't know about opportunities, making sure that equally they know about SOUL, just like they know about adoption and reunification. Ensuring that staff are
If you can make
trained.
your
in-
last point as your overtime.
Okay. Ensuring that staff is trained in trauma-informed practices, making sure that there are no financial obstacles as far as like adequate and timely payments, and lastly, collecting data to measure how these new options help keep families together. This is not just legislation; it's liberation.
Thank you for your testimony. I have just a few questions. Ms. Panett, you talked about the cost of the SOUL legislation. Can you elaborate and where you're coming up with the figures that it would be half of what foster parent would cost the district?
They're not my figures. There was a fiscal analysis done by a national organization that CFSA and others were fully involved in that costed out what are the upfront costs in terms of additional staff that they might need to hire, the SOUL coaches, paying for that, other services that the district government might have to pay for because the decision to allow young people to continue to have access to services that youth who are aging out would potentially be an added cost. And then what's the cost of placement for a young person who's in care versus what's the cost of a subsidy that is paid to a family when a child or a youth achieves permanency. So there is a fiscal analysis that was done. It was done in 2024, kind of early 2024. And I don't think there's been any discussion about revisiting it. It probably should be, but it's not mine. So I don't know that I can say that I can share it, but I don't see any reason that it couldn't be shared with you.
But the headline there is that
I actually had it on my phone. I had pulled it up. I mean, the headline is that the first year there is a net cost to the government, and in subsequent years, obviously this is based on projections of how many youth would achieve permanency, but the net fiscal that was calculated was the first year a cost of $51,000, the second year a savings of $315,000, and by year 3 a much larger savings.
That's significant.
Yeah.
What is your understanding why the government didn't move forward with this? Like, I'm happy to introduce it. I'm happy to work with you all. We've met several times. I think the Lex leaders are brilliant, as everybody here can attest. I still haven't quite been able to figure out why haven't we moved forward with this before?
I assume it had to do with the fiscal situation when the 2026 budget was being
Understood.
discussed, which was a lot worse than I think it is right now, but.
Okay.
Yeah.
Thank you. And for the three of you from the National Center for Children and Families, what are some of the challenges you've seen with older youth at risk of aging out of the system that we're trying to address by this legislation?
So prior to being a Kin Network specialist, I was a case carrying social worker. And in my time there, I can think of 5 youth in particular who would qualify for this SOUL goal. And only out of the 5, only 1 of them achieved permanency. 4 of them aged out without a true plan or place to go. And so this gives them an opportunity to go back to the family they love. Like my colleague was saying about how like the kids are penalized for being in illegal placement when they go back to their neighborhood and they want to, go see auntie, but you can't go to auntie's house because she's not a licensed foster parent, right? And so it kind of helps with that over policing. I know that the government just wants to do right by its residents. However, sometimes our children get sucked into a system where they go from being the victim to being now in a place of blame. And so I think what SOUL does is it works more collaboratively and it holds, folks accountable for providing that natural loving system that they would do anyway.
Awesome. Thank you. I'm going to stop there for the sake of time, but thank you all for your testimony. And I'm going to call our next panel of witnesses. And apologies in advance if I mispronounce names. Najiba Halimi with Foster and Adoptive Parent Advocacy Center. Tammy Warasinga Kote with the Children's Law Center. I swear I mispronounce that every time. Catherine Piggott-Took with the Children's Law Center, and Delia Allen. And you may begin.
Good afternoon. Thank you for the opportunity to be here and present and testify today. My name is Najiba Halimi. I'm the Executive Director of the Foster and Adoptive Parent Advocacy Center, or FAPAC. So to begin, I just want to say FAPAC represents and supports foster, adoptive, kinship, and families and youth aging out of foster care. The first thing here, we definitely support this legislation. We're so excited to see it go this far. And I just want to share, I was going to read this whole thing, but you guys have this, and I just want to share my personal story. So I grew up in foster care and I aged out. And just as those other young ladies told you, I chose not to be adopted because I didn't want to lose benefits. I went to college, I had all the good things that a college campus offers, but I found myself without a family. And I'm a little nervous about talking about this part, but it wasn't until I was in my 30s that I realized I didn't have connections. So I went back to people who mattered to me, and I created my own family. Now I spend Christmas in Ohio with family. I spend Halloween also there. I spend Thanksgiving with another family in Loudoun County. None of these people are related to me. None of them are legally ever involved. They're just people that I've created. And we're lucky in foster care, I think, because we get to choose our family. So I'm definitely excited about this legislation. So the other thing is, a couple months ago, you had a roundtable discussion. Two of the young ladies who came up were twins. I don't know if you remember them. And this is exactly what they needed. Right now, I got a call from one of them crying, I want to go live with my godparent, but I can't. She's not licensed. I don't want to stay in this foster home, etc. She needs this legislation. She and her sister do. And until that foster parent becomes licensed, or that her godparent becomes licensed, they're in an unlicensed foster homes, which puts everybody against the law, right? So it doesn't work. Also, I also want to encourage the council to consider pairing this SOUL legislation with the opportunity for youth to have progressive independence, meaning that there's specific plans for them to be on their own, to have their own apartment. But with that, you'll also need to make sure that it follows FUP, the Family Unification Program, which is the housing voucher that they receive from DC Housing Authority, because that, I think, specifically says they have to age out of care. So maybe there's some work there that can be done with DCHA. And then finally, I would say, please allow SOUL caregivers to appear in court to testify on behalf of these youth also, and to be heard in court without having to make them parties first, so that everyone has an opportunity to advocate and work together with these young people. Thank you.
Thank you. Next, Tammy.
Good afternoon, Chairman Parker. My name is Tammy Wersinga-Cote. I am the Policy Director at the Children's Law Center and a resident of Ward 4 and a parent of 3 children here in the district. Thank you for this opportunity to testify regarding B 26399, the Sole Amendment Act of 2025. CLC attorneys serve as guardians ad litem for approximately half the children in the care and custody of DC. Over the nearly 3 decades we've been doing this work, we've worked with hundreds of older youth in foster care. We have been with them through their journeys towards permanency, sometimes achieving their goals, sometimes not. We have seen the district's existing framework of reunification, adoption, or guardianship meet the needs of some youth in care, but we've also seen this framework fail our older youth clients many times. We know there are gaps in the district's existing permanency framework that result in some of our clients aging out of care and into adulthood alone and unsupported, sometimes with tragic outcomes. It is therefore urgent for the district to fill this gap by establishing SOLE as a new permanency option for older youth in care. SOLE meets the critical need of older youth in care to have an alternative to aging out by enabling youth in care to build families that work for their individual circumstances, that can be dynamic and flexible in structure, and that don't have to fit within preconceived notions of what a family should look like. SOLE offers youth that would otherwise languish in care before aging out a way to take ownership and agency in building their own futures. Although more flexible in structure than adoption or guardianship, SOLE includes important guardrails to ensure the youth's safety and long-term well-being. My written testimony contains more details, but thank you for the opportunity to testify today.
Thank you. Next, Catherine.
Good afternoon, Councilmember Parker. My name is Catherine Piggott-Took, and I am the Appellate Deputy Director and a Senior Guardian Ad Litem Supervisor at Children's Law Center. I began my work at CLC in 2012. For 4 years, I served as a court-appointed GAL for youth of all ages. In 2016, I became a GAL supervisor while still maintaining a caseload of clients. In the last 6 years, I've continued to supervise GALs, but in my appellate role, I consult on complex neglect trial level litigation, handle and supervise appeals, and work to assess and advance our long-term strategy on systemic issues. Thank you for the opportunity to testify regarding B 26-400, the Statutory Neglect Amendment Act of 2025. CLC strongly supports the proposed legislation and urges the committees to move it forward as quickly as possible. Nearly 5 years ago, CFSA became a thriving families, safer children jurisdiction, marking an intentional shift in how the agency views its role in preventing child abuse and neglect. CFSA established the 211 Warm Line as an alternative pathway for families that are struggling with poverty. So instead of subjecting them to a CPS investigation, CFSA connects them with resources and support. As part of that initiative, CFSA sought to re-examine the neglect code to determine if updates and revisions were necessary to support and codify efforts to distinguish poverty from neglect and keep families together safely whenever possible. To this end, CFSA formed a working group that met several times a month for several years, made up of the 3 primary types of attorneys that practice under the neglect statute: Assistant Attorneys General from OAG, who represent the government in neglect proceedings, GALs from CLC, and CCAN attorneys who represent both children and parents. As far as I know, this is the first time DC neglect legislation has been revised through a targeted and collaborative effort involving attorneys from all perspectives and with deep experience with and knowledge of the work. The group recommended changes that would provide clarity where the current language has proved confusing and update the statute to reflect improvements in practice over time. The recommendations focused on 2 major updates. First, they focused the statutory definition of neglect on the condition of the child, as opposed to the qualities or perceived blameworthiness of the parent. This better protects children, both from safety concerns in their home and from the harm of family separation, by keeping their condition at the center of the inquiry. Put another way, the goal of our laws should be to ensure that every circumstance where a child is unsafe or faces imminent risk in their parent's care is covered by the neglect definitions, not to target specific parental behaviors or characteristics that may or may not compromise the child's safety. Second, the recommendations better distinguish between conditions caused by poverty and conditions caused by abuse or neglect, by clarifying language to exclude cases where resources alone would enable the child to remain safely in their home, and by holding the government accountable for providing these resources rather than pursuing neglect charges against the child's parent. The Statutory Neglect Amendment Act proposed by Councilmember Parker largely reflects and honors the hard work, resulting compromises, and recommendations of our working group. CLC believes that passing this amendment would improve the district's work to keep children safe and with their families where possible. However, we've identified a few priority areas where the proposed amendment could be strengthened. My written testimony contains a complete list of our detailed recommendations, but for today, I'll focus on two of our top priorities. First, proposed revisions to 16-2301 9A2 strive to distinguish cases where the child's conditions arise not from neglect or abuse, but from a lack of resources. In these latter cases, it's important to hold CFSA accountable for providing families with a connection to resources rather than a neglect intervention. Children should not be without food, a safe environment in which to live, or education. But when children are living in an apartment without heat because of a negligent landlord, or go hungry on the weekends because their mother was improperly deemed ineligible for SNAP, they are better served by their parent being connected to a housing conditions or public benefits lawyer, or to Virginia Williams for temporary family housing, than by being separated from their parent and placed in stranger foster care and subjected to a neglect case. Incorporating a reference to the agency's existing duty to make reasonable efforts to avoid separating a child from their family, as a proposed neglect amendment does, is helpful, but we believe that adding a reference to the list of services and supports that CFSA is authorized to provide, found in section 4-1303.03813, would be even more beneficial, as it would provide further guidance for the kinds of efforts that would be reasonable. Moving to our second point, we recommend that the council remove the provision proposed as section 16-2301 9A10, which reads, whose parent, guardian, or custodian can give no satisfactory explanation for evidence of illness or injury to the child, because that conflicts with similar language in section 16-2316C, which the council has not proposed to repeal. 16-2316C, or the unexplained injury provision, is sufficient to protect children who have been injured due to abuse or inadequate supervision, but better tailored to prevent unnecessary neglect findings in two important ways. First, rather than setting up a per se definition of neglect, it allows judges to infer that a child is neglected when a parent cannot provide a reasonable explanation for an injury, while also allowing judges discretion where the parents are unable to provide an explanation, but where the injury may not be a result of abuse. Second, the proposed provision leaves out an important qualifier from section 16-2316C, which states that the child must have been in the custody of the parent when the injury occurred for the system to assign neglect. Consider a parent who drops their healthy and unharmed baby off at daycare. Later that afternoon, the second shift of daycare staff notices an injury and calls the parent. Should the daycare or parent call CPS, under the proposed 10 definition of neglect, the parent who cannot provide an explanation for the injury renders their child neglected by law, even though the injury occurred at daycare. For these reasons, we urge the committee to remove this new per se definition. Thank you for your time and consideration on this important legislation. I welcome any questions from the committees.
Thank you. That was really helpful. Dahlia Allen.
Can you hear me? Okay. Good afternoon, Chairperson Parker, Chairperson Pinto, and members of the committee. My name is Dahlia Allen, and I am a mom empowerment advocate with Mothers Outreach Network. I live in Ward 8, and I am a proud mother of 5 children. I'm here today to share my perspective as both a mother and a survivor of domestic violence. I want to begin by saying that no parent should ever be labeled neglectful simply because they are a victim of domestic violence. Abuse is not something anyone chooses, and it is not something any parent wants their children to experience or even witness. When an abuser is also part of a family support system, escaping that situation becomes incredibly difficult. Many victims, especially single mothers, face an impossible choice: stay with an abuser to keep a roof over your children's head, or leave and risk homelessness, unemployment, or losing access to childcare. For several years, I've experienced emotional, physical, and mental abuse from my children's father. Walking away was one of the hardest things I've ever had to do, not because I wanted to stay, but because I was terrified of how I would provide for my children on my own. Being a single parent of multiple children means constantly balancing survival and stability. When abuse happens in a home, a loving parent's first instinct is always to protect their children. But protection can look different when you have limited resources, no family support, or nowhere to turn. That doesn't make you neglectful. It makes you human and in need of help. That's why I believe that when domestic violence is present, the system's first response should not be to punish or separate families, but to evaluate, educate, and support. The abusive parents should be required to participate in comprehensive parenting and behavior programs to address their actions. At the same time, victims should have access to financial assistance, safe housing, childcare, and trauma-informed counseling. These supports can make all the difference between staying trapped in an unsafe situation and building a new stable life for their children. Labeling victims as neglectful only deepens their pain and adds to the trauma that families already face. What we need are laws that protect, empower, and heal, not ones that punish people who are already doing everything they can to survive. Thank you for giving me the opportunity to share my story and speak on behalf of families who are often unheard. I hope my testimony helps inspire policies that truly protect children by protecting the parents who love them. Thank you.
Thank you. Najiba, I really appreciated your recommendation to look at the housing vouchers provided to older foster youth that are aging out. I've heard testimony that there are already some issues with that program, namely whether or not foster youth can actually use the voucher in enough time. But that is something I'm taking to heart and we will include in our markup. I also wanted to come, Ms. Piggott-Took, you gave several examples of ways in which the neglect code could be strengthened. We've heard testimony from some that says the reasonable efforts clause should just be stricken from the statute altogether. It seems like you're suggesting to keep it in, but to give examples in order to clarify. Is that fair?
Yes.
Why should we not strike it all together? Or do you think it would be fine to strike it all together? That phrase, reasonable efforts on the part of CFSA.
We'd like to keep it in. We think it's really important for this bill to hold the agency accountable for providing these services. And we think that including this language guides judges as to what they can look to for what would be a reasonable effort to support families, keep families together. So we think that guidance will help courts.
And I heard from Acting Director Torres Trice earlier that the reason they're recommending to strike it is because it conflicts with another part of the statute where there is another reference to reasonable efforts. Do you have any thoughts or reaction to that?
It actually doesn't conflict with the other subsection. It repeats this, it references back to the subsection. So for us, it's a helpful reminder and helps keep courts focused on that provision that exists as a guide to evaluate what supports families are getting. So it's not a conflict.
Got it. That is helpful. Ms. Warasinga Kote, you highlighted some of the concerns with SOL as introduced. Can you elaborate a little bit more on the context for those concerns? Yeah, I'll leave it.
Sure. I think my written testimony identified a few concerns. Is there one in particular that would be most helpful? Or I can run through the top four.
There's four. Yeah, why don't you run through the top four?
Okay, so the first one that we flagged for the committee that some of the Lex leaders had also mentioned was a change in the draft for when the youth, so the legislation empowers the youth to file the motion to initiate the SOL proceeding. That's really important, again, for the youth having ownership, agency in the process. Part of that is identifying if any of the other parties to the case disagree with the decision to move forward with a proposed SOL family. So parties to the case, meaning the AAG, the GAL, if there are disagreements, those parties don't agree, that the youth has to identify. The legislation as proposed also asks the youth to explain why that other party doesn't agree or doesn't support the proposed SOL family. We'd like to see that burden shifted to the adult party who has the disagreement to explain the reason and the basis for their disagreement. That's one important change. Another one is the draft legislation currently makes SOL supporters full case parties. And that was an issue that the Lex leaders and the other stakeholders talked about a lot. Who should be a party to the neglect to the sole proceeding? And you know, the becoming a party to the proceeding means that you have access to the entire case file. So the entire neglect case file, which I know you've talked about a lot actually today, about how much information is in there, all the different types of records that are in there, and how it goes way back into the history of the case. And so where we landed as a stakeholder group was that while it's important for sole supporters to be full members of the proceeding going forward, so they need notice, opportunity to participate in all the court proceedings, that it's not necessary for them to always get full information about everything that's ever happened in the life of the neglect case. Yes, for caregivers who are taking on a larger responsibility, but not for sole supporters who may be playing a smaller role.
And who would make that determination of who and when they get what information?
So if you were to put it back to only the caregivers or case parties and sole supporters get notice and opportunity, then the family court would retain jurisdiction and discretion to either at their own, motion, add the sole supporters as full case parties. So if the court is looking at the situation and saying, you know what, I think this person actually needs the full information, or if another party feels, I want this sole supporter to have full information, they can make a motion to the court to say, in this instance, can you make the sole supporter a full
Understood.
case party?
That's helpful.
And then the other top priority I would flag is in the discussion, in the part of the legislation that outlines the adjudicatory proceeding for forming sole families, the draft legislation adds a line around the family court may direct the agency to enter into evidence a background check of relevant background information. And this we were concerned that this provision the courts will read it as a requirement that they should be always asking the agency to enter into evidence background checks. And while we fully expect that the agency will be doing background checks of potential sole family members, they will be doing a vetting process to make sure that the people in the sole family are safe and appropriate caregivers for the youth. Putting those records into the court record will again give everyone who's a party to the case full access to all those records. So putting someone's entire background check into the record for everyone to see is kind of a big deal. There's a lot of personal information, a lot of private information. It's not something we require for any other permanency proceeding.
And I would imagine it may make me less likely to want to do this.
Exactly.
If I know I'm going to expose this information to other parties. So that's a really good point.
Yes.
But let me clarify, you are supportive of CFSA doing the background check. It's about having them on the court record. Is that fair?
Absolutely.
Got it.
Yeah.
Okay. Thank you. And then Ms. Allen, you're taking issue with the neglect statute, the provision regarding exposure to domestic violence.
Yes.
I take to heart your testimony, really, truly. And again, I want to clarify, it's not that a victim of domestic violence who has a child, we're advocating for the child to be separated. That is not what this is saying. In fact, it was clarifying earlier that it seems like our intent is aligned with the status quo that we are putting in the code, which is essentially to say, if you are a victim with a kid and you are suffering from domestic violence and are not taking reasonable steps to remedy that situation, whether that be to leave, to seek protection, to remove the kid from the home, then that might be grounds for neglect. I appreciate you said something about we shouldn't victimize people who are already victims, and I'm really sensitive to that.
Yes.
Can you just speak to I don't want to say the harm of exposing a kid to domestic violence, but what are some of the nuances that we should keep in mind as CFSA investigates cases where a young person is seeing mom, for instance, being attacked on a daily basis?
Yes. So, as a mother, I am aware of the emotional trauma that a kid can experience by seeing domestic violence on a daily. However, like I said, when that
abuser is your support system outside of your own family or your community, it becomes a hard thing to walk away from, because you have to make the decision like, am I going to stay with this person and deal with the things that I'm dealing with? Or am I going to sit at home, not be able to work, not be able to pay my bills, not have no support, and possibly not be able to feed your children because you don't have that extra support? So I'm all for protecting the children, but I feel like CFSA, when they come in, they more so try to scare you and make you seem like the bad person for being a victim. And they do not come with resources for you.
But I'll challenge that a little bit. I'm sensitive to what you're saying, but I don't think we would say that if we substituted domestic violence for sexual assault. We wouldn't say, yes, the kid can stay there even though we know they are being exposed to sexual assault.
No, what I'm asking for is more support, so that way it could be easier for the victim to walk away. I'm not
Understood.
saying that it's right to stay and allow the child to experience that. They just need to make sure that they're given the parent the tools that they need to be able to be financially or mentally stable for them and the children.
And that I agree with, that we need to continue to double down on efforts to support individuals who often happen to be women when they are in those instances of domestic violence. So thank you for your testimony, and thank you all
Thank
for
you.
your testimony. Next, we will have Tyler Dukes, Stephanie McClellan with the DC Kin Care Alliance, Kelly Fong, and Michelle Bortley Gore. Tyler Dukes, are you Tyler? Why don't you get started while we are, oh, two are virtual. Okay, well, since two are virtual, I'm assuming virtual, we have Kelly Fong and Michelle Bortley Gore. Is that right? Okay, so Angel Brand and Yasmin Holmes. And Tyler Dukes, you may begin.
Good afternoon, Chairperson Parker, Chairperson, oh, she's not here, and members of the committee. My name is Tyler Dukes. I'm a mom's empowerment advocate with Mothers Outreach Network. I was raised in Ward 1, but I now reside, no, I was raised in Ward 5, but now reside in Ward 1. I'm here to testify about the B 260400, the Statutory Neglect Amendment Act of 2025. When I lost my job in 2021 after the birth of my second son, my life changed drastically. I found myself at food banks and diaper drives to help make ends meet. I'm testifying today because I believe B 260400 should update its definition of neglect. Lack of stable housing and financial shortcomings should not be the sole reason for child neglect, especially in the event that the issues with basic necessities can be explained. Separating a child or children from their home can possibly cause mental issues for both parent and child or children. And even though I've never had any of my children removed from my care, I can only imagine the agony and suffering that both parent and child or children endure. In closing, I would like to commend the chairpersons and committee for moving partly in the right direction, but I still believe families in need should be supported instead of causing unnecessary CFSA cases. Thank you for your time.
Thank you for your testimony. Next, we will have Stephanie McClellan.
Good afternoon, Chairperson Parker. My name is Stephanie McClellan, and I am the Deputy Director and co-founder of DC Kin Care Alliance. I'm here today to testify regarding B 260400, the Statutory Neglect Amendment Act of 2025, and specifically our serious concerns regarding some of the proposed changes to the definition of neglected child. We believe that the proposed new definition of neglected child has the unintended consequence of giving CFSA cover to continue its current illegal practice of hidden foster care, also known as kinship diversion. Hidden foster care occurs when CFSA determines that there is abuse or neglect of a child such that the child cannot remain safely at home with their parents, even with the provision of services. Both federal and district law have taken great pains to ensure that when a government agency separates a parent and child, it may do so only by filing a neglect case and placing the child in foster care, preferably with a relative or close family friend through an expedited temporary license. But rather than follow the law, CFSA skirts its responsibility and diverts the child to live informally with a relative, which does not provide due process, services, or supports, including foster care maintenance payments. DC Kin Care Alliance has filed 8 federal lawsuits on behalf of kinship families who have been harmed by this illegal and discriminatory practice. DC Kin Care Alliance was not invited to be part of the working group that made recommendations to the council regarding revisions to this language, and we have not been able to obtain a copy of the recommendations, so we don't know the perceived problems that they were intended to address. Taken at face value, a reading of lines 28 to 42 seems intended to distinguish neglect from abuse within the neglect definition instead of having a separate definition of abuse, to try to separate a shorter-term lack of supervision out of the new definition of abandonment, and to incorporate a currently separate definition of negligent treatment or maltreatment into the new definition of neglected child. It also appears to be part of a broader effort to require a connection between the harm or risk of harm that the child suffers directly to the parental behavior. While these changes may have been well-intentioned, the result is that CFSA could use this as a pretext to engage in hidden foster care. It is because, as written, the bill provides that a child suffering serious harm does not fall within the definition of a neglected child unless that harm is due to a parent's failure to, quote, plan for or provide adequate supervision. If that is the case, the implication is that the converse is also true, that if a parent does plan for their child's supervision, even after the child has suffered, there is no neglect. It is not difficult to imagine a situation where a child is abused or neglected. A CPS social worker tells the parent that the child is going to be removed to foster care, but if the parent makes a plan to have the child go live with a relative, that child will not even be considered to have been neglected at all. That same plan for or provide language is used regarding a child who is suffering due to lack of food, clothing, or shelter, with the same implication. CFSA could use it to deny a child who has been starved the supports and services they need by engaging in hidden foster care. While our main concern is that abusive or severely neglectful parents will be permitted to plan their way out of a neglect finding, and that CFSA will deny maltreated children the protection and resources they need, it is certainly worth mentioning that CFSA could use this language in instances that we think the bill may have been trying to prevent. For example, when a mom leaves her young child at home alone for a short period and they are at risk of hurting themselves, a CPS worker could threaten the parent that if they do not agree to plan to have their child live with grandma, their child could be removed to foster care. While the Attorney General might not have chosen to proceed with a neglect case, or a judge might not have authorized a removal in such an instance, the mother doesn't know this and may agree to the diversion in a moment of distress and fear. The majority of families involved in the child welfare system in the district are economically under-resourced Black residents living in wards 5, 7, and 8, where the power imbalance between CFSA and these families is striking. We urge the council to be wary of any law that could be interpreted as allowing CFSA to act to force families to give up their children to caregivers outside of the checks and balances of judicial oversight. Thank you for the opportunity to testify today. I'm happy to answer any questions.
Thank you for your testimony. Next, we will have Kelly Fong, who I believe is online.
Yes. Hi, everyone. Hopefully you can hear me. Thank you so much for the opportunity to speak with you this afternoon. My name is Kelly Fong. I'm an assistant professor of sociology at the University of California, Irvine, and I am here to voice my support for the Statutory Neglect Amendment Act of 2025. So I come to this conclusion from over a decade of experience conducting in-depth multi-method research on the front end of the child welfare system. I've received a PhD in sociology and social policy from Harvard University, and my book, entitled Investigating Families, Motherhood in the Shadow of Child Protective Services, traces how conditions of poverty too often entangle families in the child welfare system, especially families of color and low-income families, in ways that actually exacerbate families' challenges. I also serve on the Evaluation Advisory Board for the Opportunities for Prevention and Transformation Initiative, where DC is one of 4 sites that were selected for the innovative work that they're doing around prevention work supporting families beyond the child welfare system. So as has been stated before today, poverty is not abuse, poverty is not neglect. And when we respond to conditions of poverty with a child welfare investigation, this is not helpful to families. And so this act takes the important step of clarifying maltreatment definitions to distinguish child maltreatment from conditions like homelessness, unstable housing, and public benefits receipt. So if passed and implemented, this act will improve child and family well-being in DC by reducing family stress and by facilitating positive relationships for families and the systems that aim to support them. So in my research, which I did in Connecticut, I saw many reports that were based on situations that were reflective of conditions of poverty. CPS investigators were receiving these cases and often didn't feel they needed a child protection specific intervention. They felt like issues like homelessness could be addressed some other way. And families agreed. So when reports of homelessness, for instance, can be screened in because the allegations meet statutory definitions of maltreatment, this subjects families on the edge to investigations that they find terrifying and traumatic. Families know that CPS is the entity that can take their children at will. CPS reports also undermine trust and engagement between families and the systems that are intended to support them. So the mothers that I interviewed described switching doctors, canceling social service providers, planning to change schools after these providers called CPS. Assistance often requires opening up to professionals about your needs, but parents are wary, understandably, about disclosing vulnerabilities, such as those related to poverty and homelessness, when these conditions can be considered neglect. So for instance, I interviewed a mother who had come from out of state and lived in her car with her boyfriend and her 2 young kids on and off for 6 months before they got a place in a shelter a few weeks before we met. While they were living in the car, they went to the welfare office to try and sign up for cash assistance and SNAP. But when they learned they needed proof of residency, they decided to forego this assistance because the mother said if welfare found out that they were living in the car, quote, they have to tell CPS and CPS will come and take the kids away. So instead, they endured severe hardship into the record cold winter that year. They would just turn on the car every so often throughout the night for heat. So the Statutory Neglect Amendment Act is a step towards ensuring that another family in that same situation can get the help they need without fearing a neglect charge. Ultimately, the act can make DC children safer by reducing family stress and supporting connections to important services and resources. One final respectful point of suggestion, the amended language defines neglect using the language of parental failure, quote, provided the failure is not due solely to lack of financial means. In my view, the inclusion of the word solely there is unnecessary and will inhibit effective implementation. And so rather, I would suggest simply saying, provided the failure is not due to lack of financial means. Thank you so much for your work on the Statutory Neglect Amendment Act. And I hope the council will support it to promote the well-being of DC children. Thank you so much.
Thank you for your testimony. Next, we will have Michelle Bortley Gore, who I believe is also virtual. And she is no longer with us. Next, we will have Angel Brand.
Good afternoon, Chairperson Parker, Pinto, and members of the committee. My name is Angel Brand, and
Please lean more into the mic so we can.
Good afternoon, Chairperson Parker, Pinto, and member of the committee. My name is Angel Brand, and I am a mom's empowerment advocate with Mothers Outreach Network. I live in Ward 7, and I am a proud mom of 9 kids. Today, I am testifying about the Statutory Neglect Amendment Act of 2025 because this issue affects families like mine and many others in our community. I want to share what I know about CFSA based on people I know who have been impacted. When a report is made about a problem, it is an extremely difficult situation. Educational neglect is a common reason people get cases with CFSA. This happens sometimes even when the family does everything they can to inform the correct person at the school of the reason their child has missed days, and even when the child has a valid excuse for the absence. When parents do what they are required to do, there should not be an investigation. More should be done to make sure that schools acknowledge that you notify the school of a valid excuse for all of the child's absences. We parents believe that sending our kids to school every day is important. Going through investigation by a Child and Family Services Agency is very stressful for parents being investigated, trying to prove you are a fit mother. I believe that parents need more resources. Some families need help with transportation to school. This is an urgent issue because education is important and families need help, not punishment. Families are being unjustly torn apart. Based on the experiences of people in my community that I know firsthand, I have recommendations for the DC Council. The DC Council should focus on improving the hotline and investigation training to avoid unnecessary investigations. They should improve the way they help families if they open an in-home services case for educational neglect. They should increase transparency so we know what is happening with cases. They should change laws to mandate the release of Child and Family Services investigation details to parents. This will help families like mine by keeping families together. Thank you for the opportunity to testify.
Thank you for your testimony. And then last for this panel, we have Yasmin Holmes.
Good afternoon, Committee Chair Parker and Pinto and members of the committee. My name is Jasmine A. Holmes, and I'm a single mom of 5 boys, all ages 6 and under. I was born and raised here in D.C. I live in Ward 8, and I grew up in the foster care system. Today, I'm here representing Mothers Outreach Network, where I am a Mom's Empire Advocacy Fellow and participate in the Mothers Up Guaranteed Income pilot program. The Mothers Up program has been a lifeline for my family and I. It provides extra income with no strings attached, support that helps us meet our basic needs and breathe a little bit easier. But I know it won't last forever. My participation ends in April 2026, and I already worry about how my family will manage once that support is gone. I want to thank Council Member for passing the Child Tax Credit Amendment Act of 2024, especially Councilmember Parker for leading that effort and Councilmember Pinto for supporting it. That kind of leadership gives family like mine hope. Today, I want to speak in strong support of the Statutory Neglect Amendment Act because it's something deeply important, making sure parents aren't punished for being poor. I'm especially glad the bill clarifies that homelessness does not equals neglect. That's an important step forward, but we need to go farther because families living in poverty still face deep bias and unfair treatment. Too often, financial hardship is mistaken for neglect. For example, a mother might not have the money for a toddler bed. That doesn't mean she doesn't love or care for her child. It just means she's struggling financially, yet instead of offering help or connecting her with resources, CFSA social workers often make negative assumptions about her as a mother. When they come into a family's home, they should come with compassion and not judgment. They should offer support, not suspicions. But instead of sharing that there are funds or programs that can help, families are met with cold questions and conclusions. Investigations shouldn't happen just because a parent is poor. Again, poverty is not neglect. Parents like me want to raise our children with love, stability, and opportunity. but we can't do it alone. We need a system that helps us, not one that watches and waits for us to fail. I'm asking the council to continue leading with empathy and to make sure our laws clearly protect parents from being punished for poverty. Every family deserves dignity, understanding, and the chance to thrive. Thank you so much for the opportunity to testify.
Thank you for your testimony. Ms. McClellan, I wanted to come to you. I think your testimony is compelling. This concern of providing a pretext for hidden foster care. What would you recommend the change be that we make? Because what we see as the status quo is that we have an unclear, vague statute where we were trying to parse it out. Although I hear the concern that the changes might incentivize this effort of hidden foster care or having a kid live with a relative so that they aren't formally entering the foster system.
Thank you so much for your question, Chairperson. My executive director, Marla Spinell, and I have actually been parsing this language extensively and trying to figure out a way to both address the concerns that the council and others have had about clarification while not having those unintended consequences. That's something that we have not been able to successfully come up with that language to recommend yet, but we are working on it, and we would like to partner with you to make changes that will address concerns. But it's, I think whenever you are making changes, you know, you want to make sure first you do no harm, right?
Yes.
And so we want to,
And for those, sorry to jump in, but for those watching and may not fully appreciate what you mean by hidden foster care, can you give like a 20-second primer of what is the concern and why it's something you would argue the council should focus deeply on?
well, hidden foster care is when CFSA decides that a child has been abused or neglected such that they cannot remain in their home with their parent, even with services. So the decision's already been made. This child can't stay here. What happens next? And we advocate for relative caregivers. We definitely want that child to be placed, if at all possible, with someone known to that child. But it's very important that everyone get the protections and supports and services that DC law and federal law require when that happens. What we don't want to see is a shadow system. It's called hidden foster care for a reason. It is hidden from public view. It is not tracked. It is not, there's no system of checks and balances the way there is with when a removal is done in a legally required way. So what we want is to make sure that everyone has the legal representation, there's judicial oversight when necessary, and that families don't have their arms twisted into doing something that either isn't necessary at all to begin with. It may be that a removal isn't even required, or if it is required, is done without those protections.
And we heard about the importance of those services, namely from the young people today, because if a kid is removed from the home and is formally in the foster system, they are guaranteed certain services and rights. If a young person is now sent to go live with grandma or an aunt, but not technically a part of the system, they are not entitled to those services.
That's exactly right. And in our experience with working with relative caregivers, these are folks who put everything they have on the line to be able to take in a traumatized child who's often coming to them in the middle of the night with nothing but the clothes on their backs. And when these caregivers who are living on the edge of economic security themselves take in these children, they need that economic support. And when they get that call in the middle of the night, they don't think of themselves first. They say, of course I'll take my grandchild. Of course I'll take my niece or my nephew. It's only later that the problems come up, right? Oh, how am I going to pay for a bed? How am I going to pay for bedding? How am I going to register this child for school when I don't have a birth certificate? How am I going to get benefits when I don't know this child's social security number? And that's, often when we get involved and we see the problems that happen when those checks and balances aren't in place.
Thank you. Well, here's an invitation. As we move this bill towards markup, if there are ways that you think we can do both, as you put it, trying to make our code more clear, but also ensure we're not doing harm, it would be really helpful to receive whatever written feedback you have as a follow-up.
Thank you so much. We really look forward to working with you.
Absolutely. Ms. Fong, thank you, or Dr. Fong, thank you for your testimony. I really appreciate the example you laid out about the family living in their car, to just make clear that in that scenario where a mom could have potentially sought resources, chose not to for fear that she was going to be punished, and poverty would be used as a pretext to remove her kids from her life. And that is what so many people are doing. Now, I would like to think our CFSA already has this perspective. And what we're doing is essentially codifying in law what CFSA is doing in practice, trying not to, or deprioritize, I shouldn't say deprioritizing, but not using poverty as a marker to remove kids from a household. At the same time, I take to heart what my colleague was mentioning earlier, that the flip side of that is we can't excuse valid examples of abuse and neglect simply because the family is in poverty. And I know that's not what you're suggesting, but I don't know if you want to weigh in on that side of the debate as well, or if you have perspective.
Yeah, well, first, let me share. I appreciate that perspective, and especially the idea that CFSA may already be kind of cognizant of some of these issues in their intervention. And what my research really highlights is that CFSA can go out, do the investigation, and determine, okay, this is primarily an issue of a family that needs additional support rather than, say, foster care. But that in it, and sort of close the case and get out of that family's life. But that intervention in itself is extremely traumatic, extremely stressful, and extremely damaging to families. And so to the extent that we can prevent CFSA from ever sort of getting involved in that family's life for an issue of homelessness, I think that's the direction that we want to go. I think, this parent thinking about going to the welfare office, no one reported her to child protection for homelessness, but because she understood that this could be sort of an instance of neglect, this was her fear, and it sort of created this chilling effect. And so, of course, it's not only changing the law; it's also sort of shifting practice and changing the understandings on the ground for families to really trust that this is how CFSA is going to operate. But as you're saying, I see sort of codifying it in the law, in statute, as an important part of that effort.
Awesome, thank you. Ms. Holmes, Ms. Brand, Ms. Dukes, thank you for your testimony. I always love when a Mom's Outreach Network is here because I feel like you all are bringing a level of expertise and on the ground experience that, frankly, I don't have. And I'll be honest with you, there is a level of critique in your testimony that's saying we're not doing enough or we're not going far enough, and that's at tension. And I want to defer to your perspective because I think you all are the experts. At the same time, I'm not fully persuaded on some of the points, although I trust that you know from experience. And so here's an invitation. On the matters of exposure to domestic violence, on the matters of CFSA investigations. I even took down like the recommendation to improve the hotline. As we send these bills to markup, I will sit down with you all to go through the areas that you think we should change. And if you can bring as much evidence and research, lived experience to back those things up, I'm willing to listen and potentially make those changes. And so, because I think you all are the experts, and we ought to listen to people who are impacted most by these laws. So I'll stop there. And I want to thank you all for your testimony. I'm going to turn to my colleague, Councilmember Pinto, for a round of questions.
Thank you, Chairman Parker, and thank you all very much for all that you do and your testimony today. I want to zoom in a little bit on what more we should be doing to provide resources to caregivers and the entire Soul family. Like, as we think about next steps, what additional supports would be most useful and productive in making sure that the entire Soul family and network has the supports they need? Go ahead.
In my testimony, I just, want to make sure y'all is coming to y'all decision with the utmost empathy for not only the youth, for the single mothers. Only because we don't get our voices heard a lot and we get looked down upon a lot. But a lot of the bills that y'all are coming out with, I do agree with. CFSA is just really special to me because I did go through the foster care system. And as I stated, I do have 5 boys that I fight for every day. So yeah, I just want to make sure that I'm fighting for me, my family, Mothers Outreach, and all the mothers that's in Ward 8 across DC and everything like that.
Thank you. Anyone else? Other resources that would be helpful for caregivers or anyone in the Soul network? Okay. Well, thank you all. Thank you.
Thank you for your testimony. All right, we are moving along. Patrill Holloway and Dijon Harris. I believe they are not here, but going once, going twice. We're going to keep moving. Betsy Crum with Volunteer Legal Advocates. Melanie Sandler with Legal Aid DC. The Robert Vincent Branham, a man who needs no introduction, with the Ward 5 Leadership Council Public Safety Committee. Michaela Deming, the DC Coalition Against Domestic Violence. Michaela is online. I'm going to keep going to fill up the seats. Penelope Spain with Open City Advocates. All right. And I believe we have one more seat. Josh Miller with Open City Advocates. And we will start with Betsy Crum.
Yes, good afternoon, Chairpersons Parker and Pinto. Thank you for the opportunity to testify. My name is Betsy Crum, and I am the managing attorney for the Child Advocacy Program at Volunteer Legal Advocates, formerly DC Volunteer Lawyers Project. We applaud the Council's ongoing efforts to address a broad range of issues affecting at-risk youth in our city, most recently through proposed bills we're discussing today. I'm here to talk about a category of at-risk youth that is often overlooked in these conversations: vulnerable children in highly contested custody cases. Specifically, I'd like to talk about the role of guardians ad litem, GALs, in custody cases and highlight how current statutory and policy limitations affect our ability to serve the best interests of children. In the District of Columbia, GALs are appointed under DC Code Section 16914 in contested custody cases to investigate and report on what is in the best interest of the children. Their responsibilities include conducting interviews with children, parents, and other relevant parties, observing the child's home and school environments, reviewing records, and providing the court with an independent recommendation regarding custody and visitation arrangements. GALs serve as independent fact finders for the court, helping judges make informed decisions in complex family disputes. Custody GALs are different from GALs in abuse and neglect proceedings. GALs in neglect proceedings are integrated into the child protection system and have statutory authority to access CFSA records. Custody GALs, by contrast, operate solely in civil family law cases. They do not automatically have access to CFSA records, and they are not part of CFSA's statutory oversight framework. This distinction means that custody GALs have to rely on our own independent investigation methods without the benefit of CFSA's unique insights into child safety and welfare. In 2024, our organization represented 139 at-risk children as GALs. More than 90% of those children had either witnessed domestic violence, experienced abuse themselves, or both. Many of their families have a history of CFSA involvement or include third-party caregivers. Our clients range from newborns to 17-year-olds, most living in wards 5, 7, and 8. The vast majority have endured trauma, instability, or exposure to violence. Nearly all of our cases involve allegations of abuse or neglect, and many intersect with CFSA's work. However, current law makes it very difficult for custody GALs to access CFSA records. Under DC Code Section 4-1303.06, information acquired by CFSA is considered confidential and accessible only in certain narrowly defined circumstances. CFSA routinely cites this provision when our GALs seek records or when we subpoena social workers from CFSA to testify regarding their findings. This creates a significant barrier. Custody GALs are asked to make comprehensive child-centered recommendations, but they are legally barred from reviewing the very information that may be most critical to assessing a child's safety. When CFSA has an open investigation or holds the only information about prior abuse or neglect, a custody GAL cannot access any information until the investigation closes. As a result, GALs may be forced to delay their investigation or tell the court they cannot make a fully informed recommendation, and the court, in turn, may have to decide custody based on incomplete information, as it also does not have access to this information, potentially jeopardizing a child's welfare. This tension reflects a broader systemic issue in DC family law. The court expects a full and independent best interest analysis, but CFSA's statutory duty of confidentiality prevents sharing key safety information with the very professionals the court has appointed to protect the child's interest in child custody cases. I urge the council to consider a narrow amendment to the Youth Records Transparency and Oversight Amendment Act that would permit limited access to CFSA records for custody GALs. This could be accomplished by adding a provision to DC Code Section 4-1303.06A8 to permit release or disclosure of information for an investigation by a guardian ad litem appointed pursuant to DC Code Section 16914. This approach would maintain CFSA's essential confidentiality protections while ensuring that custody GALs and ultimately the courts have access to the information necessary to protect vulnerable children. Custody GALs are vital to ensuring that the voices and best interests of DC children are heard. Without reasonable access to critical CFSA information, our ability to fulfill that mandate is limited and children's safety can be compromised. I respectfully urge the council to consider this proposed amendment. Thank you for your time and your commitment to the children and the families of the district. I'd be happy to answer any questions.
Thank you for your testimony. Next, we have Melody Sandler. Melanie Sandler. All right, we're going to keep it moving. Next, we have Robert Vincent Branham.
Greetings and salutations and good afternoon, Chairman Parker and Chairwoman Pinto. I am Robert Vincent Branham, President Emeritus of the DC Federation of Civic Associations, Chairman Emeritus of the 5th District Citizen Advisory Council, former A&C Commissioner, and a former long-term DCPS substitute teacher. Let me also say I am a service-connected disabled and retired veteran. I testify in full support of the SOUL Act. It was less than 10 days ago this council considered and passed emergency legislation which criminalized District of Columbia youth. I did not testify. I listened. I listened as adults proclaimed our children were out of control and needed to be contained. I listened as adults spoke with generational disdain about children seeking love, attention, guidance, and support, only words labeling them as hostile. I sat with sadness as adults described it was best to abandon our children. Your legislation lifts them up. As I sat, I thought to myself, I am blessed to be close to the denouement of life than the genesis. I commend both of you for the introductions of these pieces of legislation in support of district youth. I commend you both for standing in the gap to offer hope, love, direction, support, if not salvation, for the youngest of God's children. The focus of a great society and a village should be to raise a child and train a child in the way he and she should go, so when he and she are old, they will not depart from it. Young people don't just learn from what they are taught, they also learn from watching the actions of others, characterized as leaders and role models. Too often, a parent, in disciplining a child, will say, "Where did you learn to act with such disrespect and disobedience?" And the child replies, "I learned it from hearing how you and what you said to others and how you treated my mother or my father. I learned it from how you treated me." Our youth need a stern hand, but also a comforting hand. Our youth need to hear a strong rebuke, but also witness a compassionate heart. The 6 proposed legislations do not address the total circle of needs of our young people, but they help keep them out of harm's way and can loosen the grip of life's adversity, growing up and surviving into adulthood. The soul of America and the District of Columbia is in our youth. And as I end, I just want to extend my respect to the, I don't see her, the young lady on your staff who reminded me that only water was allowed in the hearing room, and so learned. Thank you.
Thank you. Thank you. Next, we will have Michaela Deming.
Hi, thank you, Councilmember Parker and Councilmember Pinto. My name is Michaela Deming. I am the Policy Director here at the DC Coalition Against Domestic Violence. We are the federally recognized statewide coalition of domestic violence service providers here in DC. I have many more statistics in my written comments, but I will share the highlights with you here. The proposals today include exposure to domestic violence as child abuse, and this has come up before in prior legislation. And while we do know that domestic violence negatively affects the well-being of children, removing options from adult victims and increasing removal of children from safe parents is also harmful. We also know that this disproportionately impacts historically and presently marginalized communities. The neglected child definition, including the phrase, when the parent has failed to take actions that are reasonable under the circumstances to protect the child from abuse, end quote, doesn't really address the concern here. Instead, it really squarely focuses all of the inquiry on the action of the adult domestic violence victim with child welfare and the court making determinations after an incident about whether or not the victim is to blame for the exposure of the children to domestic violence. Intensive training for court, child welfare teams, and counsel for parents and guardians would be imperative to even begin to understand the reasonableness of the actions of domestic violence survivors within the context of the specific abuse and violence tactics being used by the person using harm in their home. It's also notable that the reference to domestic violence in the proposed bill is not to the criminal or even the civil legal definitions of interfamily offense here in DC that would be able to be addressed by prosecutors or meet the threshold for a civil protection order. Instead, it refers to the code section that is more aptly used for the service providers in the community. So when we apply that context of labeling a child as abused and make a finding against the adult victim of domestic violence, that same adult has no legal recourse for relief, and that leads to some perverse results. I have a couple of examples. Let's say that an adult in the home is blaming the parent of the child for their job loss with the purpose of trying to influence them to pick up more shifts at work to maintain control over the household finances. Any child in that home would now meet the statutory definition under this proposed bill of an abused child. CFSA and the court would then focus on the parent of the child and the actions they took to prevent the child abuse from occurring. If the parent did pick up extra shifts to bring in additional income but didn't separate from the recently unemployed partner, then the court-ordered plan could impose the family to prevent removal of the child with required actions focused on that parent who is working in the home and taking care of the children to prevent this possible financial abuse from the partner. There's no need to demonstrate an impact on the child themselves because of the new statutory definitions. Further, if the parent in this scenario was afraid for their safety due to increasing isolation, humiliation, emotional abuse, they would still be unable to rely on criminal systems or civil systems for any relief or protection. Instead, by reaching out for help to any mandated reporter, that would trigger this potential for a child welfare response as described above, without offering any material support. So other organizations designed to support domestic violence and their families would also be more difficult to access because of this language, because of the risk for the mandated report. I will note that half of survivors, domestic violence survivors, report that child welfare reports actually made things worse for their family situation and not better. These interventions, any intervention is most successfully paired with increased accessibility and availability of well-resourced services and supports for survivors. And we support keeping all of those options open. I also wanted to pivot very quickly in my last minute here to talking about teen dating violence and the pregnancy support bill. We know that the percentage of female students in DC here experiencing sexual violence is increasing. Among youth who are dated within the past year, 70% report experience dating violence. And reproductive and sexual coercion is a common abuse tactic used to exert power and control over young victims' reproductive choices. Teen girls in physically abusive relationships are 3.5 times more likely to become pregnant than non-abused girls. We were happy to support the bill that came up last year, supporting pregnant adults, B 250914, the Safe and Supported Pregnancy and Delivery for Incarcerated Individuals bill. And appreciate the opportunity to support those investments and supports for incarcerated pregnant youth as well. In conclusion, I appreciate the Council's commitment to supporting DC's youth thriving in safe homes and communities and the opportunity to highlight domestic violence as an integral part of the conversation. We look forward to continuing to work with you across government agencies to provide wraparound support for survivors and reduce and prevent domestic violence harm. Happy to answer any questions, and thank you, Chairperson Parker and Chairperson Pinto, for the opportunity to testify.
Thank you. I am told Melanie Sandler is now online, so we will try again. And you may proceed.
Good afternoon, Chairpersons Parker and Pinto and members of the committees. My name is Melanie Sandler, and I'm an attorney in the Domestic Violence and Family Unit at Legal Aid DC. We work with survivors of domestic violence, helping them in their civil protection order cases and with family court matters. Though we do not practice directly in abuse and neglect court, we represent clients whose families have often been involved with CFSA. Given our work with survivors and with DC residents living in poverty, we can give helpful insight today on this bill and its implication on our community members. We know that the Council shares our desire to protect district families and to keep vulnerable youth with their parents. Thank you for the opportunity to speak today and for taking the time to listen to stakeholders as you consider this important topic. First, we are concerned that the addition of exposure to domestic violence as a new basis to find that a parent has abused their child puts protective parents at risk of losing their children due to the actions of their abusers. We ask that you cut this addition. A protective parent should not lose their child due to the actions of their abusers that were not done by them. We know that it can take a domestic violence survivor 7 times before leaving an abusive relationship, and that leaving the relationship is often the most dangerous time for the survivor. This provision risks exposing domestic violence survivors to findings of neglect for their abuser's behavior. In an already extremely stressful and dangerous situation, the language of this bill would put additional burdens on survivors, many of whom are already worried about losing custody of their children to their abuser. Further, DC Code Section 4-551 defines domestic violence very broadly. It even includes dynamics for which a survivor cannot obtain a civil protection order, such as emotional or economic actions or threat of those actions. If the council decides to include this provision in the revised statute over our recommendation to remove it altogether, we would strongly encourage using a narrower definition for domestic violence from Section 16 of the code instead. If the council continues to use 4-551 to define domestic violence, a parent may not be able to obtain a civil protection order, but would still be at risk of losing their child. The current statute already provides protection for children targeted by this proposed change. DC law currently states that mental injury is a basis to find abuse, and case law has said that evidence that a child was present during episodes of domestic violence can be mental injury. The statute also has a separate definition for mental injury, stating that it means harm to a child's psychological or intellectual functioning. As OAG testified to earlier, striking the exposure to domestic violence language would not affect their ability to prosecute cases that they believe need intervention. Exposure to domestic violence is too broad, and under the current proposal could lead to a survivor losing their children based on actions taken by the abuser. Survivors know best how to keep themselves and their families safe, and sometimes that means a delay in leaving in order to do so safely or to be able to leave with their children. By removing a child from their child could be at even greater risk for protracted harm. Second, we believe that the lack of financial means test should be applied to the entirety of what is currently Section 2, including the inadequate supervision portion of the law. Poverty alone should not form the basis for neglect. Poverty does not inherently mean a caregiver is neglectful. A caregiver's limited financial means alone should not form the basis of a finding for neglect. Caregivers should be given support by our community, not subjected to the breakup of their families due to factors that are outside of their control. Poverty is racialized, impacting our local communities of color at higher rates, which also increases their likelihood of contact with the child welfare system. Research shows that a low-income parent of color is more likely to be reported for abuse or neglect. That report is more likely to be substantiated, and that child of color is more likely to enter the foster care system than his or her white counterpart. Failing to include language that prohibits a finding of neglect where the allegation is solely due to financial means risks disproportionately subjecting communities of color to the child welfare system. We appreciate the council's understanding of this dynamic. The current bill prohibits a finding of neglect in some circumstances where the alleged behavior of the child's parent is due solely to a lack of financial means, such as where the parent is accused of not providing a child with adequate food, clothing, shelter, education, or medical treatment. However, this bill does not apply that same provision to failing to plan for or provide adequate supervision. That lack of financial means test should also be applied across the neglect section, both to the failure to provide physical needs and also to the failure to provide supervision. Quickly, while we're happy that the council is proposing provisions to make clear that receipt of public benefits and lack of stable housing shall not be the sole basis of substantiating neglect, the current language is difficult to understand, and we would encourage them to modify that. Thank you for allowing us to testify today.
Thank you. Next, we will have Penelope Spain.
Good afternoon, Chairman Parker and staff. My name is Penelope Spain, and I'm the CEO of Open City Advocates. Today, I'll be focusing primarily on parental engagement at DYRS. Often I come to this building to elevate the voices of the children my organization represents. Today, I'm bringing a different voice, my own voice, as a parent of a young teenager growing up in Washington, D.C. And I ask you, whether you are a parent or not, to please hear my testimony today with your parent hat on, or perhaps more apt, your parent heart. Can you imagine what it feels like to have your 13 or 14-year-old sent over 1,000 miles away by a city agency? DYRS tells you that you'll likely see your child in person once every 6 months or so, but you've never been on a plane before. You don't even have a suitcase to pack in. You've never checked into a hotel, and you don't have a credit card to present when they ask you for incidentals. You have to do all of this simply to see and hug and love on your child for a day, maybe 2. We often talk about how the juvenile justice system robs our children of their childhood. I'm asking you to think about how it also robs parents of their precious years of parenthood. A friend once said to me, you get maybe 10 or 12 good Halloween trick-or-treating years. Those years when you see your child delight in the sweetness and frivolity of community. When we lock children up or send them away, we rob not only the children of those sweet years, but we rob parents of those precious days and memories they will never get back. So if we're going to take children out of the care of their parents, denying them the opportunity to create those memories, we darn well better do it right. When we commit a child to DYRS, we do so under the doctrine of in loco parentis, requiring DYRS to, quote, act in the place of the parent. If our city is going to step into that role, we have to do our very best. So I ask you, what would you demand if it were your child locked up at the Youth Services Center, New Beginnings, or a treatment center hundreds of miles away? This isn't just legislation. It's not just policy. These are children, these are parents, and these are families. Here's what we must demand of our system if we're going to do that. First, meaningful communication. The Road Act requires parental communication at the start of commitment. It is sadly silent on any communication whatsoever after commitment begins. Parents deserve monthly outreach at minimum. If your child were locked up, would you accept going 4 months without word from the agency holding them? The parental engagement bill should require DYRS to notify parents within 24 hours of hospitalizations or emergency medical treatment, serious incidents like suicide attempts or the use of restraints. These notifications should begin with a phone call because no parent should learn their child was hurt through a letter days later. Next, medical decision-making. Committing children to DYRS does not strip parents of the medical rights for the treatment of their children, but it certainly alters their practical ability to exercise those rights. Parents must be given an opportunity to provide informed consent before psychotropic medications are initiated or dosages changed, and for non-emergency medical procedures. The bill should also specifically prohibit DYRS from asking parents to sign over medical decision-making authority. This goes doubly for out-of-state placements where we still see chemical restraints being used or standard waivers for the use of chemical restraints casually embedded in boilerplate consent forms. Third, for out-of-state placements, this bill must mandate meaningful parental access to their children. It should establish a minimum frequency at which DYRS will pay for and facilitate parental visits. My written testimony includes other recommendations regarding how to strengthen parents' involvement in team decision-making meetings, the need to expand and enhance the role of family engagement specialists, and how the agency could better respond to GPS monitoring violations and other technical violations. These aren't just policy recommendations. Each one represents a moment when a parent either gets to remain connected to their child or loses another piece of those precious years. Each one is the difference between a parent feeling like a partner in their child's rehabilitation or feeling even more distant and alienated. You cannot do this work alone as legislators, just as we as parents cannot do it alone. We must rely on our village. Let's make our village strong so that we can make our children and families healthy, well, and full of joy. I ask you today to lead from your heart as a parent or a family member, or as a leader who simply believes in the importance of parents' involvement in raising their children. Lastly, I'm happy to address any questions, especially regarding what we're seeing at Open City Advocates in our own cases and how that may reflect to current changes underway at DYRS. Thank you.
Thank you. Next, we will have Josh Miller.
Good afternoon, Chairman Parker. I'm here to talk about why independent monitoring of juvenile justice facilities isn't just helpful, but essential. While the Strengthening Capacity and Transparency Act is a valuable stopgap, it's inadequate to the needs of independent oversight, and we would again ask you to restore funding for a juvenile justice facilities monitor. Take a look at the OIJJFO's Behavioral Health Services report released last month, even as the office's funding lapsed. Independent review found no evidence that court-ordered diagnostic evaluations informed DYRS's treatment plans, despite youth having documented trauma, learning disorders, and substance abuse. It questioned whether New Beginnings was successfully rehabilitating the youth detained there, or ever could, given the lack of adequate program design. That report also found suicide precaution monitoring dropped from 100% to 21% compliance. DYRS's responses to those concerns showed a pattern. Admit no fault, promise better documentation, but don't respond to recommendations about whether rehabilitation actually works. Would DYRS have self-reported these gaps? We didn't see them in DYRS testimony at budget oversight this year, despite the agency saying in response to the report that they were already aware and addressing the issues. Agencies focused on daily operations, managing overcrowding, and staffing crises don't recognize their own systemic gaps. Independent oversight provides the distance needed to see patterns. Yet DC allowed this capacity to lapse just as it was demonstrating its value. During Director Abbott's testimony at this committee's October oversight hearing, we learned that DYRS is negotiating to acquire or lease a Maryland detention facility. But Maryland's independent monitoring data suggests this site is wholly inadequate and unfit for imprisoning DC's young people. When we researched the facility, matching Director Abbott's description, he said it was 3 miles from New Beginnings and Laurel. It appeared to be the Waxter Children's Center in Maryland. And we discovered that Maryland's Independent Juvenile Justice Monitoring Unit had documented conditions at Waxter for nearly 2 decades. That facility operated for 15 years after state oversight bodies formally recommended its immediate closure. In 2007, Maryland's Independent Juvenile Justice Monitoring Unit concluded Waxter had quote-unquote outlived its usefulness and was quote-unquote virtually impossible to improve. They recommended closure at the quote-unquote earliest possible date. The facility remained open for 15 more years. During those years, independent monitors reported HVAC failures causing mold that gave detained girls respiratory illnesses, holes in floors, water leaking through walls, the persistent smell of raw sewage, fire safety hazards so severe that the girls incarcerated there said that if there was an emergency like a fire, we would be injured because the staff can't work the keys fast enough. Maryland's own DJS secretary said in 2009 that he'd like to blow it up, but kept it open due to overcrowding. DJS director, Sam Abed, who served in that capacity from 2011 to 2023, finally closed the facility in January 2022. Here's what makes this history instructive. For 15 years, Maryland's Juvenile Justice Agency frequently contested independent findings. The secretary would respond that monitoring reports, quote unquote, contain incorrect or misleading information. For 5 years straight, they used identical language saying that monitors were biased or were making subjective recommendations. Most tellingly, DJS argued that statements from youth cannot form the basis of any conclusion for audit purposes. Let's be direct. When DJS said youth testimony didn't meet audit standards, they were saying, don't believe children. When girls told monitors that mold made them sick about smelling sewage, about fearing fire, DJS argued those statements weren't reliable evidence. This is how institutional failures can go unrecognized, by discrediting the only witnesses who see everything. Throughout those 15 years, girls lived with respiratory illnesses and dangerous conditions while agencies contested methodology. The facility only closed when political pressure made continued operation untenable. The question isn't whether agencies are well-intentioned. It's whether any agency can acknowledge its own failures without independent verification. Waxter proves the answer is no. 15 years of operation after independent oversight wanted to close it, with agencies contesting findings the whole time, proves the answer is no. If this council allows independent monitoring to remain defunded while considering legislation that shifts oversight to DYRS self-reporting, you're going to lose a very important tool that prevents facilities from deteriorating undetected. Please don't do that. Thank you for your time and attention.
Thank you. And thank you all for your testimony. Mr. Branham, I really appreciated your support of the SOUL Act, as well as just lifting up the needs of our young people. I agree. There is so much more that we need to do. Ms. Crum, I wanted to thank you for flagging this gap. This was not on my radar in terms of custody GALs not having access to information that is important for custody decisions. Why wouldn't the court be able to mandate this information? Because it seems like you're suggesting that the courts themselves don't have access to it as well.
Yes, that's correct. So the courts will sometimes call into court someone from CFSA to discuss what's going on, and the same provision related to confidentiality is cited by CFSA. So they will not, unless both parents provide a waiver at that time, they will not provide information to the courts either. So the courts don't have the information, we as GALs don't have the information, and we're all trying to make a decision about the best interests of the children without a full picture.
And you are having to conduct your own independent investigation about what's happening, which I would imagine is more manpower, more money when the information is already available.
That's correct. Also, as GALs, we are attorneys, we are not social workers, and so we don't have the benefits. A CFSA is social workers who are trained in talking to children about these issues, about abuse, neglect, sexual abuse, that sort of thing. We are trying to do our own independent investigation, and we are not social workers and don't have that benefit of that sort of training.
Okay. We heard from CFSA earlier, but I'm just going to throw this question out there. I wonder if they would be supportive of custody GALs having a limited amount of information relative to their cases. We will follow up and try and get those answers for
Thank
you. But thank you for putting this on the radar for us.
Thank you.
Ms. Deming, I wanted to come to you. I will be honest, I was a little confused about some of the examples you provided. Like, for instance, a young person whose victim parent, it seemed like you were suggesting, was short on financial resources, may now be found to be neglectful, if I'm remembering the example, but that's not quite what the bill is doing. In fact, we are saying poverty would not be a factor used in neglect findings, but if you could just elaborate, maybe you're saying there's loopholes now created where that is in fact what could happen.
Yeah, I appreciate the question, and did not mean to be confusing for picking that specific example. What I was trying to highlight is that the definition that is referenced within that provision is actually, it's DC Code 4-551. And that's the definition of domestic violence that comes from the confidentiality piece of the code around, for specifically domestic violence counselors that work in domestic violence survivor support programs. And that definition of domestic violence is really expansive, which is great for folks who work in the community with survivors. But it includes things like a pattern of abusive behavior in a relationship used by one partner to gain or maintain power and control. It includes physical, sexual, emotional, economic, and psychological actions or threats of actions that influences another person, and can consist of behaviors that intimidate, manipulate, humiliate, isolate, frighten, terrorize, coerce, threaten, blame, hurt, injure, or wound someone. And so you can see there are several pieces of that really expansive definition that, again, really meets the purposes for the code section that it is in, that can lead to some really disproportionate results if that's the definition we're using to determine that a child has been abused in the home. And there are pieces of the code that really don't correlate to any relief that could be available in the criminal code section and the civil protection order statute. So there's no relief available under those pieces because of the place that the reference to domestic violence was linked.
Understood. And is there a section of the code that you would recommend that we use?
I think that one of the options today was that there's not a reference to domestic violence exposure being a piece of the bill. If it has to remain in there, there is another section of the code that talks about intrafamily offense, or an IFO, and that is the definition that's used both for the criminal code as well as for the civil protection order code, that might fit the purposes or the intent better if it has to remain in the bill.
Understood. Final question, and I think you referenced this in your testimony. You would support us striking the inclusion of the exposure to the domestic violence?
Yeah, I think there's a lot of unintended consequences there for adult survivors and for the youth.
Understood. And I take to heart the testimony we heard earlier from the Office of the Attorney General, which essentially they are arguing we are already and can already do this. And by spelling it out in the code may actually have unintended consequences. So I do take that to heart.
If I may, council member,
Yep.
I did want to mention that two of the folks that signed up to testify today are members of our Survivor Advisory Board. They have submitted written testimony, but they would also be a source of information for you if that's a group of folks that you would be interested in hearing from.
Are they not planning to join us?
They are unable to join in person anymore, but did submit their written testimony and could be available to
Who are
meet.
those two individuals?
Michelle Bordley Gore and Dejanay Harris.
Got it. Okay. Thank you. We will be sure to follow up.
Thank you.
I wanted to come to Ms. Spain. Thank you. Your testimony resonated deeply. Essentially, you're saying we're not going far enough. We could be doing a lot more to impose restrictions. I thought I was a little beside myself earlier with the director because I too thought we were pretty lenient in our bill to just simply ask them to document what they should be doing. In your experience and engagement with the agency, what are you seeing as it relates to TDM meetings and predisposition meetings and engagement with parents?
So I will say that since the Road Act was implemented, TDMs are beginning to happen on a more regular frequency. I think that the parental engagement in those TDMs is still a point for inquiry. I was really taken aback today by the conversation regarding attempted contact or lack of contact made when attempts were made. I just want to give a little bit of context that my organization, when we started 20 years ago with a 2-person staff and still with only 6 people staff, our data systems allow us to log when we have attempted contact and not made contact.
That's right.
So the fact that we are able to do that with a teeny tiny nonprofit organization and our government agency is not able to do so is astounding to me. I think that the fact that we're asking for parental contact at the moment of pre-commitment and really don't have any metrics to evaluate the parental contact during TDMs, hospitalizations, change of placement of locations. There are so many places where parents should be involved and sadly are not. So I think that, you know, at the bare minimum, showing when contact was attempted, and if it wasn't made, that's fine. Well, it's not fine, but you know, I think just at a bare minimum, we need some quantitative data. And I can't imagine that should be that heavy of a lift. I will say that we are doing our very best at our organization to try to figure out what is happening with parental involvement, the implementation of the Road Act as well. For example, we have requested individualized rehabilitation plans for all of our clients. We have requested that information through the General Counsel at DYRS. We have received 0 individual rehabilitation plans. We have received a few success plans for our clients who are based at New Beginnings, but none of the individual rehabilitation plans, which should cover the period of commitment and what we're
From today,
striving
it sounds like maybe there are no rehabilitation plans,
I-
individualized plans.
I think that is absolutely a proper deduction from today's testimony, yes.
Okay. Thank you. I appreciated the concrete examples and how we can go even further in putting timelines and expectations for parental engagement. I would just remind folk, we have heard testimonies that parents are going to visit their kids in detention, and only when they get there, they say, your kid is not here. We ship them to Tennessee. That's wild. Or my child has been in the hospital suite for a week, and I'm only finding that out either through someone else or when I come to visit, not because the agency has contacted me. So
I would be more than happy to work with your office on all of the points of parental contact that should be made. I also mentioned disciplinary hearings when we have young people who are at New Beginnings, not for minor offenses, but maybe for a large offense, and their placement at New Beginnings is being extended by 1, 2, 3, 4 months. Parents are not being notified of that, and trying to encourage, support your child from afar via phone messages without that critical information is nearly impossible. We require so much more for our young people who are out in the community from our public schools. We definitely should be requiring that same level of communication when our young people are behind bars.
absolutely. Thank you. I'm over time, but Josh Miller, I too appreciated your feedback. I think it's safe to say you don't support DYRS trying to acquire the Wexler facility in Maryland. I think you made that pretty clear.
That's true. But I would want to draw it back to the bill that you're considering, right? What we heard from Director Abed is that when you give him the money to make a plan, it's going to be the plan you already got. He needs $30 million to unify the parole or the probation and commitment systems, and he's going to need that every year because that's what it costs the courts to do it. And he's going to tell you that maybe he needs a facility like this. And so I would ask whether that's a good use of your resources, and if it's going to take an FTE, which is what he said, to track incident data, which they've been able to do for a long time.
That's
and
right.
You can talk to Mark Jordan about this. Then why not give that FTE to the auditor or to the OAG or to the OIJJFO to do that work independently?
Yep. One more question there. In terms of the timeline to create a plan to address overcrowding, with your experience with the agency and the facility, what are you seeing in terms of the consequences of overcrowding? I felt a little gaslit today, and I think that's why I was a little bit beside myself. Like, this is not normal. It's not okay. And what are you experiencing?
So, I mean, I go into YSC every month, and but not every day. And what I see is that the staff are frustrated. I see that the young people are being broken into smaller and smaller groups that can't have contact with each other. I see that services need to be provided, or programming needs to be provided multiple times because they've got so many separations. I will draw this back to Waxter. If you look at incident data at Waxter, they had a really terrible year, the worst year ever in 2015, and it's when they were significantly overcrowded. That was under Director Abed's leadership then, and I think he knows exactly what's going to go wrong at YSC today.
Okay. Thank you all for your testimony. We're going to move on. Sharon Harris. Dankwa. I hope I pronounced that accurately. April Thomas. Melody Webb. Okay, we only have three. Salim Adolfo. Magdalena Songas, Council for Court Excellence. And Sharon Harris, you may begin. And if you could just hit the button so the red light comes on and try to speak directly into the microphone.
Hi,
Hi.
I'm Sharon Harris. I'm here to talk about the SOAR Act, this amendment of 2025. I have been through SOAR before. Oh, sorry. Can you hear me? Okay. I have been through a process with Gastonia, North Carolina, and Washington, D.C. It was a permanency act given to me in 12 months, and I was not even involved in a case of neglect. My son was kidnapped from me at the age of 3. I didn't find him until he was 12. So at this point, we need so many steps to take care that I know of. Guardian ad litem, they dropped the ball on my son. The court system, the psychiatrist, I mean, I went through every avenue you can think of through DC to show that I was sane, complete, a good mother. But the only problem is that they saw me as problematic, is that I worked too much. His father was a stay-at-home dad, but he was not a good dad. I come home, there's no food. I come home, he has friends over. I come home, there's different avenues here. When he was not going to school, I was notified. And I tried to take steps to get it done, but DC, before I went to North Carolina, DC Superior Court took my custody because they were my HIPAA right. I have been through so many trials and triumphs because now I have me and the person that had the permanency act that I have broken through Gastonia, I've broken through the whole legal system to show that I love my child and I'm here to stay. And I'm his mother and I gave birth to him, so why can't I have him in my life? He has been adopted. He has been, I have never gave my child to show that I love him and I deserve to be in his life. I had missed almost 8 years, but he is now in college. I put him in college. I get to visit him. I get to see him. He coming home for Thanksgiving. So I am very happy about that. I think the SOAR Act can save some individual lives. The people that went through what I went through, well, you're amending it. It's an amendment. I guess you already made it or it's starting to be sourced. That was my question. I'm saying my life is that. My life is the act that you are actually coming to do. Like I said, I've been through domestic violence. I've been through everything. Any avenue you want or have or is listening to today, because you understand these women have triumphed here. These men have triumphed here. They have shown you they have gotten and still have their children in their lives. And it took me 18 years, but I did that. So I thank you for listening to me. And if you have any questions, I can give you any answer.
Thank you for your testimony and sharing your very personal experience. Thank you.
Yeah.
Aqua Dankwa? Aquia Dankwa. Okay. If you could push the button so that the light is on. Yep, there you go.
Good afternoon, Councilmember Parker. I would like to express gratitude and appreciation for the bills that you have proposed and the arguments that you have put forth today. My name is Aquia Dankwa, and I'm a parent advocate with Mothers Outreach Network, an organization that uplifts the voices of parents impacted by the child welfare and juvenile justice systems. As a mother of 3 children, including one who has had contact with DYRS as a result of ongoing mental health challenges, I speak both from personal experience and a community perspective about the urgent need for accountability, transparency, and family inclusion within DYRS. Why this bill matters. B 26-004, Strengthening Capacity and Transparency at DYRS Amendment Act of 2025. Transparency at DYRS is not just about numbers. It is about trust, safety, and outcomes for youth. Parents often struggle to get accurate information about what is happening to their children once they enter DYRS custody and how they are being treated, where they are housed, and what supports they are receiving. Without reliable and consistent reporting, families are left in the dark and cannot advocate effectively for their children. Regular reporting on youth demographics, incidents, and recidivism allow the council, DYRS, and the public to measure whether youth are truly being rehabilitated and what supports are needed to improve outcomes. According to a 2022 study report by the DC Criminal Justice Coordinating Council, 92.7% of youth committed to DYRS in 2018 were rearrested within 2 years of their commitment, and nearly half, 47.6%, were reconvicted or adjudicated for new offenses. Transparency ensures accountability, identifies gaps, and guides youth resource allocation for programs that genuinely support youth development. Why family involvement and youth voices matter. As a parent, I know how critical family connection is to a young person's success. When youth feel cut off from their support systems, it deepens isolation and can worsen behavior or mental health challenges. Transparency must include real engagement with families, not just data publication, but open communication and accountability when youth safety or well-being is at stake. Equally as important is including youth as advocates for themselves, listening to what they want, what supports they find most helpful, and what obstacles prevent their growth. Youth voices must inform policy decisions, program design, and oversight. Nearly half of the youth committed to DYRS in 2018 were reconvicted within 2 years of their release, and more than 9 out of 10 were rearrested during the same period. These numbers are alarming, whether it's the 50% mentioned earlier or the 90%. They tell us that despite the district's investment in youth rehabilitation, too many young people are cycling back into the justice system. We have a clear opportunity and responsibility to strengthen evidence-based rehabilitation, reentry, and community support programs that address the root causes of this recidivism and help our youth build a stable, productive futures. I have heard from many DC parents who want to partner with DYRS, not fight it, but we cannot do that if we do not have visibility into what's happening and if youth voices are not heard. My respectful ask to the council is to ensure that the reporting requirements in this bill are robust, public, and disaggregated by gender, race, age, community, and residential placement. Add language requiring DYRS to share incident updates directly with parents and guardians, not just internal reporting.
Develop a family advisory group that meets regularly with DYRS to review data, make recommendations, and ensure parent and youth voices are heard. Incorporate youth perspectives as part of the reporting and program evaluation process so that policies reflect the needs, desires, and lived experience of youth. I will also ask that DC build a psychiatric juvenile residential facility so that youth are not criminalized for having genetic disorders or behavioral disorders. This would serve as a preventative approach, addressing mental health and behavioral crises before they escalate to juvenile justice involvement. Children's Hospital currently has only a handful of inpatient psychiatric spaces, and the criteria for admission are not always met or possible. And for children who are impulsive or in crisis, admission is not always met or possible for children who are in crisis. PIW, the Psychiatric Institute of Washington, is also not a stable placement or suitable placement for youth in these situations. In closing, every young person in DYRS custody deserves more than supervision. They deserve clarity, safety, and the chance to rebuild their lives with the support of the people who love them. We have a responsibility to ensure that transparency, family involvement, and youth voices are not optional, but are central to how we guide and support our youth. I urge the council to act decisively so that every young person has the opportunity to grow, thrive, and break the cycle of recidivism. Thank you for the opportunity to come before you today.
Thank you. I gave you 2 extra minutes. Let the record show. April Thomas, I believe, is not with us. Next, we have Melody Webb.
Good afternoon, Chairman Parker, and also Chair Pinto and absentia, members of the committee and the staff. My name is Melody Webb. I'm a resident and native of Washington, D.C., also a mom. I'm the executive director of Mothers Outreach Network, which is an organization that is constituency-driven, as evidenced by the moms who are here today. I'm so proud that they were able to attend. We engage in advocacy and legal programming. Our legal programming includes representing parents during the investigation stage of involvement with CFSA, a low-income tax credit clinic, and also representation of parents who are seeking expungement. We also were not invited to join the OAG convened working group on the amendments to the Statutory Neglect Amendment Act. We also convene the DC Guaranteed Income Coalition. Our organization's mission is to ensure that every DC resident has a permanent guaranteed income above an income floor. For 5 years, this month, we've led a coalition to make a connection between poverty and involvement with carceral systems. I want to indicate that we strongly support the intention and goals of the Care for Youth plan as a whole, as a bold and meaningful leap forward for youth and families. I will concentrate my comments on portions of B 26400. For us, quite honestly, the most striking feature of the Statutory Neglect Amendment Act, because of our focus, is that its poverty-related provisions really further what should be a core mission of our government, ending poverty and its crippling effects on the well-being of children and their families. Again, for 5 years, we've worked as almost a singular mission to make this connection between poverty and involvement with CPS or CFSA. And it is an amazing turn that today we heard so many advocates and the government indicate that there is a connection and that poverty is not neglect. It is unconscionable that in the richest nation in human history, the poverty rate in its capital is 14%. This has consequences. In DC, at least 12% of families involved with CFSA are experiencing housing insecurity. The vast majority of cases and parents involved with CFSA are deeply impacted by poverty. While little more than 50% of DC's children are Black, over 80% of the children involved with CFSA are. So this is also a racial justice issue. I'm here in part to praise the work of the committee, and particularly you, Councilmember Parker and staff. The legislation is really a giant leap forward. Thank you for listening to the parents who've come before you in this committee for the past several years, for centering the devastation poverty reaps. Poverty absolutely is not neglect, as you've heard here, you will continue to hear. But our current law actually makes poverty factors a basis for neglect. We were so persuaded that ameliorating poverty will address neglect that we invested in a guaranteed income pilot, and the report from that pilot, the Mother Up Guaranteed Income Pilot study on CFSA involved moms given cash, was conducted by the Access to Justice Lab at Harvard Law School. It reflects a conclusion that suggests that but for poverty, moms in that program would have avoided involvement with our city CPS system. I do encourage you to review it. You have taken crucial steps in the direction of correcting policy to reflect this through this Statutory Neglect Amendment Act. That plus the passage of the guaranteed income legislation, the child tax credit, really deserve deep pause and appreciation. In addition to plus, I will quickly raise some concerns we have about possible missed opportunities to address specific harms of the system. I would like to say that in addition to the poverty factors, really so much of what you've heard today related to domestic violence, also what you hear about inadequate supervision and educational neglect are deeply rooted in poverty. There's an August 2022 ABA Resolution 606 that condemns harms that the system has inflicted, particularly on Black families. So I have a few recommendations. I have other suggestions, which I've been communicating with the staff about, and we will consolidate those all in writing. Some specific language changes we've made. I want to just, indicate that just to read really quickly, I don't think I have a lot of time. The current code, essentially the failure of the child's parent, guardian, or custodian to plan for, provide the child with adequate food, clothing, shelter, education, or treatment, or are necessary for the child's physical or mental health, provided the failure is not due solely to the lack of financial means, demonstrated by reasonable efforts. What we would like to do is just to indicate that we think that you should take a look at the active efforts standard in the Indian Child Welfare Act. There was some discussion previously about that. And I guess, again, what we've talked about is through hours of testimony in the past that we should be eradicating poverty and not punishing it. We urge the council to ensure that the final language of the bill clearly prohibits the use of poverty-related conditions of all types and not limited to housing factors, but all of the enumerated ones that I just read, given the prevalence of hunger, the lack of adequate food should also be stricken in particular. We think that doing so—
If you can give your last thought.
Yes, I will give my last thoughts. So just to close, there was a lot of discussion today about whether or not parents could prevent poverty. There's also language that was added to your proposal around planning for. Harvard behavioral economist Sendel Mullalathan, who studies how the situations of poverty and scarcity skew focus and long-term planning, and states that in a study that he did, they found in plane crashes, the fault is in the cockpit, not the pilot. The flaw is in the circumstances of poverty that parents are encountering, not the parent. How would one have planned for the recent SNAP emergency? Thank you.
Thank you. Next, we have Magdalena Tsongas with the Council for Court Excellence.
Thank you. My name is Magdalena Chungus, Policy Manager at Council for Court Excellence. My testimony today focuses on 3 of the bills being discussed. First, the Youth Records Transparency and Oversight Amendment Act would provide much needed increase in the oversight of DYRS and CFSA by mandating access to existing agency data. In our May 2024 crossover youth audit, completed on behalf of the DC Auditor, we recommended that, consistent with the terms of the Ombudspersons for Children statute, DYRS and CFSA should provide requested data on the full population of crossover youth and not just those youth who are dual jacketed, so that OFC can comply with its mandate to collect, analyze, and report on population of crossover youth in DC. We shared in testimony earlier this year that OFC continued to have critical gaps in data sharing from other agencies, including DYRS, that hindered their efforts to effectively identify and support crossover youth in the district. So if enacted, this legislation would increase access to these juvenile records for OFC, allowing the independent ombudsperson office to actually report on the full population of crossover youth and greater understand the scope of the need. The Strengthening Capacity and Transparency DYRS Amendment Act would require DYRS to report daily youth demographics and incidents publicly on their website, data that was previously reported by the Office of Independent Juvenile Justice Facilities Oversight. We have found as an organization that this publicly available demographic data is a useful resource for public awareness and accountability, and data that we want to continue to be available. However, we know that data alone is not sufficient. We remain steadfast in the belief that DYRS must have independent oversight to ensure accountability and better protect incarcerated youth. This permanent oversight was codified in the Road Act but remains unfunded, with the elimination of OIJJFO. With the elimination of that office, an independent office ceased to exist. While continued reporting on demographics and incidents is one step, independent oversight allows for independent investigation into incidents, such as alleged staff on youth physical and sexual violence, both of which there are ongoing lawsuits against DYRS currently. Without OIJJFO to investigate allegations such as these, this oversight will be left to DYRS internally by a staff whose capacity is already stretched thin and who work directly with those whose actions need to be investigated. Additionally, independent oversight allows for deeper exploration of specific issues at youth facilities, such as were raised in OIJJFO's final 2025 report around behavioral health services in New Beginnings, which raised issues about the conditions in the youth facilities that have potentially life-threatening consequences if not addressed. The bill also seeks to address ongoing overcrowding at YSC by directing the mayor to create a one-year action plan to address the issue, which is an issue raised in our recently released report, Committed Youth Awaiting Placement in DC Youth Services Center. Youth awaiting placement is a main driver of overcrowding. We support a multifaceted approach to addressing the multiple issues that are driving increased wait times. Furthermore, issues such as violence, access to schooling and programming are all impacted by overcrowding and should be monitored by a permanent independent oversight body. Of note, 64% of youth who completed our questionnaire in our youth awaiting placement report, who were previously awaiting placement at the Youth Services Center, cited concerns related to living conditions. One additional area of increased transparency that this bill could address is to require DYRS to publish all operational policies on its public website, recognizing that a small subset might be unique security-related elements and not appropriate for the public. But this would be an important step in helping families understand the systems their youth are committed to, and this requirement would bring DYRS into alignment with the Department of Corrections, which makes publicly available the majority of its policies. And finally, we support parental engagement between DYRS and parents and the tracking of these interactions as proposed in the Promoting Parental Engagement at DYRS Amendment Act. However, recognize that more work must be done than tracking the attempted outreach that as required every 6 months in this bill. Our committed youth awaiting placement in DC services, DC YSC, had multiple recommendations developed including from youth and parents, centering on increased parental engagement, such as including parents in placement conversations, engaging with youth and family immediately on system contact to assess their needs, and replicating the CFSA youth family meeting model, and holding such meetings in both the pre and post disposition phases. Beyond ensuring that parents are engaged and aware of the details of their child's treatment, youth themselves must be better informed throughout the process. Among youth who'd previously been awaiting placement at YSC who completed our questionnaire, 58% reported they did not know why they were still being held at YSC, revealing a gap in what's being communicated to youth about their placement. Overall, we recognize each of these bills as a step in the right direction to ensure greater oversight and accountability from DYRS, while much more remains to be done, including creating permanent independent oversight of DYRS. Thank you.
Thank you for your testimony. I don't really have questions for this panel, although I do appreciate the recommendations, both about the neglect statute that you referenced, Ms. Webb, and emphasizing that, yeah, today this is about face in many ways, in the fight that I know you've been a part of for quite a while, ensuring that poverty is not used as a indicator in removing children from their families. And Ms. Chungus, I appreciate the recommendation around publishing all policies on the DYRS website. That is something we'll certainly look into. But I want to thank you all for your testimony and your time. Thank you. All right, we have finally made it to the final panel. We have Christian Green with Electric DC, Marari Dreama with DC Alliance Against Racist and Political Repression, Maka Taylor, and Diamond Gabriel. All right, Christian Green, you may proceed.
All right, excellent. Good day, Councilmember Parker. I'm honored to be here speaking with you and echo the voice of the community. I'm testifying as a historical expert with the complex world of child welfare, juvenile justice, and mental health. I'm a clinical social worker who was CFSA's ombuds. My whistleblowing established the independent office of the ombudsperson for children, appointed by and reporting to DC City Council. The office was not established because advocates screamed we could do better. Rather, the origin was an expert who whistleblew to DC City Council with facts of failure, preventable fatalities, falsification of records, and facades of children's rights enforcement. I bared witness to these stories, held those hands, wiped the tears of the failure, and grieved the death of those children. When adults' emotions become more important than child safety, when liability outweighs validity, it will always result in secrecy of costing us the truth that will never be decoded because the stories died when the children and families were stolen or buried. Regrettably, CFSA continues to value the rights of the parents over children and is in violation of reporting child near fatalities as required by law. The statutory neglect definition changes. How will this legal language change policy, protocol, and practice? If this does not reach the social worker, then this will be a back-end resolution after the harm is done, when it reaches the lawyers and the court rather than prevention as intended. Clinicians will always be the experts in the practice of law. The diverse people of DC are the heart, the power, the echo of the heartbeat. Isn't the politics, parties, or the political powerful. It is the determination of the diverse city that has survived despite no independent statehood or federal representation. Power forgets the heart must continue to beat for the city to exist. Right now, federal government infiltrates daily life in DC, bringing the violence and disrespect while our mayor watches, claiming she doesn't hear the cries, and embedding ICE into police, sanctioning kidnappings, targeting the population CFSA professes to protect. Giving away our rights, sickening the heart of democracy. For what? For who? For why? I don't have the solution, but I do have a question. Are CFSA and DYRS working with ICE or facilitating ICE through MPD? Historically, CFSA promised in oversight testimony they never will. Council and the mayor enacted laws to make DC a sanctuary city, yet these words on paper are just words, not practice. The heartbeat is missing. 15 years ago, a social worker cooperated with ICE. DC City Council called an emergency hearing. The social worker and chain of command testified to the public and were held to account. If yes, where is our outrage that our children are pawns to a federal campaign to violate the heart of the democracy? Our community is not only being silenced, but stolen with the most tender of sacrifices. If unknown, it means CFSA hasn't even deemed the question to have thoughtful value. While all abuse allegations go to Youth Division MPD via CFSA hotline, duly jacketed civil and criminal cases in front of the court, forensic interviews, multidisciplinary team meetings, dual testimony prep with OAG, and shared confidential records, basic, pervasive touch points that must have valid oversight. If no, then we push to validate this because no is not sufficient. It should be public promise to not only deny cooperation, but a policy that immediately changes social worker practice. Social worker guidance is how to code sensitive information, placing restrictions on MPD's access to CFSA data points that are used to target children and families, such as Social Security, immigration status, origin of birth, so that they do not use unprovoked data polls to harm those communities. OAG issuing a legal public position, DC City Council commitment to close oversight via public emergency hearings? The answer is the right question because the answer to the question determines community action. Resistance requires the courage, the cost, and the morals. What are we willing to sacrifice? Is our comfort more important than another person's life? Solidarity, all of us or none of us. Thank you, Council, for letting me speak to our communities because power will always reside with the people, and the power in our testimony is echo, the heartbeat.
Thank you for your testimony. Next, we will have Marari Jarima. And make sure you push the button so we can hear you. Or individuals with organizations get 5 minutes. But they adjusted your clock, so you get 5 minutes. Yes, yes.
Thank you. So just real quick, the DYRS conversation, I just want to enter into the record that we've also heard from, I think, reputable sources that there's a practice in there of, my name is Marawi Garima. I'm with the DC Alliance Against Racist and Political Repression. Just want to add into the record that there's a practice of guards basically putting hits on certain kids who are held in DYRS with snacks is what they called it. You know, basically offering one kid snacks to beat up another kid without, you know, obviously telling them, you know, that they're going to have charges brought against them or, you know, their time extended in jail or in DYRS. So I wanted to add that in there. To me, DYRS reminds me of Oak Hill. I don't know if you remember that, but Oak Hill was a notorious location that I think is a place that we don't want to let this get to. And I think, you know, there's potential for you to call a hearing on DYRS conditions, you know, to have people who have experienced it to come speak on it so that you can investigate further. I want to talk about two things that I believe are directly related to supporting our young people. MPD's racial profiling of Black youth at Navy Yard and the MPD cover-up of HSI's near shooting of Philip Brown on October 17th. So on Halloween this year, MPD was recorded racially profiling Black youth at Navy Yard Metro Station after the National Guard situation. They were stopping Black youth from exiting the station while clearly allowing non-Black youth to exit. I don't know if you've seen the footage. I can share it with you if it's appropriate to the hearing. WSA 9, you know, who's been reporting on it, released another report today describing how Black kids who live across the street from Navy Yard train station are not being allowed to exit at that station, you know, after the curfew, and are being told instead to take the train back to Waterfront and to walk from there to their homes in Navy Yard. Obviously, this does nothing to reduce crime. If anything, it exposes these youth to increased danger. The following night, 4 people, including myself, were arrested while protesting the ongoing racial profiling. Protesting the ongoing racial profiling. We believe protesting is not a crime, and of course, these charges must be dropped. But I'll tell you what is a crime. I'm sure at least you yourself, Mr. Parker, have heard of the Philip Brown case, who was an unarmed Black man who was nearly killed when federal agents opened fire into his vehicle during a routine MPD traffic stop over dark tents. The officer, Jason Sterling from 6th District, who filed the police report, was instructed not to include the federal shooting in his report, so he omitted it. He even checked the box that said no shooting occurred. None of this would have come out if he wasn't forced to admit it under oath during Phillips Brown criminal case, which was dismissed. After our press conference, the DC Alliance, exposing this cover-up, Police Chief Pam Smith testified during Councilwoman Pinto's recent hearing on the curfew zones, claiming that there was no cover-up. I can't decide if she was lying through her teeth or is just being plain incompetent, but she misrepresented the truth in some alarming ways. She said that there was no cover-up because a second police report was filed that acknowledged that the federal shooting occurred. This is not true. A second police report was authored, but never filed in court. MPD held on to it. In fact, the officer's questioning in court about why he failed to include the shooting in his report, he still never mentioned that report at all during his questioning. In all likelihood, that report is just something that they created to cover themselves, to cover their backs in situations like this. Pam Smith said that the body camera footage had been released to the USAO, but again, this is not true. USAO has stated The MPD has the footage on lockdown, and neither Brown's criminal lawyer nor her civil lawyers have been able to gain access to the footage to this day because it is locked down by MPD. Most ridiculously, Pam Smith claimed that Officer Sterling was not instructed by his supervisor to omit the shooting from the report. In court, Officer Sterling testified that he was instructed by a team lead. We refused to play a game of semantics with Pam Smith. The point is that someone leading him instructed him not to include the shooting. He did not include the shooting, and no supervisor or sergeant included the shooting in the police report. Perhaps most telling is the fact that she nearly cried over the plight over one of her officers for the stress this is causing him, but not a single word about Philip Brown, a DC resident and father who came so close to death that he had a bullet hole in his shirt collar. The Navy Yard racial profiling and MPD cover-up have occurred in the policing environment created by Bowser's policy of collaboration with the Trump agenda. When they cover up and lie about it in our faces, they're just following the example that the mayor has set without fear of accountability. To Councilwoman Pinto, we urged her to investigate this cover-up and push Pam Smith to rescind Executive Order 2505. She's told that there's no need to hold a hearing about collaboration because she already has a public safety hearing coming up, but we want a specific one about Executive Order 2505. To Councilmember Parker, we hope that you will start an investigation onto MPD's patterns and practices of profiling these youth curfew zones. Hopefully that's something within your purview and in your interest, because it certainly is within ours. These are the first steps, in our opinion, of the City Council taking steps to stand with the people against the racist and reactionary Trump agenda. And finally, I'll just close by saying, everything that people spoke about today centers on the over-policing of poor and working Black and brown people in DC, in a city where almost 20% of kids primarily live below the poverty line. CPS and undue family separation works together with much broader systems of police violence and targeting. They're being traumatized by police violence at home and then again in the streets. This violence has intensified under Trump's assault on the city with federal police and National Guard. Of course, all this legislation is incredibly important measures, but they must be paired with accountability. We must hold the police, local and federal, accountable for the things they do and don't do in our communities. So I hope once again that you will follow through on these hearings.
Thank you for your testimony. Maka Taylor?
Maka, thank you.
I was gonna go with Maka.
A long A, short A.
Yes.
Hi, and thank you for having me. Again, I'm Maka Taylor. Today I'm here on behalf of and with the Mothers Outreach Network. Yeah, we're going to start here. So good afternoon. We are in the afternoon now. Chairperson Parker and Pinto, thank you for your committee membership. My name is Maka K. Taylor, and I'm here on behalf of the Guaranteed Income Coalition and the Mothers Outreach Network. But I also come before you as a mother. Actually, that's all I am today. That's all I am today. Raising school-age children in the district. I want to begin by thanking you for introducing and advancing policies through the Care for Youth plan that center young people, their families, and those of us who live the realities these bills are meant to address. Because for too many of us, this work is not theoretical, it's survival. Relative to the SOUL bill, supporting other unseen loves means recognizing that healing and development extend far beyond bloodlines and court orders. Across this city, so many children are anchored by non-custodial parents, mothers, and fathers who may not have daily custody, but still carry the weight of love, responsibility, and hope. Their care is often unseen, but is no less powerful. Alongside mentors, caregivers, and chosen family, these parents form the quiet backbone of our communities. We must begin to honor that effort with acknowledgement, with healing, and with incentive. Let's build pathways that help non-custodial parents restore their inner selves, find stability, and be supported, not punished for showing up. Because when we invest in the emotional health of those who love from afar, we strengthen the soul of every home, every block, and this city itself. I'm going to keep reading and then I'll come back to that. Too often families, for the statutory neglect bill, too often families are criminalized for poverty. For the record, my family is one of those. Neglect, as currently defined and enforced, sometimes confuses economic hardship with parental failure, as it tears families apart. A single missed utility bill or the inability to find after-school care can trigger investigations that traumatize children and parents alike. We need a legal definition that distinguishes systemic neglect of families by our institutions from intentional neglect by caregivers. If the district truly believes in equity, it must reform statutes that penalize those already surviving on the margins. Give us resources, not removals, empowerment, not punishment. The School Safety Enhancement Amendment Act of 2023. As a mother, I carry the same fear every parent does, sending our children into schools that sometimes feel more like stress zones than safe zones. Safety cannot just mean policing or metal detectors. True safety is relational. It's trust between teachers, students, and families. It's stable staffing, trauma-informed support, and schools that recognize when a child's outburst is actually a call for help. We need culturally responsive practices with a culturally responsive definition of culturally responsive. Peer mediation programs and pathways to mental health care that meet students where they are in their humanity, because a safe school isn't one where every threat is punished, it's one where every cry is heard. These three bills that I am addressing in your package, sole statutory neglect and school safety, share a common thread. They are not about saving children from their families, but saving families with their children. They ask us to stop treating crisis as character and instead see care as capital. So as you deliberate, I urge you to remember the mothers, fathers, guardians, and aunties who are uncles as well, who are doing their best to raise resilient youth under the weight of iniquity and to make policy that honors our lived experience, not just our need. With that, offerings that I have suggestions to enhance the impact you have to understand that a father who may be separated, he might sit in the back, he needs to be understood. He needs that soul piece. The parents, what I'm trying to say is parents who may be separated, we have to include them in this as well. It's not just outsiders, the parents of those children still also have to be included in that. And I'm just gonna say that I'm a parent right now. I have twin 15-year-olds. One of them is at 80% absence, the other is at 64%. When they are at home, councilmen, they are not truant, and I can't make them go out and I also can't put them out. That's a catch-22 that we have to figure out what that line is. With that, I thank you all for the committee as well as listening.
Thank you for your testimony. And I believe Diamond Gabriel is not with us. So that concludes our witnesses today. So that means I get to ask you all the questions.
You should, because I want to be oversight director.
Okay. You can take my job.
I don't want yours. I want the job over all the other jobs.
Understood.
Here.
Ms. Taylor, I want to come to, I know this isn't about truancy, but you mentioned you have two youth. One is at 80% truant, the other one is at 65% truant. When you say when they're in my home, I can't make them, what do you
That
mean?
gentle parenting that you spoke to, we tried that. It was not successful in my own experience. With that, I will admit I currently have no control of my children. What I do is hands off.
So you say go to school, they say no.
They just don't go. Or it will be an incident where the police will be called. Like, it will be a full-on extension of foolishness to where I don't even, the last time I went to wake them up, and this was 2 weeks ago, get up 7:30, they go to Coolidge, it's right up the street. The police were called. I'm very familiar with Ford MPD, not by my own admissions or allocations. These youth, and what I'm saying when I say support, I love what Mr. Brown said, and this is why you can't judge a book by its cover, because I thought he was gonna be something altogether different. But speaking to that loving, nurturing, even though they need a firm hand, our children are out of control, but this is a generational output in my thinking that stems back. So I work with the Black codes in my professional self. And when we're ready to start having those discussions, other than that, we just need to cut contracts and use people who are very, very well aware with the lived experience.
But I want to unpack this. So
let's unpack.
What correspondence have you received from the school and/or CFSA?
So
Well, I guess if you're talking about teenagers, it wouldn't be CFSA. It would be
immediately
it'll be the
CFSA.
Office of the Attorney General.
So here's where we require, again, I'm alone, so I'm for the record, I don't even want to be, but when mothers are saying it's nobody else, it's nobody else. It's nobody else to pick up any support. It's nobody else to really come in. So when you're saying why I'm proceeding with that, because my daughters are brilliant. they don't want to put them in that position. And I'm not forcing that. With that, they call, I receive the emails, we're in communication. When they do decide to go to school, they've gone to school yesterday, they went to school today. I can't guarantee they're gonna go tomorrow, but it's out of my hands. I'm not putting my hands on my children. You can't beat a kid and make them do anything anyway. You know what I'm saying? So I don't know what the collaboration is. When I'm speaking to school safety, I know that between just general peer-to-peer negative engagement, then I know that my daughters have spoken to the adults not kind of having, when I was in school, there was an absolute border between youth and staff, and teachers were teachers and students were students. And so they speak to kind of like this cliquish environment in the educational field where they're not feeling like they're adult. And I'm not saying that is everything. I'm just speaking to different aspects that when they feed back to me, what they're saying, they are extremely, the social media, the imagery that they have to go through, like it's just a lot dealing with these children. And I would love to, as I shared with you, truly offer, when I'm not just on camera, but these kids going through a lot. And to have somebody who's living, my daughter's in a DYRS situation where she got the intervention. My other daughter just came out of one. These things, it's everywhere, but there are conversations to be had that are directly relative to these things, I believe, and the work that I've done that I could add to it.
Okay. I'm not going to belabor this point. So it sounds like you're saying there's not much you could do. It's not much we could do.
No, I'm saying you all could do a great deal more, but I don't know what you can do without us sitting down to go over these points and these.
Okay. Because we're trying to figure it out.
I am too.
And I would welcome your feedback and thoughts. I appreciate you being transparent. I think I fully support the Attorney General's posture that we're not going to prosecute parents, because I think a lot of parents are in your position where it's like, I can't force my teenage, almost adult child to go to school. At the same time, I believe we're setting our young people up for failure if they don't go to school and get a diploma and go on to do something.
So if I could offer, my background is in advocacy. I've been in nonprofit work. I facilitated I've run the gamut, and that may seem why I seem like this, but I think that everything has to be reanalyzed and strategically looked at differently in terms of who we're educating, what that population is. If we keep saying that these are 80 to 90% Black and brown kids, then that's a specific slant we then have to look at. We are not cutting or shading anybody. It just requires a relevant formula that we can then transpose and transfer into something else. I believe that we're missing out a great deal in terms of entrepreneurship and utilizing these things in these kids' hands to actually cause education to happen. Not only that, there's a shift industrially where now business seems to have a heart, but if you've been in business for 40 years, that's new. And so all of these things kind of have to be implemented. I believe in building a plane while flying it, but it has to be at least discussed, communicated, and bullet points sent out so that nobody should ever not know what's happening in today's world. You can use, that man right here could have pulled up ChatGPT and gave you 13 different scenarios. So for people who are paid and compensated to have no idea, or they're saying things like they and we don't have, this is where my voice, my passion comes in, because I got something if you don't, and why are you receiving 6 figures and over this agency if you don't? You understand what I'm saying?
No, I do. And you don't ever have to apologize for your passion. I really appreciate it. I'm going to take you up on your offer to follow up, to talk about ideas and solutions.
Feel free. Media literacy is huge, though.
Yeah.
That's what I will put on record. Are you familiar with media literacy at all?
I think so.
So I'm not going to do that. So media literacy, I actually facilitated a program. The 21st Century Grants is multi-million-dollar, multi-year after-school grants. And media literacy is a tool that can take this and everything that we're talking about and transform it. But it's about, and I've been asking the district for over a decade to find a way to fund and allocate for this, because it almost is an all-in-one. Everybody's on the phone. To take this and teach them how to make money immediately in the era, it's almost immediate. But somebody has to have that thinking and the implementation thought. I truly thank you for hearing.
Absolutely. I shouldn't do this, but I'm going to ask one more question. What are your, when your teens don't go to school, what are they doing?
at home, sleep until they feel like getting up. Working on my nerves, acting like staying together that long is not a disproportionate challenge.
And it sounds like they've had run-ins with DYRS.
Yeah, I'm currently avoiding a call because I'm tired. I'm exhausted. These teens are exhausting. The mental health, the lack of resilience, the inability to sustain.
I get it.
Is exhausting, and to be a hands-on. So I couldn't even think about any other side, but to be hands-on it's exhausting.
Yeah.
And there's not, so to say, even with all of these programs, let me say, none of them typically have been assisted. They felt good, but as far as actually helping me to move forward or helping their mental health, none of that's been assisted. So I'm not saying it's not working for somebody else. I'm saying there are different personalities, there are different needs. So when you have students who've been maybe presidentially recognized and their vocabulary intimidates grown people, and this is the way I am, and then you got to have a program for them. You got to have something for them to do.
Understood. Thank you. And again, I want my team to make sure we get your contact so we can follow up with you.
I'm Googleable though. I'm easy to find.
Ms. Green, I wanted to follow up with you. I have asked about coordination with ICE. I have repeatedly been told by the mayor, by agencies, by the deputy mayors, there is no coordination. I will follow up again. I appreciate the push that about asking different and better questions. I did want to ask you about the SOUL Act. Given your experience as a social worker and a practitioner, what do you think are some of the potential positive outcomes of the SOUL Act in giving this new permanency pathway for young people aging out of the system?
Family isn't always who we are born into, but it will always be who we choose. I think it can be extremely powerful. I haven't spent a ton of time. I was going to do that in my written testimony. I do have some worries about implementation and kind of that middle gap between the custody courts and the child welfare courts, or who gets to dictate the actual the actual goal being changed in the system. Historically, emancipation was authorized by the director of the agency and heavily scrutinized. So I'd be quite curious how it's implemented. My only concern is this being another form of illegal third-party placements or hidden foster care, or people not really having the proper representation. But as long as we are able to safeguard some of those pitfalls that we know about and are currently struggling with, I think it could be a powerful place for our youth to self-identify where they feel safe.
Yeah, and use that magic word, hidden foster care. Our friends at Care Alliance are all over this. I've heard repeatedly from the agency, we don't have hidden foster care. What are things we should be looking out for and ensuring that we're not incentivizing these unsanctioned placements? And when I say unsanctioned, I just mean outside of the formal system.
I think a gap that I kind of spoke to in my testimony, but we could dive deeper into, is the distinction between the legal definition and the policy or the practice. If we don't cover that gap, we're always going to have problematic issues. Hidden foster care in my generation of social work was called illegal third-party placements because the agency recognized their legal powers was to present the removal in front of the court. And when that didn't happen, they had no legal powers. What you're having now is practitioners going out into communities, making safety plans that are unenforceable and violate the rights of the youth, the parent, and even the person taking faux custody of the child, because custody courts take a long time to get through and be actionable. And they lack representation. The person taking control of the child doesn't get access to health care or TANF or food stamps or Medicaid because they don't have any of the legal documentation. And technically, a parent could go pick up their own child with these illegal third-party placements because they're not enforceable. I've known caregivers who stepped in that moment of crisis, and they were penalized by having the police threaten them with kidnapping charges because they presented the CFSA document and that wasn't sufficient because it's not legally binding. There is a remedy in the system that people keep on forgetting exists. There's a reason that kinship foster care exists. There's a reason that there's a federal push on it. And the reason is that children should be with the people that have the most home-like setting, but we have to be respectful of the children's rights in the meantime, because we're removing the victim, not the perpetrator. And then we're not safeguarding the victim because we're creating a cycle. So if I were to be high on PCP and CFSA were to show up, the only way they should be able to plan with me is if I'm safe to plan with. My active use of PCP would make me unsafe. Grandparents have no legal rights in the district or across the nation. So if a grandparent shows up on scene and the CFSA social worker makes an agreement with a grandparent, they violate the child's rights, the parent's rights, and the grandparent's rights because there is no legal authority. I, as the parent, can go pick up that child. So now it becomes chronic neglect and cyclical. And what you're seeing with these hidden foster care cases is they keep on touching child welfare, and child welfare is pushing their duty and their financial responsibility on really vulnerable communities without offering assistance. And the remedy is CFSA can license a foster home within hours if they're in the district, or within 24 hours if they're in Maryland. And that gives the child legal protections, it gives court oversight, it gives the parent the right to reunification, because that's something missing in these safety plans. And what we've seen happen with the policy at CFSA is become more and more and more vague. And the reason it's more and more and more vague is because they can't be held account to vague. Right. So I've reviewed some of these policies and they're extremely problematic. And so I understand why some of the language is changing in the legislation proposed today, but that vagueness complicates the problem. And laws are just people in community making actions and then a determination if it respects people in the process. So laws should always be led by the community who leads that process. And the community who leads that process is clinician in DC, right? They're the ones who enact these policies. And that's why I've had such a heavy voice in this space, because children's rights are being violated on a chronic basis. And that was a theme that I saw as a social worker as ombuds.
Understood. I really appreciate. Well, I invite you to share recommendations of places in the statute and beyond that you think are vague, that we should consider as we mark up these bills, but also consider others. I appreciate your testimony. Marari, thank you, both for your work, but also your, I don't want to say advocacy because that feels kind of flat, but your fight for what the district is under. I am sensitive to what you shared in your testimony. One, about the train incident, that was not on my radar, but now I will look into it, about young people not being able to get off the train at Navy Yard. Yeah. So thank you for flagging that. That seems kind of crazy to me, that we would be taking those steps if that is in fact true. In terms of the work that this committee can do as it relates to youth well-being, we are working on things. I invite you to collaborate with us. But one question I had was for
snacks.
Say it again. You said snack?
No, I thought you meant to the DYRS situation. But go ahead, I cut you off.
I was gonna go to DYRS, but it's more so like, what work are you all doing or thinking about as it relates to trying to support our young people in the city that are clearly hurting, clearly need support? You may have noticed today I'm asking more questions as we are kind of trying to figure out, like, what is the solution? I don't think it's necessarily a legislative one.
Sure.
But what recommendation would you provide for how we both focus on DYRS as an agency, but the young people that are on a pathway to DYRS because they're kind of not being supported adequately?
Yeah, sure. I mean, the first thing I'll say is, as you know, your hometown Chicago's got a plummeting crime rate at this point, in some really important ways. And there was a curfew attempted in Chicago, but it was defeated. Actually, Brandon Johnson, the mayor, vetoed it. And instead, recommitted to what was already going on, which was total investment, in the youth. One of the most important things being year-round employment, opportunities for young folks, as many as they could across the, the first thing that came to my mind as you were talking about your situation at home is, are they employed? Are there ways to employ them around their schedule, around their school schedule and things like that? As we know, that really gets the ball rolling for a lot of people when they have opportunities to purchase the things that they want,
Yes.
or live the type of life they want to live. The other being, of course, they reopened these mental health facilities across the city. That's another thing that, all this trauma that we're talking about, Black people exposed to all different kinds of whatever in the city, mental health, networks that can catch people at every stage, become crucial, in that process as well. That's just on the legislative side. On our side, our fight is against police crimes. The DC Alliance, that's our main focus, because we believe that public safety and police accountability are two sides of the same coin. We believe that whether it's DYRS, CPS, MPD, Metro Police, these federal officers, at this point, they're running rampant through the city in all kinds of ways, and everybody's been affected. Adults, Black adults, Black youth, of course, immigrants, and everybody in between. And so, an approach that doesn't alleviate this massive boot that's on everybody's neck at this point, you know what I mean, in terms of, just kind of increasing all opportunities of police violence. These curfew zones have been intensified by the presence of National Guard, by the presence of federal officers. You know what I mean? In fact, that whole fracas, down in Navy Yard, what we've been told is that it happened because it was National Guardsmen, kids being kids, whatever, but National Guardsmen who's calling them B words and N words, you know what I'm saying? On that night, and then of course we've seen the footage of them chasing them around. And so we organize around police accountability. We believe that they should not be allowed to, whether federal or not, to break the laws that exist in DC, and that when they do, the things that they do in our communities, they should be held accountable,
Absolutely. And then you mentioned the hit on kids within DYRS using snacks. Believe it or not, that's not the first time I've heard that. It's not the first time I've heard that, and it's alarming that it's coming up again.
Yeah.
That essentially, I've actually heard it twice. One young person who was begging to be transported out of DYRS or out of YSC because he had a hit on his head for honey buns or whatever the snack was.
Yep.
And then others who were being promised snacks in order to deal with somebody who was accused of snitching.
Yeah.
Can you just share more about what you're hearing and how you're hearing?
I've heard these two situations. I'm happy to give you, more
Yeah.
information offline, but I'll say that, this situation with the honey buns and the other one, those are, I believe, the two situations I heard of in which kids are, being, of course, hospitalized, I believe, or nearly hospitalized. And then on the other side, the kid who is attacking the other kid is now being hit with additional charges that, of course, they're not, considering in the lead up to the whole thing. So, and then of course, the accountability to the prison guard who's, who should be held accountable, or whoever is putting the snacks on whoever's head, is not part of the equation. It's just a matter of, kind of whatever. So this is just another case of kind of impunity, rampant impunity within DYRS and generally with policing. But I will just end by saying, to me, this situation in which the man was almost shot by federal officers and the MPD covered it up points to everything that we're talking about. These are MPD officers who are choosing to protect federal officers who nearly killed DC residents. That shows the extent to which they're collaborating, the extent to which our autonomy has been eroded, despite the fact that Mayor Bowser is saying, home rule is her North Star. We're showing that she's actually eroding it and eroding our ability to protect DC residents,
Well, thank you for your testimony. I want to thank everybody who testified today. If you have not submitted your formal written testimony as part of the record, I'm going to ask that you do that, especially if you have recommendations for how any of the bills could be improved. And given that this is a joint hearing, there will be two markup processes, one for the Committee on Youth Affairs, another markup for the Committee on the Judiciary and Public Safety. And so I look forward to sharing more information with everybody soon. And so with that, I am going to adjourn this hearing convened by both the Committee on Youth Affairs and the Committee on the Judiciary and Public Safety. The time is now 4:31 and this meeting is adjourned. Thank you.